assisting in writing up.
I declare open the public hearing of the Joint Select Committee on National Anti-Corruption Commission legislation for the inquiry into the provisions of the National Anti-Corruption Commission Bill 2022 and the National Anti-Corruption Commission Consequential and Transitional Provisions Bill 2022. Can I acknowledge the traditional owners of the land on which we meet and pay my respects to elders past, present and emerging. These are public proceedings. Although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in private session. I remind all witnesses that in giving evidence to the committee they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. If a witness objects to answering questions, the witness should state the grounds upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in private session. Such a request may, of course, also be made at any other time. For Commonwealth or State officers, I particularly draw the attention of officers to an order of the Senate of the 3rd of May 2009 specifying the process by which a claim of public interest immunity should be raised. Copies are available from the Secretariat. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. A witness called to answer a question for the first time should state their name and capacity in which they appear. In accordance with the committee's resolution of the 4th of October 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. In addition, recording by members of the media must not occur from behind the committee or between the committee and the witnesses, and computer screens and documents belonging to senators or members must not be filmed, photographed or reported. Witnesses are reminded that they can object to being recorded at any time. The committee thanks the media in advance for maintaining a COVID-safe approach while in the hearing room. So I now welcome the Honourable John Hatzigonis, AM Chief Commissioner, New South Wales Independent Crime Against Corruption, and also the Honourable Robert Redlich, AM Victorian Independent Broad-Based Anti-Corruption Commissioner, to give evidence today. I understand Commissioner Hatzigonis has only got half an hour, so we were going to focus on you first, if that's okay. And for the Hansard record, could you please state your full name and capacity in which you appear before the Commission?
John Hatzigonis, Chief Commissioner, Independent Commission Against Corruption, New South Wales.
And Mr Redlich, can I ask you to do the same?
Yes, I'm the Commissioner of the Victorian Independently Based Anti-Corruption Commission.
Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Mr Hatzigonis, can I ask you to make if you wish, to make a brief opening statement before we proceed to the discussion with you?
Chair, I don't propose to make an opening statement. I'm happy to respond to any requests for information that members of the committee may have.
All right, so I think, committee, if we can direct our questions to the Commissioner first. Mr Zapier.
Thank you, Chair, and thank you, Mr Hatzigonis, for appearing before the committee. Firstly, can I go to the question of the definition of corrupt conduct as it is proposed in the legislation? How does that definition compare with the definition in the New South Wales legislation?
Well, firstly, I'm not in a position to comment on the provisions of the National Anti-Corruption Bill. I have had a cursory examination of them. Our legislation I can comment on, and that has a definition of corruption which is quite specific. It includes various things in Section 8, and in Section 9 excludes certain things from being corrupt conduct. So it's not an identical definition to the definition which is contained in the National Anti-Corruption Commission Bill.
Okay, well, thanks for that. Can I then go to perhaps your experience as a commissioner, from your observation or assessment of the legislation that is before the federal parliament? Do you have any comments about whether there are any glaring omissions or issues that you believe, from your experience, should be addressed in the bill?
Senator, is it?
Member of the House of Reps, Tony.
I'm sorry. Yeah, look, can I just say this, that from the point of view of the New South Wales Independent Commission of Corruption, we've focused on the provisions of the bill which look at our interaction with the new proposed National Anti-Corruption Commission. We haven't focused on the intricacies of the bill as it applies to the areas of responsibility that the National Anti-Corruption Commission will be undertaking. So in the areas of interaction with the New South Wales Independent Commission Against Corruption, we're satisfied that the provisions of the bill are operational. We can, under our Act, engage in joint task forces in relation to other agencies. We can't, however, share information with other agencies unless it's authorised. But there's nothing in the legislation, as I see it, which improperly interferes with our ability to act in the way in which under our Act.
Okay, well, perhaps my last question to you then. Again, from your experience and the experience of the Commission in New South Wales, what advice would you give this committee in terms of matters that you believe could become problems for any commission, and that should be addressed in any legislation that we're looking at? In other words, what pitfalls might there be in legislation and problems that may arise that you've noted from your experience?
It's a very broad-ranging question. Not sure where it's directed to. Look, I've looked at your legislation, the proposed legislation. It is different to the way the New South Wales Independent Commissioner Against Corruption operates. You can't cherry pick something out of a bill and compare it, say this is more restrictive or that's more expansive. I think you have to look at the legislation in its context. And some of the debate that I've seen around some of the provisions of the bill, I think ignores some realities. For example, one of the issues taken is the role of the Administrative Appeals Tribunal in approving warrants for telecommunications intercepts. Well, we go to the AAT now in New South Wales to seek approval for telecommunications intercepts and data and certain information connected to that. So I just don't see them without an issue as far as that's concerned, but it seems to have extracted some controversy. The other issue that's been raised is the issue of public hearings as private hearings. I'm a strong supporter of public hearings. I believe that they're important because they make the organisation accountable. They provide an opportunity for other people to come forward. We've had investigations which have commenced in public, and as a result of that information, other people have come forward and we've been able to go into other areas which have raised significant issues of corruption. It also, I think, ensures transparency and accountability for the agency and justifies the case that ultimately is made for change. So that's the other issue that I've heard ventilated at quite some length. It doesn't mean that I support every public hearing that's been held. I haven't. And and the Act has been changed in New South Wales to allow us to be much more focused in terms of that aspect of our operation. I'm happy to go into that detail if you wish.
Can I
These are
just,
all matters that
can I
do you
just
need
ask
to
on that issue of the public
take into
hearings?
account?
On the issue of the public hearings, can I just ask, who makes the decision as to whether there will be a public hearing, and is there a set criteria as to how that decision should be made?
Well, there's set criteria in the Act. First of all, we've got to be satisfied that there is a likelihood of finding of serious or systemic corruption. We then have to be satisfied that it's in the public interest, and we have to obviously weigh against that individual interests that may be prejudiced and take account of whether the public interest overrides that. We also have to consider the role of other agencies in preventing corruption. Weigh that into account as well. And we can take a broad range of factors into account in terms of the case for change that might be made by having a public hearing. For example, if we've done 4 investigations into particular aspects of local government, we would have to consider what the impact of, if any, would be of doing a 5th one, and whether that matter would be better referred to another agency. So we do have discretion. We don't have unlimited resources, and we have to use our resources to ensure that we get the best outcome for people of New South Wales. In terms of the mechanics as to how a decision is made, a report's presented after we've engaged in compulsory examinations. That report is submitted to the commissioners, and the commissioners make a decision. No matter can go to public hearing unless it has the concurrence of the Chief Commissioner and one other commissioner.
Thank you for that. Thank you. Thank you, Chair.
Thanks. Senator Scarr?
Thank you. If I can just continue those questions in relation to this question of a public hearing versus a private hearing, Commissioner, and I think you outlined the considerations quite clearly that under your legislation you need to consider. I just want to ask you, the first one you outlined was, is it the likelihood of a finding of serious or systemic corruption or misconduct?
Well, we have a threshold in our Act which requires us to focus on serious corruption or systemic corruption. That's our focus. So if something's unlikely to reach that threshold, it's most unlikely that we would go into a public hearing.
But yeah, okay, all right, I understand. That's the issue I was trying to grapple with, because if it's not serious or systemic corruption, then maybe it's not even in your jurisdiction. That's the bill as it's structured in this bill.
Our Act requires us to focus on that, and also to bear in mind the responsibilities of other agencies for preventing corruption.
Okay.
So in a case that falls short of that, the likelihood is that we would refer that off to the other agency to investigate. Now, when you talk about systemic, one of the things that we do is that we require reporting in relation to all corruption by agencies or agency heads. As I understand it, the National Anti-Corruption Bill focuses on reporting of serious corruption or systemic corruption by the agencies. In New South Wales, it's any corruption. So that is a difference. The impact of that is that we use the detail, even though we may not go into a public hearing in relation to something that falls short of serious or systemic corruption, we use that data to analyse trends in corruption and where we may have to devote our corruption prevention work. So, for example, if we see something occurring in public hospitals that is coming up time and time again, and whilst individually those acts may fall below that threshold, it is important for us to identify that trend so that we can then direct our corruption prevention work. Does that make sense?
Yes, it does. Makes perfect sense. I just have two other areas of questions, and we are short of time. I've been given writing instructions by our chair. The first one is in relation to the functions of the inspector or the inspectorate. I'm not sure how it's referred to in a New South Wales context. We received a submission from Mr McClintock in relation to the importance of the role of the inspector and the importance that the function of the inspector includes, and these are his words, the audit of the operations of the relevant agency for the purpose of monitoring compliance with laws, but also detecting agency maladministration and officer misconduct. I just wanted your views with respect to how that works in practice and the effectiveness and importance of that in a New South Wales context.
Well, first of all, I have some knowledge of the role of the inspector because when the ICAC was first established in New South Wales, there wasn't one. I was the chair of the parliamentary committee that put up a report requiring the government or demanding from the government that I was then a member of, an inspector be established, and one ultimately was. Now, in terms of practice, the inspector communicates with me regularly. We have a memorandum of understanding with the inspector. We've supplied that to the parliamentary committee, or the inspector has supplied it to the parliamentary committee, which outlines the details of the relationship. That includes providing the inspector on a regular basis with minutes of our management meetings, both our investigations, our prevention meetings and our executive meetings. That includes enabling the inspector to be able to be an observer on our audit and risk committee. It includes making available to the inspector any records that the inspector is entitled by law to have access to, and that includes the bulk of the records. There's some telecommunications records which at the moment the inspector can't access, but that will be changed, as I understand it, in the near future. And then there's regular correspondence by the inspector on particular issues that come up, and we respond to the inspector, and from time to time we will proactively report matters to the inspector.
Okay, thank you very much. My last question is in...
I should say we also have quarterly meetings with the inspector.
Okay, excellent. My last question is in relation to the threshold which should apply to heads of agencies, which triggers a mandatory obligation to disclose an issue or to inform the Commission of an issue. There's some debate in the submissions we've received as to whether or not it should be a suspicion of systemic or serious misconduct or corruption or a reasonable suspicion. I'm not sure there's a huge difference between the two, but I was just interested in your thoughts with respect to the threshold that should apply that you would expect in your context for the head of agency to actually refer a matter to the Commission and how that's working in practice.
Well, the duty, are you talking about the duty to notify
Correct.
the Commission?
Correct.
Yeah. Well, the duty is contained in Section 11 of our Act, and it applies to the Ombudsman, the Police Commissioner, the Principal Officer of a public authority, an officer who constitutes a public authority, and a minister, although a minister can also report through an agency head. And it's a very wide remit of reporting. It's concerning any corrupt conduct. So any matter that the person suspects on a reasonable ground concerns or may concern corrupt conduct, that's the threshold.
So how does that work in practice, Commissioner? Are you being, and I'm not making a comment here on the Civic Society in New South Wales, but do you get frustrated because you're getting too many referrals at a level that you think, oh, why did they refer that? Or is it the opposite issue in terms of people aren't referring enough and you have to educate? Or are you in the sweet spot, if I can put it that bluntly?
I don't worry about agency. I don't worry as much about agencies that report as I worry about agencies that don't report.
Right. Yep.
If that makes sense.
Yep, it does.
The issue for us is that we get, last year we had a record number of about 3,500 reports into the ICAC. We deal with them through an assessment team which goes through in quite a lot of detail each of the matters that come into us. A lot of them come in anonymously. They are reported and we have a database and we match it up with information that we've obtained from other reports, because it may be sometimes that an issue arises and there's multiple reports coming in. So we try and marry all that information together through an assessments team which reports to the commissioners, and the commissioners, we triage those matters in relation to those matters that we may need to take further action and those matters that fall outside of our jurisdiction or there's insufficient information for us to be able to act on.
Okay, thank you, Commissioner.
And
Thank you,
then a
Chair.
commissioner is rostered on to consider each of those reports, except anything that needs to progress, they go to the 3 commissioners.
Okay, thank you.
Thank you. Dr Haynes?
Thank you, Mr Hatziskos. I'd like to turn our attention to the New South Wales ICAC's Operation Jersey report from August 2022 that found pork barrelling could constitute corrupt conduct in certain circumstances within the definition of Section 8, which defines corrupt conduct for your ICAC. Would you agree that it's important that the National Anti-Corruption Commission has the capacity to investigate pork barrelling?
Look, I'm not going to make comments on the National Anti-Corruption Commission bill in that level of detail for you, Ms Haynes, and for your colleagues.
Would you be able to explain to me then what impact the change in your legislation would have materially in New South Wales?
Well, first of all, in relation to that issue, there's been a large number of reports done in New South Wales, apart from Operation Jersey. There's been a report done by the Auditor General, there's been a report done by the Productivity Commissioner, there's been a report done by the Department of Premier and Cabinet, and there's been a number of responses that have been communicated. Operation Jersey itself, there's a requirement under our legislation, I think it's Section 111, which requires the agency to report back to us in relation to progress on the recommendations. So all of that is in play at the moment. So that's still a work in progress.
Would you be prepared to make a comment about explicitly putting such a definition in the National Anti-Corruption Commission legislation?
I'm not sure what definition you're referring to. I mean, the issue with pork barrelling has been comprehensively considered by the commission, this commission, in Operation Jersey, and I'm not sure what else it is that you want me to add. We've recommended, the Commission's recommended some changes to legislation. You can read those in the report. I'm not sure if they have relevance to you. In fact, in some respects, we're asking the New South Wales Parliament to take up matters which are already the subject of federal legislation.
Okay, thanks, Mr Hatzikus.
Mr O'Brien?
I've just got one quick question and just seek a clarification on something. Section 114 of the Act, Disclosures Prejudicing Investigations, subsection 3D, clearly, specifically states medical practitioners, registered psychologists are exempt or making disclosures to those people as exempt. Have you ever had any problem in relation to that piece of legislation?
So Section 114 of your proposed bill, or the
New South Wales.
No, the New South Wales one. The New South
Wales Act? No, I'm not aware that that's ever created a problem for the New South Wales Commission.
Okay. And just for my benefit, your statements that you've made about commenting on the federal bill, which I respect, can you just elaborate on why you don't want to, why you're reluctant to comment on them, please?
Well, I don't feel qualified to do so. As I indicated to you, I've looked at the New South Wales, I looked at the provisions of the NAC bill, mainly for its interaction with the federal legislation, and I'm satisfied that it interacts perfectly well. In relation to the detail of the structure of the bill, I've made some comments that may be pertinent in the context of the debate, but ultimately it's for the federal parliament to determine what the legislation should be. I don't see my role as a commentator on federal legislation.
Okay, thank you.
I can assist you by telling you how we operate in New South Wales, and if that's of assistance to you in determining how this commission should operate, then well and good. But I don't see my role as being an analyst or a commentator on a federal piece of legislation, which I won't have to apply.
Thanks. My question is, only around 4% of hearings undertaken by the New South Wales ICAC have been in public. What role in your experience or in the Commission's experience do private hearings play as an investigatory tool available to the Commission?
Well, first of all, I don't know where you get that figure of 4% from. If you look at the extent of what we do hearings, about 40% of the hearing time, just over 40% actually, is done in public. Now, if you're talking about what percentage of complaints that we get end up in becoming public hearings, full investigations, it's less than 1%. So,
All right, so if I've got the figures
they're the
wrong...
statistics which I'm aware of. I'm not aware of where the other figure comes from.
Okay, I apologise.
But let me just...
Can you
well, let me
address the
just-
substantive part of the question, which was, do private hearings play an how do the private hearings play an investigatory? How do they work, as far as you're concerned, in terms of investigations?
They're called, well, first of all, they're called compulsory examination. They involve bringing persons in, using the Commission's coercive powers and ascertaining what that person has to say about a particular matter that's the subject of investigation. It's usually for the Commission to obtain additional information, supplementary to the information which the Commission has already acquired in the course of the other powers that we've exercised, such as telecommunications intercepts and surveillance, controlled operations and so on. At the end of the process of compulsory examination, we sit down and we make an assessment as to where the matter is to go. It may be that the matter will not proceed to a public hearing. It may be that it does, but a judgment will be made at that point. So the compulsory investigations, the compulsory examinations may ultimately reveal, for example, that the threshold is not reached for serious corruption or systemic corruption, in which case the matter will be most likely be referred on or terminated. On the other hand, it may reveal that serious corruption or systemic corruption is in our view, highly likely, in which case we would then have to make a decision about going to a public hearing,
Thank you.
exercising the discretion that we have under our legislation.
Thank you. Mr Shoebridge? Sorry, Senator Shoebridge.
I should just also indicate that it may be during the course of the compulsory examinations that revealed that particular witnesses don't have much to say about a particular matter and aren't as relevant as we may have thought, in which case that could also shape the public hearing proceeds. Sorry, yes, Senator Shoebridge.
Commissioner, good to see you again. One of the arguments that's put in favour of public hearings is that a public hearing ventilates an issue. Often witnesses are examined and given certain versions on the public record. And then other relevant parties, maybe from the public service, maybe externally, can hear that evidence and may then approach the Commission and provide them with assistance after hearing the public evidence. Can you give any views on whether or not that plays a benefit in the role of the New South Wales ICAC?
Well, yes, absolutely. And that's happened time and time again. I mean, the classic example of that was in Operation Dasher, which you might recall was an investigation which started off in relation to affairs of Canterbury Council and then morphed into an investigation extending to members of Parliament. So that all emerged during the course of the public inquiry. Wasn't information that we had acquired initially when we started that operation. So that happens. But as I indicated earlier, beyond the question of getting additional evidence and further persons coming forward, the organisation has to be accountable. And in my view, public hearings are a way of keeping the organisation accountable. I mean, I
No, and
beg to
indeed,
differ with people who think that you can make findings against people, serious findings against people, in private.
indeed, it's been suggested by some experts that one of the bodies that's held most accountable by a public hearing isn't the witness or the agency under investigation, but the Corruption Commission itself. And it requires a higher level of integrity in the operation of the Corruption Commission itself if its hearings are in public. Is that your experience in New South Wales?
Well, I think it has been the experience in New South Wales. I mean, people are able sometimes to criticise the Commission for the way it's conducted itself. That's fair enough if they want to do that, but other people may form a different judgment. But if it's all done in private, I would have concerns about it.
The
Commission's not in a position to defend itself, and we've had inquiries done in private. I know the Ombudsman's done inquiries in private. You might recall one in New South Wales, which was the subject of sustained criticism by persons who were criticised in that inquiry, and the Ombudsman wasn't in a position to defend.
I think following some 2016 amendments, there was a requirement of the New South Wales ICAC to develop and then issue procedural guidelines for public hearings. Can you assist the committee in that regard?
Well, we can provide the guidelines to you, and you can, if you haven't seen them. There are on our website. I don't have them in front of me at the moment.
But they
But
particularly...
they're basically to ensure procedural fairness. Can I just indicate this to you? The compulsory examinations that we undertake are done on the basis of the person being present in the examination room with a legal representative, if they have one. They're not done in conjunction with all of the other parties who may have an interest in the matter that we're investigating. If we were to do that in private, you'd have to bring all these people along after you've done the compulsory examinations in order to afford procedural fairness to the person who might be the subject of an adverse finding. We don't do that in our operations. What we do is we do the compulsory examinations, we make a determination from the evidence arising out of them, and if we do feel that the relevant threshold is met, statutory requirements are met, we go into a public inquiry where everyone can see what the evidence is and has an opportunity to test that evidence.
And that has procedural fairness benefits in terms of other witness, but also efficiency benefits for the Commission. Is that your experience?
Well, the alternative is that you do it all in private again. So you do the compulsory examinations and then you run a private inquiry and you just publish a report. And at the end of the day, people haven't seen the evidence, which leads to you making the conclusions that you've formed, or the findings you've formed, and the recommendations for changes you've made.
My last question, Chair, is about there's been an ongoing negotiation between a variety of integrity agencies in New South Wales, including the ICAC, and the New South Wales government about funding and seeking to get more independent funding. Can you summarise where that has arrived at in New South Wales in relation to ICAC?
Well, there was a number of proceedings, as you'd be aware, in the New South Wales Parliament, which examined that, and there was a recommendation made for a change in the fund formula. In terms of our actual funding, we have been actually restored to the position that we requested by additional funding in the last budget from New South Wales. In terms of the mechanism moving forward, the government has announced that there will be a separate section of Treasury which will be responsible for assessing the budgets of the integrity agencies, that we won't be the subject of efficiency dividends, that we'll have an opportunity to comment in relation to any proposals to go to the Expenditure Review Committee, and we'll be subject to a new Treasurer's memorandum which will reflect our status as an independent agency. We haven't seen that memorandum yet. That's the position, as I understand it, that the government has reached in terms of our funding.
Thank you.
Thanks. Ms Lawrence, have you got...
Thank you. And this perhaps may be one that you prefer to take on notice. Given you've spoken to the threshold of serious and systemic corruption that's expected before you pursue a public hearing, do you collect data on how those matters then progress through criminal proceedings as compared to private? Is that data you collect to sort of follow through to the outcome?
Sorry, in relation to...
So I'm just curious as to whether you collect data on the outcome of prosecutions of serious and systemic corruption that, from public hearings as compared to private.
All recommendations that we make to the Director of Public Prosecutions for consideration of prosecution action are reported in our annual report together with the outcomes. Now, we have had instances where we've decided not to go to public hearing and simply recommend prosecution action or recommend consideration of prosecution action by the Director of Public Prosecutions. But generally speaking, our recommendations come out of the public inquiries that we make.
Thank you. And so your annual report will then reflect where...
Our annual report updates it, and there is an update also on our website.
And it will reflect where a proceeding has not gone ahead,
Yes.
as well as those
Yes.
that have, and the outcome of those hearings. Outcome
All the
of those
outcomes.
proceedings.
Just bear in mind that our power is to recommend to the Director of Public Prosecutions consider whether to take prosecution action. So it's a recommendation for the Director to consider. It's not a recommendation that the Director take the action. It's a recommendation that the Director consider it. Now, the Director will make a decision. The outcome of the prosecution action, that is whether the Director decided to prosecute or not to prosecute, is published. If the Director has taken proceedings, what those proceedings are for and what the outcome of those proceedings is, all publicly available information.
Thank you. And just one final from me. Is there ever a circumstance where you have made a finding of systemic or serious corruption in a report but chosen not to publish it?
No.
Thank you.
When it's a finding, we make findings in our reports. You can't make a finding unless you have a report.
But in
Does that
terms
make
of
sense?
publishing it, though, do you have an option to not publish in your Act?
If we go to a public hearing, we must publish a report to Parliament.
But private?
Well, no, I think it might be, you might be a little bit confused. I think you might be asking me, correct me if I'm wrong. I'm sorry?
I said she's not the only one.
Okay.
I'm confused
Well,
too.
I'm happy to. All right, let me just clear this up. Are you asking if there's an instance of serious or systemic corruption in which we decide not to go to a public hearing?
Correct.
We may decide that arising out of that, there should be prosecution action. That may be possible.
Sure, but also...
And we would not publish a report. We would simply go to the Director of Public Prosecutions and recommend that the Director consider taking prosecution action.
Okay.
We would not publish a report. We would simply furnish the information that we have to the Director, and the Director would make that decision. But we would not actually make a finding.
Thank
Does
you.
that clear that up?
That's helpful. Thank you.
So is anyone else unclear about that?
No, I'm clear as day.
I've
you
got
put it
one
that
further
way.
question if you've got time. There have been many questions here of organisations about making it a requirement that the Commissioner of the NAC should not be a former politician. Do you have a view on this proposition? Most of them, all of them in fact who have been asked that have said it shouldn't be a former politician. Do you have a view?
Look, I don't have a view. The Northern Territory says you can't be a recent politician, I think. The ACT has a different position on it. I think our Act says you can't be a serving politician. Bear in mind also that the agency, our agency also looks at corruption in the judiciary. If you bear that analogy across, you might take the view that you shouldn't have a judge, which might make it a little bit difficult.
Thank you. I don't think there's any further questions. Thank you for your time.
Thank you.
The questions. I think there might have been one question as a follow-up that someone asked you to provide further information, but we'll be in contact if I...
Look, I'm happy to supply anything relevant to the New South Wales Commission in writing if you wish to ask me the questions. I'm sorry, I can't stay any longer. I have to go.
No, that's fine. We appreciate you giving us your time at such short notice. Thank you. We might go now to Mr. Redlich. Is there any? Would you like to make an opening statement before we start questions with you?
No, I don't desire to do that, Madam Chair. We filed an extensive submission with the committee, and I'm happy to assist the committee any way I can.
Thanks, Mr. Redlich. I might ask, I think, Mr. Walhan.
Thank you, Commissioner Redlich, for your submission and for making time to appear before us. I'm not sure if you heard the New South Wales Commissioner's evidence.
Yes, I did. I listened.
He said it is not his role to act as a commentator or analyst on federal issues, yet you have taken a different view, despite being in the same position in Victoria. And in another context, there's a state election in November, and the two major parties have put on the public record in Victoria that public hearings is an issue for the election. Why do you think it is appropriate for you to weigh in on that issue and on the federal questions before this committee?
Well, I'm going to take a point of order on that. Effectively inviting this witness to enter the fray in relation to Victorian politics, I think, is unfair on a witness who's chairing the Anti-Corruption Commission. And my reading of the submission is this witness never made a statement relevant to the Victorian election. And I think trying to politicise this witness, the head of a corruption agency at the beginning, is a very unfortunate start.
I agree with the intervention. I think the submission doesn't go as far as you've suggested, and I don't think the Commissioner has entered the fray. Can you rephrase your question?
I will. So leaving aside the Victorian state election, the comment made that he did not think it was his role to comment or analyse federal issues. Why do you think it is appropriate for you to do that?
Well,
I'm going to take one further objection. My understanding is this committee invited IBAC to make a submission and invited IBAC to make a submission on the bills. It was a resolution of this entire committee. So to challenge this witness for responding to our own invitation is, I find it, an extraordinary proposition. And again, I think it's out of order. We invited this witness to make this submission. And the witness responded.
And can I respond to that, Chair? We invited both, and they both took a different view. I'm asking for the Commissioner's opinion why his view is different. I think that's a reasonable question.
Well, again, I object. When a witness has responded at our invitation to assist us in our work, and
but
then
how they respond is up to them.
And then the questioning is attacking them.
It's not an attack,
I think it
it's a
is
question.
totally out of order.
It's a question.
Could I add to that? The previous witness also indicated that he hadn't sufficiently investigated the legislation before us, and he didn't feel he had the capacity to comment.
Well, he said it wasn't his role. That's a
Okay, I've
different
got a
thing.
rule. Look, I think the witness and IBAC was asked by us. Unlike, I think, every other Integrity Commission, they wrote a submission, which and as I recall yesterday's discussion, people who didn't put in a submission were severely criticised. I don't think we should be opening. We've got limited time. Mr. Redlich is busy, is going to be here till 12:30, and I think going backwards and forwards about political matters when there are substantive matters of law and the way in which it operates, our time would be better spent interrogating that than talking about
I'm happy to move on, Chair.
So if you could confine your questions, but bearing in mind you've spent a number of your minutes arguing about this. Can you go to the substantive question?
To be fair, the minutes have been the response on the objections, but I'll move on. Commissioner, 4 months ago there was an article in the Melbourne Age noting that there was a letter that you had sent to the State Attorney General about the legal challenges to your draft findings acting as a delay for you publishing your reports. And I think one of those was by way of an urgent injunction preventing the tabling of the report. And can you just elaborate what the grounds for those were, and in particular on privilege and natural justice grounds?
Well, it's a little difficult for me to do that because, with the exception of one piece of litigation, there are either suppression orders or closed court orders made in relation to numerous pieces of litigation, and I think it's probably helpful in the course of amplifying some of what's been said in our submission to explain that part of the consequence of what is a necessary natural justice process at the end of an investigation, people exercise their rights to challenge in different ways the tentative findings that have been provided to them. But I don't think, unfortunately, because of the nature of the orders that are made in litigation, I have difficulty in being able to more fully answer your question.
That's all right, I'll move on. The previous witness noted that the hearing time for hearing days as a percentage in New South Wales is 40%. Correct me if I'm wrong, but when we did an analysis of your reports from 2014, because that's when you started, or your institution started publishing hearing times, and we noted that it added up to about 27%. Does that seem accurate to you?
Well, in round figures, it seems so.
And would you agree?
It's a very small portion of our investigation work that ever finds its way into a public hearing or a special report.
But when measuring public versus private hearings, would you agree that that's a constructive comparison to make in terms of hearing days rather than total investigations?
No, I don't think that's a useful comparison because the number of hearing days is immediately proportionate to the complexity of the particular litigation. So one of the public hearings that took a long period of time was Operation Sandon, in which we looked at the Cranbourne Council, spanning a course of conduct of almost 10 years in relation to some of the persons of interest. And so, in a sense, that distorts the number of public hearings or the proportion of public to private hearings because it was a very long investigation.
But you would agree there are equal issues with measuring investigations. Some of them are quite benign and lead to nothing and are off your desk quite quickly, aren't they?
They're off our desk quickly because we refer them to other agencies to investigate, notwithstanding it meets our jurisdictional threshold. Regrettably, very few of the matters that we do decide to investigate are off our desk quickly, and that's because it's been perceived that the particular matter we determine to investigate warrants serious attention.
Commissioner, if I could refer to your submission, you, I think it's on, there's no page numbers, but it's on page 3 of your submission, or no,
yes.
Sorry, 3, 4, page 5, sorry, I've scribbled out the page numbers. So page 5, this is the page where you refer to public hearings and exceptional circumstances. I'd just like to ask you about that.
Yes, certainly.
So you, about halfway down the page, you talk about Section 117 of the IBAC Act. And you say that this has had the effect of placing an artificial limit on IBAC's ability to conduct examinations in public. And you go through the 3 criteria that the Act outlines, and I'll just summarise: serious or systemic, it's in the public interest to hold it, or public hearings can occur without unreasonably damaging a person's reputation, safety or well-being. Can I ask you this? Have you ever been satisfied of those 3 items, yet not satisfied that it was exceptional?
I'm not sure. I'd need to reflect upon each case where we've grappled with the question whether or not public hearing. Plainly enough, all of those where we have conducted a public hearing, and I think it's been 5 during my period as Commissioner, have met all of those requirements. It might be helpful if I answer your question this way. What the NAC bill does not provide for is that if the Commissioner is not satisfied that there'll be no unreasonable damage done to a witness's reputation, the Commission cannot conduct a public hearing with that witness. My primary concern with the way in which the bill is presently drafted, and it's modelled largely on the IBAC legislation, my primary concern with the form of the bill is that it does not provide that if the Commission comes to the view that a witness's reputation may be unreasonably damaged, they cannot examine that witness in public. The way the bill is expressed, that it's merely a discretionary consideration for the Commissioner, that the Commissioner, quote, may have regard to that question. That's not, in my respectful submission, good enough. The bill, if it's to provide the protection, which I think should exist, and I believe that that's primarily the objective of the bill, to ensure that reputations are not unfairly damaged, should be quite prescriptive. It should require that the Commissioner will not examine the witness in public unless the Commissioner is satisfied that the witness's reputation will not be unreasonably damaged. And of course, how does one reach that state of satisfaction? By looking at the cogency of the evidence that exists in relation to that witness's conduct. If the Commissioner is satisfied that that evidence demonstrates on its face a high degree of likelihood that the witness's conduct is worthy of being examined in public, then the Commissioner can proceed. But the way the bill is presently drafted, it's merely a discretionary consideration. Now, once you put in a mandatory, an obligation on the Commissioner to be satisfied that reputations will not be unreasonably damaged, in my view, the need for exceptional circumstances disappears. The other...
Sorry, yeah, sure.
Just one.
I was just going to go into that in detail. You are mandated in the Victorian Act, but this one is discretionary. So this one says may.
Yes.
And so you're criticising the mandatory nature of that. And would you also...
I'm criticising the discretionary nature of it.
Oh, you think it should be mandatory?
Correct.
Sorry, I misinterpreted you. Can I just get you... sorry, Tanya. The difference in that part, and in yours it's 117C, it talks about unreasonable damage to a person's reputation, and in 73.3C, instead of unreasonable, it says unfair. What do you think the differences are between unreasonable and unfair?
I think that's unfair to ask you.
That's an unreasonable comment, though.
I could be prejudiced.
There may be differences. I noticed that in the bill, at some points, it uses our language of unreasonable damage, whereas at other parts it uses the phrase unfair prejudice. I'm not sure that there's a great deal of difference between the two. But I think while we're dealing with that particular clause, 73(3)(c), may I make the observation that while the draftsman has picked up the wording of our section 117, I think it's unsatisfactory to lump together in the one clause questions of unreasonable damage to reputation and unreasonable, I'll use the wording of the provision, unfair prejudice to reputation, and in the same phrase, unfair prejudice to well-being. I think the issue of the witness's well-being has to be treated quite discreetly from the question of reputation. And why is that? Because surely no one is going to advocate that if a commission comes to the view there will be any serious damage done to a witness's welfare, they will not be called in public, but may well be they won't be called in private either. Surely we can all agree on one thing, and that is we are not going to damage the welfare of witnesses beyond the stress which inevitably accompanies anyone having to give evidence, whether coercively in private or in public. But I think it's unfortunate that those two concepts, reputation and well-being, are lumped together in the same clause.
Can we move on?
No, I had more, but if Tanya wanted to jump in.
No,
Yeah.
I'm going to move to her.
Don't have far to
You've
go.
got one more question
Yep.
you can ask? Because we've got to move on.
When I asked you about if you could give an example where those three criteria were met, but it's still not exceptional, you didn't have them at hand. But can you give us a hypothetical that meets those three criteria, but yet is not exceptional?
Well, shortly after my appointment, we sought advice from government about how the two concepts, on the one hand, that it needs to be exceptional circumstances, and on the other hand, that you should only do so if it's systemic or serious. How can you put together exceptional and systemic in the one breath? There is obviously a tension between the two concepts of being exceptional and something being systemic. They don't necessarily have to be in conflict, but on the face of it, there is an apparent tension between circumstances being exceptional and circumstances being systemic. It's a difficulty.
Thank you. Dr. Haynes.
Thank you very much for your submission and for your witness today, Commissioner Hoytnick.
Redlick.
Redlick, sorry. Would you agree that the requirement of exceptional circumstances, given what you've just been talking about in the IBAC Act and what's proposed in the National Anti-Corruption Commission, is a significant departure from the Australian norm regarding public hearings in integrity bodies?
Well, as the debate about this issue has revealed, it's hard to... I'm sorry, I've just lost the picture, but so are you able to still see me?
Yes, we can. Thank you, Commissioner.
Very good, very good. As the debate has indicated, I'm not sure that there is a norm, but I think there is a very strong body of opinion that purposes of investigation of corruption are better served if, wherever possible, it's subject to the two protections that I've mentioned, namely no reputational damage that's unreasonable and no damage to welfare, if those conditions can be satisfied, that the investigation of corruption is better served by public exposure. There is no comparison between the public's interest and understanding of integrity issues is substantially enhanced by a public hearing. And conversely, when matters are dealt with in private, distrust arises in relation to the way in which the issues have been managed, and often public confidence in the integrity agency is also lost. And unfortunately, in Victoria, in relation to a number of our private investigations, there has been so much public debate about the processes that we have followed in private, none of which has been either fair to the Commission or to the individuals involved.
I think that's a very important observation. Can I just go back to your previous comments around exceptional circumstances and the safeguards that are in place with this bill? Am I right in suggesting that your thoughts would be that if the term may was replaced with must when it comes to the safeguards as outlined previously, that we would no longer require the term exceptional circumstances in this legislation as drafted?
That is the Commission's submission, yes.
Yes, thank you. Could I just turn our minds to budgetary independence and...
Chair, this is an important... I just have a quick follow-up to that specific question. It's very quick.
Very quick.
On that answer, one of the submissions that was made in the leading case in the Victorian Court of Appeal, R and Lamb, by the plaintiffs, was that it didn't have regard to a fair trial. The concept of considering a fair trial isn't in that list. Do you think that it should be if you were going to remove exceptional circumstances?
Do you mean by that how might a public hearing impinge upon subsequent charges and the prospect of a fair trial? Is that what you're directing attention to?
I think so. But when I read the submissions in the at first instance, it said that was their lead submission, was that the Commissioner didn't consider the potential interference in a fair trial, a subsequent fair trial. Is that something that you think should be in that list?
I think that's a relevant consideration.
Can I just make the comment that case, as I understand it, was rejected on appeal, and is that relevant to what we're discussing around this safeguards and the change in the phrase may or must?
Oh, it doesn't matter if it was rejected. It's a consideration that was relevant.
I think it matters a lot. And if I could just continue.
And he answered the question. You might not like the answer, but he answered it.
Well,
Okay, can we just not argue? Can we go, Dr. Haynes? Can you?
Yes, I wanted to move off this topic and get to a point made in the Commissioner's submission in regard to budgetary independence. And
Yes.
Could the Commissioner just speak to this? Unfortunately, I think this report hasn't been published in time for today, but you and the Victorian Auditor General's Office and the Victorian Ombudsman have all made the point that budgetary independence is key to the effective functioning of the Victorian IBAC. Would you have anything to say or any recommendations for this committee around budgetary independence for this establishment of the National Anti-Corruption Commission?
It's inevitable that integrity commissions who are examining the conduct of executive government, I mean by that public servants, ministers, ministerial advisors, that from time to time their investigations will bring them into a conflictual relationship with government. And it's in New South Wales, of course, the issue has now been debated for a considerable period of time the need for true financial independence in relation to the fixing of budgets for integrity agencies. We've set out in the joint submission of the Ombudsman, the Auditor General and the IBAC Commission various examples of commentary made at a senior level, for example by the Public Accountability Committee of the Legislative Council in New South Wales, about the need for true budgetary independence. Most recently, in the really valuable review by Professor Coldrake in Queensland, he again has reiterated the importance of the budgetary determinations being fixed by Parliament, not by the Executive. And to the extent that it's necessary to protect against the always existing risk of political interference with the budget of the day, that there should be a tribunal, as we've recommended, independent of the Executive and under the control of Parliament, that determines the budget.
Thank you, Commissioner. Given that, and the drafting of the bill that we have before us has a joint parliamentary committee with some oversight over the budget, and that committee has a government chair with a casting vote, would you make some comment about that and how that may impact the politicization of the budget for this commission?
Well, obviously, it's less than satisfactory in my respectful view. The bill proposes, as I follow the arithmetic, that the Parliamentary Committee of the NAC would comprise 6 members of the party in government at any given point of time, 4 members of the opposition, and 2 members from neither the governing party or the primary party in opposition. So that, and in addition, that the chair of the committee should be a member of the party in government. With respect, that is an unsatisfactory formulation of the composition of the parliamentary committee, because it again exposes the independent officers of the Parliament, such as the Integrity Commissioner. It exposes the Commission to the risk that is always there of political interference. And without descending to any particularity, some members of the committee will be aware of some issues that have arisen in the Victorian setting over the last 12 months in relation to issues of politicisation of the Parliamentary Committee in Victoria.
Thank you very much, Commissioner. That's all. Thank you, Chair.
Mr Lim.
Thank you, Commissioner, for coming in. My question is, the IBAC default to private hearings. An exemption is granted in exceptional circumstances. What is your response to those who believe that the test of exceptional circumstances for specific criteria and circumstances for public hearing or evidence is too broad, and that these undermine the public trust in the Commission?
Look, I'm prepared to speak further on that, but I believe that the answer that I've already given the committee addresses that question. Is it desired that I expand further on what I've said?
Maybe just a few points.
Very good. Look, the two, as I see it, quite aside from the obvious benefit of the public hearing in that it exposes the misconduct which is the subject of the investigation, and the matters that have already been touched on, namely that witnesses may come forward or be more willing to cooperate once it becomes apparent that the issues are being fully explored by a commission. The two most important considerations which stand in favour of public hearings rather than private is the educational benefits that flow from publication of the investigation process, both in terms of learnings which individuals and, more importantly, public institutions derive from the public examinations and the failings which are exposed. But secondly, the level of trust which is created, not only as to the fact that the Commission is engaging in that investigation openly, but the trust that then is derived by the public that where there is misconduct, it is going to be properly investigated and exposed. So the education and trust, as I see it, are really powerful considerations for preferring public hearings where the conditions that I previously mentioned can be met.
Thank you, Commissioner. Can you outline the extent of protection available to whistleblowers who engage with the Independent Commission Against Corruption in New South Wales? Are you aware of anyone who expressed an interest in coming forward but failed to do so as they fear that this protection didn't go far enough?
Well, sorry. How can
Yeah,
the
I'm
witness
not
answer
familiar.
that
I'm not-
about the,
Yeah. I'm
not
the
fam-
witnesses that haven't come forward to it?
Yeah. I'm not familiar, firstly, with the New South Wales setting, but in relation to this issue generally, I think the committee can take it as a given that it's a fundamental part of the human condition that people are reluctant to come forward and expose themselves as complainants, and it is only where they are satisfied that they are not going to be isolated, that they're going to be protected, that the Commission is bent upon a fair process in exploring the issues, that people will come forward and support the investigations of the Commission.
Thanks, Commissioner. Last one is, I want to ask you if there is any power, in your view, within each of your jurisdiction, of power left unused, or that require expansion to be able to better investigate corruption?
Well, look, I'm not sure if this is an answer to your question, but I am troubled by the wording of section 41, subsection 3. So we're dealing here with the question of when an investigation should be undertaken by the NAC. And I see that the way it's currently formulated, it says that an investigation should be conducted or continued if it could involve corrupt conduct that is serious or systemic. And so it's at that point in the formulation of the provisions in the bill that the requirement that it has to be serious and systemic is inserted. I'm troubled, however, by the notion of the Commissioner being satisfied that there is such conduct to continue with the investigation. It has often been the experience of the Victorian Commission, and I suspect of commissions around Australia, that whilst at the time that an investigation is commenced, the threshold for investigation is met. But as the investigation unfolds, evidence emerges that satisfies the Commission that the conduct falls short of the definition. Now, I hope no one is suggesting that at that moment of time, the investigation process should cease. And I say that for this significant reason, that invariably what flows from an investigation is the identification of integrity and process failings. Whether or not the allegation of misconduct amounting to corruption is made out, invariably the investigation provides extraordinarily helpful information about the way in which the relevant institutions approach the subject matter of the subject of the investigation. And it would be a real pity if 41.3 were construed, and I suspect if it's left as it is, it will be so challenged, that people argue that at a point of time when it emerges that the evidence was not serious and systemic or didn't meet the definition of corruption, that the investigation should immediately be halted. That would be a real pity.
Thank you, Commissioner. Thank you.
Senator Scarr?
Thank you, Chair. Commissioner, I just want to flush out that point a bit further that you've just made, because I think it's the first time at least I've heard that issue raised that you've raised in this context. And if I can ask you a question in the context where in the previous Parliament I served as Chair of the Parliamentary Joint Standing Committee with oversight of the Australian Commission for Law Enforcement Integrity. And one of the issues, and Mr Zapier is on this Joint Standing Committee and we served on that committee together. One of the issues in terms of our oversight was making sure that that committee was focused on the higher level sorts of corruption issues, if I can put it that way, rather than lower level issues which could probably be dealt with by disciplinary proceedings or internally by the department. And that was a specific issue. So in the context of this provision, isn't one scenario that the Commissioner starts investigating something and then, as you say, at initial face value, maybe this is part of a bigger systemic problem, but then it emerges, no, this is a one-off, lower level personal frolic, etc. I just want the ability to refer it back to the department for the department to apply appropriate disciplinary proceedings, etc., and not to engage further limited resources of the Commission in terms of considering that issue. Can that scenario legitimately arise as well as the concern you raised?
Certainly, the Commission has the discretion under the current bill to continue an investigation until such point as it becomes apparent it no longer meets the definition of corrupt conduct that is serious or systemic. If they get to the point where it becomes plain to the Commission that that definition can no longer be met, at the present time the Commission has no alternative but to stop, as I read the provision. It could then, of course, as you say, refer the matter to the relevant institution or organisation. I think that should really be left to the discretion of the Commission as to whether or not the investigation should be completed.
Yep. Okay.
It will depend on a complex value judgment.
Okay. That's very useful interchange. Thank you very much, Commissioner.
Can I just ask a question? Mr Redlich, I perceive this is going to go longer than till 10:30. Have you got a time that you have to finish by?
I'm prepared to devote whatever time is necessary to assist the committee.
That's a very brave offer.
I just might vary what the program says.
Can I just make the observation that it seems to me that if commissioners, particularly commissioners who've been in the job for 5 years, and my appointment is about to come to an end, if we can't give the committee the benefit of our experiences, that's very sad.
We appreciate
Well, that's the attitude I like to hear. So Commissioner Vanston is actually in the room with us, and I was thinking perhaps, Commissioner, if you'd like to go to the table, then we can sort of deal with you all together, if that's okay. We're just varying our program, people have already been asking questions of Mr Redlich, and he may drop out, but it might be useful if you come to the table and then we can interpose any questions in relation to South Australia, if that is helpful to you. But it may be, Mr Redlich, that you finish and we finish up with the questions, but I know there's a couple more questions coming our way.
Sorry, can I speak to that, Chair?
Speak away.
The South Australian experience and legislation is quite different to Victoria. I think it's constructive to extend the time for Commissioner Redlich, but I think it would be more helpful if you picked a time and then we could focus questions on the South Australian commissioners instead.
Well, I'm not suggesting that we don't focus on the South Australian Commissioner, but I've got the commissioners here on times just sitting. I don't see. Is there any downside in having her sit at the table and you can direct questions to her about South Australian experience? I wasn't suggesting that we intermingle the questions and that the questions that are directed to Mr Redlich.
Well, it might be Mr Redlich can leave.
I think Mr Redlich can also leave, but as a courtesy, I just thought I'd invite Commissioner Vanstone to the table, given she's been here and she's here in person.
Or we can spend the next 5 minutes debating it.
We could, and I'm not going to do that. I've decided how we're going with it. I will definitely not intermingle them. I do know that they're separate, and I don't think.
And I think it's a good idea.
Mr Redlich's generosity doesn't extend for another hour and a half, I'm pretty sure. Thank you. Sorry, Senator Scarr, go for it.
Thank you. Back into it. Commissioner Redlich, you make some very useful comments in relation to the referrals. The threshold that has to be met to trigger a referral by the head of an agency. And you would have heard, I think, the evidence from the Commissioner in New South Wales who commented that the biggest mischief is not getting referrals rather than getting too many referrals, if I can paraphrase him in that regard. There has been...
That's also our experience.
That's also your experience.
Yes.
So there is this question about the threshold. So what's the relevant threshold under the Victorian legislation, and how has that worked in practice in terms of the flow of referrals to the Commission? Do you think you're in the right space in terms of the flow of referrals coming through?
Thank you for the question. Section 157 of the IVAC Act requires that the principal officer of any public institution must notify IVAC of any corruption. So there's no gloss on the term corruption. If the conduct provides a reasonable suspicion of corruption, then there's an obligation, a mandatory obligation. What I think we're trying to say in the submission we've provided the committee is that it's an unfortunate gloss on that obligation to add the words corruption that is serious or systemic. Which simply invests in the principal officer of the relevant institution a discretion not to notify the NAC where there's corruption which the officer can argue didn't attain the level of being serious or systemic. It is far better that there be an obligation that any conduct which meets the corruption definition is notified, and then of course it becomes a question for the Commission, usually in engaging with the relevant institution head to determine how the matter should be progressed.
Right. So if I can just return to my previous line of questioning in relation to this, and we're talking about 41.3, serious and systemic, and the discontinuation of an investigation. We're now at an earlier stage of the process. There could be lower level, and again, this comes back to my experience on the ACLI committee, oversight committee. There can be all sorts of lower level corruption in terms of travel allowances, claiming claiming expenses which weren't legitimately incurred, things of that nature, providing a false CV, I guess. At that sort of lower level, rather than something which is more systemic, the monetary value at stake can be less. So not to downplay the significance of those issues, But how does that work in practice? Are issues at that sort of level being referred through to IBAC? Issues which, on a reasonable interpretation, should be dealt with, perhaps more appropriately through internal disciplinary procedures and so forth?
Well, it's not my Commission's experience that those sorts of matters come to us. But if some of the examples you've cited plainly enough meet the definition of corrupt conduct, but they're not the sort of matters that you would expect that a Commission would direct its resources to addressing. You would expect the Commission to refer such matters back to the relevant institution. The point we make in the submission is that there should be, in the legislation, there should be a power of referral accompanied by the ability of the Commission to review the investigation which is undertaken by the institution when it's referred back to the institution. The power review is a really important one because it enables the Commission to then look at whether or not the conclusions reached were in accordance with the evidence available and whether or not the outcomes are appropriate, having regard to the nature of the issues.
Right. Commissioner, if I can move on to another subject, I was impressed by your testimony in relation to a distinction being drawn between potential impact on someone's reputation as opposed to potential impact on their well-being, and the focus that you had as a commissioner with respect to the well-being of those who are touched upon your inquiries. How we talked about that in the context of private-public hearings. I'm interested to know how the Commission applies that principle in terms of engaging with witnesses and the general conduct of the Commission's business in circumstances where some of the privileges, in terms of the privilege against self-incrimination, the privilege around legal professional privilege, but also non-disclosure requirements can be potentially imposed, which presumably could lead to someone touched by an inquiry feeling isolated. In moving back from public-private hearing debate, how does the Commission in practice deal with those sorts of issues?
Well, witness welfare can arise in two ways. It can either arise because there's information available to the Commission, which on its face suggests that there's a welfare risk which needs to be properly considered. And I am able to say without exception, to my knowledge in the history of the Victorian Commission, that where there is a red flag, the witness is either not examined at all and certainly not examined in public, or provisions are made to address the witness's welfare. That should be a line which nobody should cross. And of course, I'm speaking now about welfare issues that go beyond what inevitably is the stress associated with ever a witness having to be coercively examined.
Okay. Two more areas of questions from me, and one of which I will seek Ms Vanstone's view as well. First to you, Commissioner, in relation to a proposal you put in your submission, which from my perspective I could see the merit, not wanting to, I guess I've just set it up in a certain way, but you countenance the insertion of a provision that appointments are made in the public interest without regard to a political or other purpose outside the objects of the Act. And that issue, that provision is actually in the IBAC legislation. Could you just talk about provide a bit more colour around the benefit of that?
You're talking about the appointment of a commissioner?
Correct.
I am reluctant to express any view about the question that was raised, I think, with my colleague, New South Wales Chair Commissioner, about the whether or not a commissioner could be a former politician.
Sorry, Commissioner, I wasn't going into that area. It's page 9 of your submission states, and I'll quote it perhaps for ease of reference.
Oh, yes.
IBAC considers that the bill ought to include an express provision, such as that outlined in the COAT Best Practice Guide. Appointments are made in the public interest without regard to a political or other purpose outside the objects of the Act. End quote.
Well, I think that submission speaks for itself.
It does.
It's plain for a political consideration to be entertained, seems to me to stray beyond any relevant considerations.
Yep, okay. Last question, and I'll ask Ms Vanstone if she'd like to comment on this. We received a submission from Mr Bruce McClintock in relation to the importance of the inspector, the role of the inspector in terms of agencies such as this. And in Mr McClintock's view, the powers of that agency should extend to an audit function. So it isn't just a reactive function responding to a particular complaint, but there's a more proactive role for the inspector in terms of the discharge of its oversight function. And I'm just interested in both of your respective views in that regard. So if Mr Redlich, to you first.
Oh, thank you. The bill makes substantial proposals about the powers of the inspector, and I have nothing to say about the appropriateness of those provisions. And I note that there is some suggestion in some of the submissions that further powers should be included. Plainly, it is of vital importance that a commission is properly oversighted, both to ensure compliance with the very specific protection provisions which are included in the legislation, but also so as to satisfy the public that the investigation of integrity issues is going to be conducted in a fair and proper way. My only observation, and I regret to say it's not actually set out in the submission, is there needs to be some form of oversight of any coercive powers which the inspector exercises. One of the features of the Victorian provisions, and it's now replicated in the bill for the NAC, is that whilst the inspector has a range of coercive powers available to him or her, and those coercive powers will mirror those of the Commission itself, there is no oversight provision whatsoever in relation to the exercise of those powers, and there needs to be such a mechanism. Indeed, the reverse is the case under the NAC bill. It specifically provides that the NAC committee cannot oversight the way in which the inspector exercises those powers. So there is currently a significant gap in the legislation, because there must be, in real time, there must be a mechanism available to the Federal Commission to be able to seek redress if the inspector oversteps their mark in relation to the exercise of their coercive powers.
Right, okay.
Sorry, yeah. I think Commissioner Vanstone's going to say something, but I just probably need to welcome the Honourable Anne Vanstone, the Independent Commissioner Against Corruption in South Australia. And I should just tell you and you were going to give evidence, for the Hansard record, would you please state your name and the capacity in which you appear before the committee so that the Hansard knows it's you?
Anne Marie Vanstone,
Thank you. And I should just also tell you that the committee does not require you to give evidence under oath. I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. But I invite you now to answer the question from Senator Scarr.
Thank you.
Good morning.
Good morning. Currently, we are overseen by a parliamentary committee and a reviewer. Last year's major amendments created the position of an inspector with far greater powers, including the ability to search premises and so forth. But that has not yet been proclaimed. However, the reviewer has open access to all our documents. He has, it's the Honourable John Sulan Casey. He has remote access to anything he wants to look at on a continuous basis, and he comes into the offices of the Commission and is given any other materials he wishes to have. So although he furnishes an annual review and he also would respond to any complaints about the Commission, if there were any, but there aren't any, he constantly oversees us throughout the year and examines particular powers that we exercise. If and when the new provisions are proclaimed and a new inspector and a deputy and staff are appointed, then I respectfully agree with Mr Redlick's view that there would need to be supervision of those powers exercised by the inspector, but that's down the track for us. As I say, I have no objection, of course, to our reviewer having open access at any time to examine all our exercises of power, quite outside any complaints he might receive, and to be assisted in getting what he wants in a format that's digestible to him. And I, with respect, the NAC bill could well incorporate a wider audit power of that sort.
Okay, so you think there is, so just two supplementary questions to that response. You think there is ambit to include, to expand the powers, legitimately and reasonably expand the powers of the inspector under the NAC bill as it's presently drafted, so that it encompasses a wider, broader remit for the inspector? Is that
yes, that's right.
Fair summary?
That's right.
And secondly, this question of, which is again the first time this has been raised, so it's very helpful that both you, Commissioner, and Commissioner Redlick raise it. In terms of, and I was thinking that phrase, who watches the watchman, it's who watches the watchman of the watchman.
That's right.
You're showing your Dr Seuss
Yeah.
in there. Yeah, that's right.
Thank you, Senator Shoebridge. And so is that a function which, and I'm just thinking on the spot here, that perhaps the Commonwealth Ombudsman could have a role, or instead of creating a new agency, trying to find another agency in the matrix of integrity agencies at a Commonwealth level, what would be the appropriate agency that has that oversight role? Do you have any thoughts on that? Maybe you could take it on notice, but interested in any thoughts you might have.
Well, certainly the Ombudsman would examine any powers exercised by the inspector, but it might be that more than that would be required, someone specifically looking at the inspector's use of his compulsory powers.
Okay. Commissioner Redlick, do you have any thoughts on that?
I'm not sufficiently familiar with the federal environment to be able to immediately suggest whether that oversight power should be reposed, but it is important that there be some real-time capacity in the unlikely event that an inspector overreaches in terms of the exercise of coercive powers or unduly interferes with the way in which the Commission is seeking to conduct an investigation or in any report that it wishes to publish, that there be a real-time capacity to view and correct any such overreach. I'm happy to, on notice, provide something to the committee.
Yeah, okay. Last question. Sorry, I was just advised by one of my colleagues of a point which is useful to raise in this context, and that is Commissioner Redlich, the Victorian Inspectorate has made a submission. Are you aware of the submission they've made?
Yes, I've read Mr Moran's submission, yes.
Okay, and paragraph 8, just for the benefit of everyone on the committee and everyone listening, the most significant difference in the oversight function that is between the NAC bill and the Victorian legislation is that the NAC bill does not require the NAC to notify its inspector of the use of coercive powers, as IBAC is required to do. And then, end quote, and then the inspector outlines some of the benefits of that notification framework. From your perspective, Commissioner Redlich, you think there's utility in terms of that notification?
I do.
Okay, and Commissioner Vanstone, from your perspective, can you see the utility of that notification framework?
It may be unnecessary in the current framework we have, but I wouldn't have any objection to it, certainly.
Okay, thank you very much. Thank you, Chair, and thanks for your indulgence in terms of time.
Thanks. Senator Shoebridge.
Look, thank you both for your attendance today. Commissioner Redlich, my reading of the NAC bill, and it's section 177, it expressly says that the parliamentary committee, one of the functions of the parliamentary committee is to monitor and review the performance by the Commissioner and the Inspector of their functions. And then in fact it gives some more detailed information about the parliamentary committee's role in oversight in both the Commissioner and the Inspector. Would that be sufficient in your mind, having the parliamentary committee, and putting to one side the proper makeup of the parliamentary committee,
Yes.
having the parliamentary committee oversight the Inspector?
Well, if the composition of the committee does not reflect control in the government of the day, that's an important step forward. I'm not sure what. Given there are a number of exclusions in that subsection, I don't have it in front of me, but there are a number of exclusions as to what the committee cannot do. I think there needs to be some attention given then to ensuring that none of those exclusions would preclude the committee being able to step in immediately to address any error in the way in which the inspector is exercising a coercive power.
Yeah. So some of the express exclusions about being able to look at an individual decision or an individual corruption inquiry of the NAC, you wouldn't
Correct.
want those preventing a high level of scrutiny of the inspector. Is that your position?
Correct, because it's most likely that the issue in real time where there might be a concern is because the inspector is seeking to take a step that immediately impinges upon a current investigation.
And indeed, I can recall a long-running war in New South Wales between the then Police Integrity Commissioner and the Inspector of the Police Integrity Commissioner, which produced significant dysfunction in the body.
Yes.
And I'm not going to pass judgment on that, but
No.
But
No, but
that's a case in point, isn't it?
It is. It's simply a realistic identification of a risk that is always going to be present, which needs to be addressed.
One of the other issues you raise in your submission is the need for an unambiguous ability on the part of a corruption commission to initiate investigations and initiate inquiries.
Yes.
Can you explain why that's important? Why you say that based on your experience?
Well, I think some of our most important investigations have been what we call in Victoria own motion investigations, where we have not actually received a complaint. I think the committee would recognise that very often the genesis of an investigation is through great work that some forensic journalist has undertaken, which finds its way into the media of the day, and which on proper examination by the Commission enables the Commission to say, this information meets our threshold, we should investigate it.
You referenced in the annual report, your most recent annual report, concerns about not having best practice legislation, but then specifically the extent to which litigation is frustrating the work of the IBAC. Can you give us some insight into how many cases, what sort of resource challenge litigation has been for IBAC?
My hesitation is only about how much detail I can provide that neither infringes any suppression orders or closed court orders or any confidentiality or in the terms of the NAC bill, non-disclosure obligations. Perhaps I can answer it this way. Some of the longest investigations that this Commission has undertaken have not yet culminated in the publication of a report because of the litigation that has emerged. It's important for the committee to recognise that particularly in the context of private examinations, that private examinations are not usually conducted with the persons of interest who are the subject of the investigation being present and aware of the examinations taking place of a multitude of witnesses who have relevant evidence to give about the person of interest's conduct. And so the first learnings that a person of interest might have of the fact that there's been a long investigation underway is when that person of interest is examined in that private setting. And then the obligation under the IBAC Act, which I think is in the broad mirrored in the NAC bill, is that that person, after they've been examined, is also entitled to receive a draft of the report which the Commission is proposing to table. And the Act specifically provides for that person to then have the opportunity to respond to any adverse comment or opinion. And it's therein that the litigation in the main arises, where people feel that they haven't been given an adequate opportunity to address the issues, that they may not have been given all of the evidence that they argue that they should have received. And it's that which can grossly protract the time that it takes before a report is tabled. I'm talking about doubling or perhaps even more than doubling the length of time that would otherwise be taken before an investigation is concluded and a report tabled. We haven't said this in the submission, but it is an issue that I'm pursuing with government, that it considers some legislation that requires the relevant judicial, the relevant court and judicial officers to give some form of priority to litigation which, on the face of it, involves the public interest. We have no such legislation at the moment, and so when the Commission is involved in litigation, that litigation simply takes its place in the scheme of things, and it can be a very long time before it's resolved.
Commissioner, could I invite you to do this, to consider on notice what additional information you can provide us in terms of the delay and the cost as a result of legal challenges to the work of the IBAC and the nature of those challenges. And I'd also, you will form your own view about whether or not parliamentary privilege will provide you with a greater latitude to provide that response than you might otherwise think. But could I ask you to provide that on notice?
Well, I'm certainly happy to take that under consideration and give you whatever assistance I can, Senator.
Thank you.
Thank you. Are there any other questions of Mr Redlich?
Chair, can I
Yes,
ask
Mr Zapier?
Commissioner Redlich, can I just ask you a question in respect to the public hearings? from your experience, has there ever been a public hearing where, having held the public hearing, you then formed the view that maybe a person's character had been in any way affected, or indeed, at the end of the public hearing, you've concluded that perhaps the hearing was not justified to be a public hearing?
The area where this difficulty will arise is not with respect to the persons of interest, that is, against whom the investigation is ultimately directed, because, as I've indicated, the Commission will have already had to reach the conclusion in order to examine a person of interest in public or others in relation to that person's conduct, that there's not a likelihood of unreasonable damage to their reputation. So, to use, I think it was Senator Lambie's quote in Parliament recently, there needs to be robust evidence that the person is guilty of misconduct in order to justify a public process. But it's in relation to lesser witnesses, witnesses who might be doing no more than giving circumstantial evidence of the surrounding circumstances in relation to the misconduct. And of course, there is the risk that the mere fact that they are being examined in public will be misunderstood as being a suggestion that they have themselves engaged in misconduct. So that is always a risk that is present, and it's really incumbent upon the Commission when conducting that process to make very clear, and I think there have no doubt been occasions over the history of the Victorian Commission where that has perhaps not been made clear, that their conduct is not under investigation and their reputation is not in issue. But that should be capable of being addressed with each witness that is called.
Yes, but Commissioner, my question goes to this. The unreasonable damaging of a person's reputation, safety or well-being would have been considered before the public hearing had been was agreed to or decided.
Correct.
So,
correct.
But having had the public hearing, in hindsight, has there been occasions where the person's reputation, safety or well-being was in fact affected?
If we're speaking about the persons of interest who warranted the investigation and the public hearing, the answer to that is no. What I meant by my previous answer was there will be a coterie of witnesses who have to give evidence about the conduct, whose conduct itself is not in issue, where it's important that it's made clear that they're not under investigation.
But surely that can be clarified by a statement at the beginning of their evidence, where you can simply say, well, this witness is coming here not because their conduct is under question, but because they're able to assist us. And is that the practice?
Correct.
That's not my question.
Correct.
I don't think that was the question.
That wasn't my question. So anyway,
No,
I appreciate your answer, but that wasn't my question.
I took it as a question about have we had experience of a decision made to have a public hearing on the basis that there'd be no unreasonable damage to reputation, and then it turns out that there was damage to reputation?
Right.
No, the answer is no, I haven't had that experience.
Okay.
Thank you.
Thank you.
And there's one further question, I think, Mr Redlich from Mr O'Brien.
Yeah, just so I can understand this. The challenges that you're talking about, the litigation, relate mainly to publications at the end of an inquiry, is that right?
Correct.
So they're not challenges that are... Sorry.
Yeah, I'm sorry. In the very early days of the Commission, there was a litigation which went, I think, to the High Court in relation to whether or not the exceptional circumstance requirement could be met, or whether the conduct was systemic or serious. But almost all of the litigation relates to the reporting stage of the investigation.
So typically the litigation doesn't frustrate the operation of the inquiry.
No, that's not correct. The general experience is that's not so.
So those reports would be reporting on non-criminal matters, is that right?
Oh, reporting on anything. The obligation in relation to natural justice is that one must identify the adverse comments and opinions that are being expressed. They have to be supported in the draft report by the adverse material which justifies them. That gives rise to litigation.
So a report could accompany a brief to the prosecution to charge someone, is that right?
Under the IBAC Act, we are precluded from either saying in a report that any person is engaged in corrupt conduct, nor are we permitted to say in a report that we would recommend prosecution. So the report remains silent about any conclusion we reach about the ultimate issue. I note that the bill presents a different position on that issue, and I have nothing to say one way or the other on that, beyond the fact that, plainly enough, if the Commission's reached the view that someone has not engaged in corrupt conduct, if it were able to do so, it would be desirable that it makes that clear in any published report.
That's all from me, thanks.
Thank you. Thank you very much, Mr. Redlich, for your attendance here today. If you've been, I think you were asked for some additional information or that you were going to consider. If you could forward that to the Secretary within 5 days from today, you will also be sent a copy of the transcript of your evidence and will have the opportunity to request corrections to transcription errors. Again, thank you for the significant time you've given us today. We very much appreciate it, and the frankness with which you have dealt with the questions before you. So thank you very much, and I will now ask Commissioner Vanstone. We will devote our next hour to you, and thank you for your patience in waiting. I now invite, if you do you have a brief opening statement that you would like to make before we proceed?
I thought it might be helpful.
Thank you very much.
Thank you. I wanted to say something in 30 seconds about myself, just my background. After a brief period in private practice, general private practice, I became a prosecutor. I was a prosecutor for 15 years, first in the office of the Crown Prosecutor, and then when the office of the Director of Public Prosecutions was established, in that office I was Deputy Crown Prosecutor, the Deputy Crown Prosecutor, and Deputy DPP for a total of 6 years. I then went, and during that time I took silk. I then went to the independent bar where I practiced for 5 years, mostly doing criminal work and mostly defence work. I was then appointed at a reasonably young age to the District Court where I worked for 3 years. I was appointed by the Liberal government, the then Liberal government, and then 3 years later I was promoted to the Supreme Court by the then Labor government. After 19 years on the bench in all, I retired ahead of my retiring age and was retired for over a year, and I've been in my current job as Commissioner of the Independent Commission Against Corruption for just over 2 years. So that's what I wanted to say about me. I just wanted to make a few very brief points about the South Australian ICAC, if I can call it that. It was established by the Act in 2012, so it's now just over 9 years old. The Commission cannot now receive complaints. It can only investigate complaints and reports referred to it by the Office for Public Integrity. That office used to be responsible to me, but after last year's major amendments, it is no longer. We can investigate potential corruption, and that's defined in a very narrow band of offences. I might mention those because it's notable that they do not include what one would naturally think are corruption offences such as embezzlement, theft, deception and the like. We can investigate potential bribery, threats of reprisals against public officers, abuse of public office, demanding benefits on the basis of public office, offences relating to appointment to public office, a few offences against the Public Sector Honesty and Accountability Act, most of which are summary, but they're things like duty to exercise care and diligence, failing to act honestly, acting in the face of a conflict of interest and the like. Offences against the Lobbyist Act, but that's largely irrelevant, and complicity of those offences I mentioned. So we're solely offence-based, which I think singles us out from any other commission in Australia. The offences which we formally could investigate were all offences, but as I say, those amendments last year reduced those. We can no longer commence an investigation on our own initiative. We do not and never have had public hearings. Our investigations are carried out in private, and if we have hearings, then those are carried out in private. We cannot make findings of corruption. We simply prepare a brief of evidence if I take the view that there is a strong case that an offence has been committed. Of course, we don't prosecute. All I can do with that brief is now give it to the police for them to potentially further investigate and potentially refer to the Director of Public Prosecutions. I can no longer make a public statement about corruption investigations unless it's to apologise for having undertaken them or for something that happened in them. I can publish reports to Parliament still, but the circumstances in which I can do that are much narrowed since the amendments last year. And that narrowing affects my prevention function as well as the investigation function. In the course of the debate over the NAC bill, in the media there's been much information put about by those who should or do know better. A person under investigation for misconduct, not corruption, Chief Superintendent Barr, took his life some time ago. Any loss of life in such circumstances, of course, is a tragedy. That's the only suicide or attempted suicide that I know of, but one is too many. But he was not the subject of public hearings. It was not known in the public that he was under investigation for misconduct and maladministration. So he was not publicly besmirched in any way. He was not ultimately cleared of all misconduct or maladministration by a report compiled before his death. That is quite wrong. He was not exonerated either before his death or after, as has been claimed. The committee might realise that all this happened before my appointment, and I've had to consult records to see exactly what happened. But Counsel Assisting told the previous Commissioner that it was open to him to make findings against Mr Barr, but ultimately, due to Mr Barr's death, the Commissioner did not deal with those allegations. There were findings against one or more others made, misconduct findings, but not Mr Barr. I would add that Mr Barr had the support of his wife and family, and of course there was no embargo on him telling his wife and family that he was under investigation or that he was giving evidence or whatever. He was also under the assistance and care of a police psychologist. Of course, as I said, it's a tragedy, but I pose the question, what flows from this tragic outcome? And the same for outcomes in other jurisdictions where there have been tragic outcomes. Does that mean that the matter should not have been investigated? I mean, I've seen in my time in the courts, two suicides which were closely linked to me in a sense. One was a client who I'd never met, who was charged with a historic matter. He committed suicide. Another one was a man who pleaded guilty to murder before me. He committed suicide having made his submissions, and he committed suicide in custody. I mean, these are dreadful events, but what flows from it? We must do everything we can to support people who are under investigation and under immense stress. And of course, anyone who appears in court and who's publicly charged with offences, undergoes a trial perhaps, or undergoes a plea of guilty and makes submissions, these people are under immense stress, and we should do all we can to help them. But it doesn't mean that we shouldn't have investigated what they did, obviously. It's self-evident. So those are the only... sorry, there's a couple more matters. In discussing outcomes in South Australia and elsewhere, there's been a tendency in the media to speak of reputations being trashed by ICAC investigations or the investigations of similar bodies. As I said, when a matter goes to court, there will, in South Australia, be an impact on reputation. ICAC investigations are no different from police investigations in that respect, that there will be that impact. Of course, ours are in private, so there's not that general damage to reputation until a matter gets to court. And of course, when one of our matters gets to court, it generally attracts more publicity than the ordinary person who is charged with offences. So it's a corollary of the criminal justice system, which is carried out in public and must be. It's a corollary that there is this damage to reputation, and that is so even if that person is not convicted ultimately at trial. So there's a further tendency in some quarters to speak of persons being exonerated if they are acquitted at trial. Of course, that is not how the criminal justice system works. People are either found guilty or not guilty. If they're found guilty, it's because the jury or the judge or the magistrate has been convinced beyond reasonable doubt of their guilt. If they're acquitted, it means that the judge has not reached that conviction. It doesn't mean that they didn't commit the crime. It doesn't mean that the judge or jury thought they'd most probably committed the crime. There's no room to draw from an acquittal that someone was not guilty of that crime, that they were innocent of that crime. When a matter has gone to court in South Australia, we've had talk of botched trials, botched investigations, but if one of our matters has reached a trial and reached the stage where the tribunal determines what the verdict is, then that means that we have sent a brief to the Director of Public Prosecutions, as it used to be, and now to the police, and the Director has determined that there are reasonable prospects of conviction and that it's in the public interest to prosecute. That's the prosecution test, and it's common form across Australia. So there's that. Then the matter goes to the magistrate's court. If it's to go on to a superior court, the magistrate will not send it up unless the magistrate has found a case to answer. So in the vast majority of cases that reach the superior court, the magistrate has found a case to answer. If the matter gets all the way to the jury or the judge for a verdict, then that means that the judge has found a case to answer. So even if the matter doesn't result in a conviction, ultimately, those various thresholds have been met. And if that's the case, then it seems to me to be hard to say that that investigation should never have taken place and that prosecution should never have occurred. There's also been a tendency to talk about matters not reaching a conviction as being attributable to a vexatious complaint. I can say from my experience, as I said, just over 2 years, that vexatious complaints to integrity agencies are rare. I have seen what I think is one. In fact, it concerned a Member of Parliament, but that's the only one that I could identify. They're extremely rare. So those are my opening remarks, and of course I'm happy to take questions on those matters or any others.
Thank you very much, Commissioner. I think you've raised some very difficult issues, and we appreciate the way in which that you have raised those and taken the members of the committee through, clearly the distinctions of exoneration and innocence and not guilty. I think that is certainly important, and we appreciate the frankness with which you have spoken about some of the pressures that your commission, or the public comment that has been about some past cases of your commission. And I think it's important that we acknowledge what you have said and carefully, there are people who are affected by this, and I again appreciate the way in which you have spoken about it. Can I ask you, myself, there have recently been significant reforms to the legislation, as you have talked about. One was to split maladministration and misconduct issues from corruption investigations and leave these matters for the Ombudsman. And the South Australian model now leaves only serious corruption, as you've talked about. Do you think this goes too far? And should non-criminal conduct that may nevertheless constitute serious or systemic corruption be within the NAC's jurisdiction, in your opinion?
Yes, Madam Chair, you've called them reforms. I don't think of them in that way. You'll understand.
Changes.
Changes, yes. I was always aware that our policy committee had intended to recommend that misconduct and maladministration be taken from us and given to the Ombudsman. And my attitude to that from the time I took up the position was that it was ill-advised, but I wasn't terribly worried about it, remembering that we are an offence-based corruption jurisdiction. I think I told the policy committee early on that I thought, and I certainly told the then Attorney-General, that I thought it was ill-advised because there might be occasions when it would be appropriate for me to investigate particular instances of misconduct or maladministration. But I said, as a general rule, I would not want to do that. And in fact, I did never opened a misconduct or maladministration investigation in that year or so when I had that opportunity. So I think it would have been better if we still had that jurisdiction, but it's not as important as some of the other changes that were made. Of course, the NAC Bill defines corruption much more widely. Our corruption need not be serious and systemic. It merely needs to be potential corruption in terms of one of those offences that I mentioned. But where the definition of corruption goes beyond offences, as in the NAC Bill, then certainly, of course, it needs to be able to examine all those instances of corruption. So it's such a different system, it's hard to draw anything from ours.
And you've certainly drawn to our attention that the South Australian system doesn't have public hearings. Are there circumstances where you think there should be public hearings? That's a hard question, I guess, a hypothetical. And are you concerned that, for instance, that you have no exceptional circumstances pathway to holding public hearings, as is the proposal in the NAC legislation?
As long as our corruption is defined in terms of offences, I would not wish to have public hearings, because we are effectively an investigation agency investigating potential offences so that they might be prosecuted. So I would not wish to have public hearings.
So, exactly. So what you're saying is you are getting this ready for the DPP or the police, as you say, to prosecute, and so you don't want to prejudice the prosecution.
That's right.
Is that
That's right.
so?
That's
It
right.
is not just looking at corruption that might not constitute an offence. This is
That's
totally offence based.
As
You're
the-
not allowed to look at
You're not allowed to look at it. Yeah.
No, that's right. As the legislation was before, I think it would have been advantageous to have the possibility of public hearings. Before the changes, we could have had a misconduct or maladministration investigation using the powers of the Royal Commission, Royal Commissioner under our Royal Commissions Act. And if that type of investigation had been in the sense of an expose about something that had happened, a bit like a Royal Commission looking back at something, then I think it would have been useful to have public hearings, certainly for the benefit of the public to understand what had gone on in that particular episode, and also in terms of education, as Mr Redlich mentioned before. But that's water under the bridge. It will never happen.
Thank you. Senator Shoebridge?
Oh, thanks, Chair, and thanks, Commissioner Vanson, for your attendance today. And I acknowledge that the job you signed up for changed substantially midway through, and that must have been a challenging process.
It certainly did, yes. But can I just say that my staff are sensational people, and we have regrouped and continued on a path that I think I had embarked on once I started, which was putting more emphasis on prevention and our investigations informing prevention. And I was pleased to see the Commonwealth Attorney mention, I think at the Press Club recently, that he sees that as a really important part of the NAC, that investigations won't always lead to prosecution, of course, but they will inform prevention outcomes.
Yeah.
So we have gone further down that path, and I think we're doing very important work in that regard.
Now, much of the discussion and concerns about ICAC hearings relate to procedural fairness. So I thought I would give you the opportunity, have you read the submission by Mr. Pangello, I think? Pangello?
Yes, I have.
And he makes a number of statements critical of yourself in that.
He does.
And then he's critical of you, being critical of... he's critical of some of your comments that you've made.
Comments he's attributed
He's
to me,
attributed
yes.
to you, correct.
Yes.
What I want to do is give you the opportunity, if you'd like to take it,
Thank you.
to clarify anything on the record there.
Thank you. Well, I've already addressed, looking at page 2 of his letter, I've already addressed this concept of failed investigations and careers and livelihoods destroyed by the secretive process. I mean, one can't have it both ways. It's hard to see how a secretive process destroys reputations, but...
And indeed, as I understood it, at least from the South Australian ICAC's position, in relation to the police officer where there was the tragic circumstances, the investigation did not exonerate and did not clear that officer in question. Is that right?
Well, that's right. Mr Lander drew short of ever making any findings. Although senior counsel assisting had recommended them, he decided that in the circumstances he should not go ahead and make any findings. So we'll never know what the ultimate outcome would have been. So that was one matter that concerned police. But there's another one which Mr Pangello speaks about. And I think when he's talking about persons who had their careers and livelihoods destroyed, he's also talking about a situation where police were charged with offences of taking seized property. And that matter went to trial, and indeed it went to verdict. So what I said earlier about that applies to that, in the sense that it had met those hurdles to get it there. Can we really say that it should never have happened just because it resulted in mostly acquittals, but I think at least one hung.
Yeah, none of them were
verdict.
no build. There was enough evidence to go to the jury or go
Absolutely,
to... Yep.
yes, that's right, that's right. Then he says that victims of ICAC investigations which found no wrongdoing had nowhere to turn because the ICAC Act prevented them from discussing the investigation with anyone, from family members to medical professionals and lawyers. Well, that's simply wrong. They were always permitted under our confidentiality provisions to discuss those matters with just those people. It's Section 54, and that was always the position. And as I
Can I
mentioned,
just ask a follow-up question just on that little point there?
by all means.
Go for it.
Is that possible? We've had a discussion or testimony earlier in the week about, in relation to the draft NAC bill, about whether or not someone who's the subject of inquiry can make a disclosure to a mental health professional, whether or not they have to actually make an application to the Commissioner under this draft bill before they can do that. What's the position just in terms of that? Just, you talked about the confidentiality provisions.
Yes.
Do they actually have to make an application
No,
in
no.
South Australia, or as
No.
of right they can do that?
they were statutory exceptions to the confidentiality provisions. An exception to obtain legal advice, to obtain medical or psychological assistance, an exception allowing a person to advise their employer, a person advising business partners or others, and in relation to a workers' compensation claim, and to disclose to a close family member, which included a spouse, parent, grandparent, brother, sister, guardian, carer.
Okay,
So
thank you.
Standing exceptions.
Thank you.
And that's never caused any difficulty?
No,
Yep.
no. Then Mr Pangallo goes on to say that I advised one person that they could not discuss their matter with him, thereby attempting to override the right of parliamentary privilege. For all my powers, I don't think I have that one. But that's not true. Mrs Barr asked me for a further exemption to the confidentiality provisions, Mr Lander having already given her a couple. I was concerned that reports that she had in her possession, firstly Counsel Assisting's submissions, which Mr Barr had been given, she had been given, they'd been received after his death, and also the final report, would find their way into the public arena. So that was what I was trying to prevent. Of course, she would have been covered by parliamentary privilege in simply discussing the matter with him and putting forward her grievances. So that wasn't the issue at all. I was concerned that there was going to be more that would flow from that. In hindsight, I think it would have been good for ICAC if those reports had found their way into the public arena, but it would have been very bad for the other people who were mentioned in those reports. So,
And in fact, that's often a difficult balancing concern if you've had private hearings about how it's released and the
That's
way in
right.
which you're protecting other third parties, perhaps at the reputation of the ICAC in that situation.
that's right, and that's the whole purpose of the confidentiality provisions, yes. He goes on to say that I'm appointed by the Parliament. I was actually appointed by the Governor, of course, but that's neither here nor there. He goes on to say that members of Parliament had been subjected to unprecedented attacks and a concerted media strategy by the current and former Commissioner in a bid to pressure the Parliament to reverse many of the reforms that passed unanimously a year ago. I'm just not sure what he's talking about there. I think at the time, and just before and just after the amendments went through, or the bill was presented, I gave 2 radio interviews at the request of members of the media in Adelaide. I believe Mr Lander gave one as well, but I'm not sure what he really was saying there. He goes on to say...
But I think, stopping you there, Commissioner, I think
Yes.
you were clearly critical of the changes,
Of
weren't
course.
you? I think you
And-
described the jurisdiction of having been decimated by
Yes,
the changes. You are
which
unquestionably critical.
Absolutely, but I mean that's not a political statement. I mean, I saw my position as a public officer and as the leader of the ICAC as a person in a unique position to say what effect I saw these changes having. And I think it would have been a dereliction of my duty not to put forward my opinion. I'd never had the chance to discuss these changes because, of course, the bill was prepared without reference to me.
Well, I think silence would have been very odd and almost certainly would have had you subject of other criticism had you remained silent in the circumstances.
Yes. But certainly I was critical, absolutely, but I deny that I politicised the debate or I played politics or whatever else political activism. I deny that. Then Mr Pangallo said it was inferred in a radio interview that he was corrupt in drawing up the legislation because it would protect corrupt MPs and corrupt police officers. Well, I don't know what inference he drew. I don't exactly know what I said on which he's based that, but certainly the overall impact of the changes, in my view, is to weaken the protections against corruption in public life in South Australia, and that's where we rest. He goes on to say that there's nothing in our system which stops a proper investigation taking place. Well, I don't want to labour the committee with endless detail about our system because it's so far from the NAC bill, but there are restrictions, as I said, on what we can investigate, and there are penalties, if you like, if those matters go to court and the offences which the subject person faces are not corruption offences as defined. A person could go to trial, be convicted, go to jail for deception or embezzlement and get all his costs back under our system. So I think there are difficulties in our system now. He talks about suicides, attempted suicides and other mental health issues. Well, as I've said, I know of only one and one is too many, but I don't know of the others. I'd be pleased to know if there were others, and there may be lessons that we could learn if there were. He talks about how it's preferable for us not to be able to brief the Director of Public Prosecutions directly. Well, I can tell you as a prosecutor, it is essential to directly brief the Director of Public Prosecutions. From my time as a prosecutor, I always had a police officer sitting behind me for the whole trial, an investigator who could continually give me his insights about what was happening in the trial, about the investigation, about why it had taken a certain turn. That could never be done by someone to whom the brief had been given, who'd read it and handed it on.
Or to deal with requisitions and the like that need to be done directly.
Now that process is, the DPP asks the police for something, the police ask us. We say, well, what about this though? We've already given you this. So that goes back to the police, and the police say, well, look, they've already given you this, and it's just endless time wasting and inefficient. So that's hopeless. He goes on to say that a right to a defence of an accusation of an offence, that is to know what offence you're accused of committing, that somehow was there under the old system. I just simply don't understand that. And he said there was an alarming pattern, a common thread in all these matters of an integrity agency accused of operating without integrity. Well, in my 2 years, 2 months, there's never been a complaint about me or any of the ICAC officers. There were complaints about the Office for Public Integrity, usually that they were not assessing something as potential corruption or misconduct, but there have been no complaints about us. And the court has never criticised us for any use of our powers. And then he goes on, there are many. Shall I go through the whole list?
I think, Commissioner, only address those things that you think are material. And if there's anything else you think is material.
Yes. Well, I think I've answered the criticisms of myself personally. Mr Pangello warns this committee that this legislation should not be rushed through. I think that's highly ironic since...
It does seem a little ironic.
24 hours was enough in South
context.
Australia, so yes, that's ironic.
Commissioner, look, I
won't.
really want to thank you for the answers, and I've appreciated your time.
Thank you for the opportunity to answer that question.
Thank you, Commissioner. Mr O'Brien?
Thank you, Chair. Thank you very much for attending and giving evidence. And my queries are more broad. I don't want to go into the detail of any matters that have been before you or before the Commission in South Australia, as I don't want people to draw any incorrect inference about a person who can no longer defend themselves. Generally speaking, the extraordinary coercive powers of a crime commission, which have the consequence of abrogating fundamental rights and privileges, and I speak mainly about those coercive powers for questioning and attending an inquiry that aren't normally applied to general people.
Yes, that's really the only difference, I think, between our powers and police powers, the power to have a hearing and demand answers.
I was a policeman in a former life, and I've been in that situation where I've been compelled to attend and answer questions, which is a process that police and other agencies that operate in that environment go through. And it's a process that you learn about at the academy. You have it reinforced that these possible elements of your job can arise regularly. But regardless of all of that, and when you are innocent, a witness, or somebody that's not the subject person, being forced or having to answer questions is an extremely stressful experience. My view is that you feel more like a criminal than you do an innocent person because of it. If you don't attend, you'll be arrested. So the obvious consequence of having this, being subject to this, is that you are in the grasp of the government. And as I said, people in law enforcement understand that. Do you see, with the National Anti-Crime Commission having such a broader jurisdiction into the public service, and general public servants who would never ever think for a moment that they could be compelled and brought before an inquiry, and if they don't, they'll be subject to, if they refuse, they'll be potentially subject to imprisonment. Do you think what's your view in educating those public servants around what's coming their way?
Well, I would expect the vast majority of interactions between NAC officers and public officers would be conversations, person to person or over the telephone, either at a neutral place or in an ICAC or NAC office. Most of them won't ever be subject to compulsory examination. That will be a rarity. Not just because of the exceptional circumstances test, but because when one is trying to gain evidence, one wants the cooperation of a witness. And so the way to get that is not to put them under undue pressure, but to build up a rapport with them as an investigator and to encourage them to be frank. So those coercive powers will usually not be used. Now, if it's a person who's a subject of the investigation, then of course they might be used. But as I say, I would expect that to be the rarity rather than commonplace. So I don't think there's any need for particular education to public officers about that. What I think is important is that public officers should have confidence in the NAC once it's established, and that will be done by the way it conducts itself and its education programs and its communications to the public. I think that will encourage public officers that the NAC is a good thing and a good resort for them to have.
Oh, thanks. I'm really interested and I appreciate your answer. I think the experience of other commissions is that people are drawn into the investigations as witnesses. And as I reiterate the point, I don't want to labour on it, but and as we've heard from commissioners today, investigations do extend to coercive powers do extend to witnesses.
Yes, they do.
And quite regularly do.
Well, certainly I've experience of that. Generally, I don't allow my investigators to set the wheels in motion for a coercive hearing, unless there's a good indication that the witness won't speak to us without one. And there have been occasions where that's happened. But generally, they will speak to us. And they're happy to speak to us. And of course, when they're summoned to appear in a private hearing, they come with their lawyer, of course, or other support person, and they're briefed in advance about what will happen, how long they're expected to be there. They may be given some indication of the particular subject matter. They usually know already, but that's the case. And they'll generally be given a liaison person as well who they can speak to, get information about the process and so forth, and then contact later if they have any questions. So I don't think that the persons who I have examined have gone away with great misgivings about what's happened. And there haven't been many of them, I might say, but I have no reason to apprehend that they left in a scarred manner or anything like that.
That's all from me, Chair.
Thank you. Dr Haynes?
Thank you, Chair. Thank you very much, Commissioner Vanstone, for your testimony this morning, and appreciate your frankness with us today. Could I ask you to comment on the constitution of the statutory Joint Oversight Committee that will be put in place once the National Anti-Corruption Commission is stood up, and your views around that committee having a government chair with a casting vote, which can determine sign off on commissioners to the NAC, for example, if you think your views on that?
Well, of course, I was appointed by the recommendation of the Attorney to the government, and our Statutory Officers Committee approved my appointment. So I'm not in a position to claim that there should be some sort of different mechanism whereby the government is denied the opportunity of appointing a commissioner. I suspect in the long run it wouldn't make much difference, frankly. I think there are a small band of people in Australia who will be attracted to the work of integrity agencies and will have the requisite experience and knowledge. And I suspect that, as I said, in the long run it won't make much difference which route is taken. They'll pick themselves in effect.
Do you have a view on the appointment of a commissioner who is a former politician, for example?
I think it would depend very much on the other qualities of that person and the other experience that person might have had.
Thank you.
What about not just the nature of the individual? And obviously there may well be people who can rise above all of those concerns. What about the public perception and the public perception of not just, actual impartiality, but no apprehension of bias? What about public perception?
Well, if there is a public perception that an inappropriate candidate has been chosen, I guess that will play out in the usual way.
But shouldn't we create legislation that does everything we can to minimise a perception of bias and to take those problems away from a future NAC? And one of those ways would be saying, well, this is, and we're not talking about your model in South Australia, but this is a model that's looking at politicians. Politicians shouldn't be chairing it.
I'm not too fussed about that. I think that's a political matter. I think that will be as it will. I don't think I can add usefully to that.
Commissioner, given that we're in the business here now of establishing a National Anti-Corruption Commission with the primary aim of stamping out corruption and preventing corruption, could you tell me, the South Australian ICAC, does it stamp out corruption and prevent corruption in its current form?
Well, I believe it does. It's very hard to measure where corruption has been stamped out. That's the trouble. I think around the country we're all trying to work out how it can be better measured, and we can say, well, look, this is what we've done. But yes, I think we constantly inform agencies of where they're going wrong and why complaints and reports have arisen and why there are perceptions that there's been potential corruption or misconduct or maladministration. So they generally react, as I said earlier, favourably to our recommendations, and they strengthen their processes and change them. So I think we often get back letters that say we've made these changes, and they're significant changes that we see. So I think we are having an impact, but it is difficult to measure.
Recently, you commented after the changes were made to the South Australian ICAC that those changes had shattered the integrity landscape in South Australia. So given that you've just told me you think it's effective in stamping out corruption, what did you mean by shattering integrity?
Well, thank you for that question. I'm pleased to answer that particularly because what I meant was that before the changes, as I mentioned, the Office for Public Integrity, the clearinghouse for all complaints and reports, was responsible to me. So we would see all those reports and complaints come in, probably 2,500, 3,000 a year, and they would go into our database. They would be assessed by the Office for Public Integrity, and they would go into our database, and then they would be dealt with. They'd be given to me if corruption. We'd send them off to the Ombudsman or to the agency or the police or whatever. So all that intelligence was amassed over a period of 8 years. And that's a fantastic resource for an integrity agency. It can inform all one's work. For instance, it can help to decide whether we'll investigate a particular allegation of corruption or we won't, or send it off to the police, or we'll evaluate that agency if there have been repeated complaints and reports about that agency. We might launch an evaluation which is a very close look at all the practices and policies and procedures of a particular agency, and a substantial report produced at the end of it. So all that intelligence informs not just investigations but our other functions as well, our education function. We can see where more education is needed than in other areas. So that's what I meant by shattering, because all that data, that information, intelligence, is now gone from us. All I see now are the referrals of potential corruption that come from the Office for Public Integrity. I don't see all the other complaints and reports. That's a huge deficit that I think has weakened our regime markedly. And that's what I meant by shattering, or I think I've also used the word fracturing the integrity landscape. That's what I mean by that.
Thank you very much.
And could I just say, in reading the NAC bill, and I haven't read it thoroughly, but it's not clear to me that the NAC will have all that data that we used to have. And I think that's terribly important, that the NAC have access to police systems, access to the Ombudsman's systems, and as much information as possible to help it inform its activities. Perhaps it's my lack of understanding, perhaps that'll be dealt with in regulations, I'm not sure, but I think that's very important.
Thank you. Mr Lim?
Thanks, Chair. Commissioner, thank you for joining us. Commissioner, you have spoken about suicide. does the South Australia ICAC provide legal or financial assistance for anyone appearing at the Commission, and not just the party that's subject to adverse outcome to be reimbursed legal fees and associated costs?
No,
I only got one question.
I
That's
see.
it, yeah.
Well, public officers, yes, get legal assistance if they appear before us in a private hearing. They are reimbursed their legal costs, not by us, but by the Crown Solicitor. We don't make adverse findings. I don't make adverse findings, of course. I don't release reports about what we've done in terms of what we've investigated and what findings we've made, although I do report on prevention outcomes to the Parliament. So the answer is yes, they do.
What about a police officer that killed himself? What sort of support the government provide for the family?
Well, I'm afraid I'm not aware of what sort of support was provided to his family. As I mentioned, I wasn't Commissioner at that stage, and moreover, I probably wouldn't have become aware of that anyway. But as I said, he was under the care of a police psychologist. I do know that much, but I can't comment beyond that.
Thank you. No more questions.
Thanks. Mr. Wallahan? Sorry. Ms. Lawrence, go.
I just wanted to ask your comment if you had any views around parliamentary privilege and, how to obviously protect that, but work within that, and whether you have had any experience either since your appointment or what you observed previously to your appointment, where perhaps it created some difficulties with any investigations.
Well, I have. It ultimately has not provided any difficulties for investigations, although there were suggestions that perhaps it would. Over a period, ICAC investigated several politicians for abuse of their allowances, and two of those are currently in the courts, and in one of them, the politician has claimed parliamentary privilege over the claim forms that he submitted, on which basis he was paid his allowance, and that's currently going on appeal to our Court of Appeal. But it didn't really cause any difficulties in the investigation as such, because although originally the Speaker and the President foreshadowed that they might not release documents to us, ultimately they did. In the changes last year, there was an attempt, I think, to strengthen parliamentary privilege, if there's such a thing, to, I think, ring-fence politicians so that we had less opportunity to investigate them. But I think that's contrary to our South Australian Constitution in any event. I mean, parliamentary privilege is what it is, and I wouldn't seek to go behind it.
And just with respect to journalists and protecting their sources, what is your process for securing a warrant in relation to journalists' material in particular? And if you have any view on the proposed wording in our bill in relation to that?
I did see that in the NAC. We don't have any particular protection for journalists against disclosure of their sources. So the protection that's given in the NAC is something additional that I hadn't seen. Not that it surprises me, but I don't have a firm view on that. It's one thing to not require a journalist to disclose his source in a hearing. It's another thing, though, I think, to provide some sort of protection against documents that are seized from his house or his office or so forth. That's a step further, which I wouldn't have thought would be necessary, but That's really a political question. I don't think I can help that much on it.
And are warrants, the process for securing a warrant, is that necessary to go through to a person with judicial qualification, or is it a lower bar?
I have the ability to issue warrants in a number of circumstances.
Oh, you can do it yourself?
I can. The view I've taken is that I won't do that unless it's a matter of extreme urgency, which forecludes an application to the Supreme Court. So I think last financial year I did not issue any warrants, but we sought 15 or so from the Supreme Court. I take that view because it's a protection in a sense. It's a good discipline for the investigators and our legal officers to prepare a warrant application, and then if there's ever a question about whether it should have been granted, then that question lies with the Supreme Court, not with me. So it's an attitude I've taken that if we have the time to do it, and we generally do, then we should go to the Supreme Court.
Thank you. And just one last one. You mentioned that your recommendations in your reports are not published. Is that the case?
I can publish reports in limited circumstances to the Parliament, and then once they're tabled, then they can be published at large. But referring to reports that are of general interest, it's under our section 42. There are significant changes to that section, such that, for instance, I can't prepare a report that includes any finding or suggestion of criminal or civil liability, and no finding that would constitute a criminal offence or civil wrong. So I can't suggest that anyone's done anything wrong. Now, if I can't suggest that in a section 42 report, then it's a bit hard to say, well, you need to fix this. I mean, normally one would say...
Do you feel then, on reflecting on our bill, where we must, the Commissioner must report where they have a finding or an opinion, do you feel that that's a potential then safeguard in terms of demonstrating accountability of the Commission?
Yes, I think those sections are very helpful. Section 149. So every corruption investigation will give rise to a report, as I understand it, under section 149.
Yes.
And I think that's very helpful.
And sorry, do you feel that that requirement, particularly where perhaps the hearing was held in private, goes to the same elements of trying to assure the public and instill confidence in the Commission that it's doing its work without necessarily having heard, witnessed themselves a public hearing of the evidence?
Yes,
but
I do.
the report in itself is being published.
Yes.
Achieves the same result?
Yes, I do. I think that's very sensible with respect. And as you mention it, you're quite right, of course, it's the obligation arises only where there's been a public examination. I wonder, though, whether I could just veer to a different direction with that question, because there was something I thought I might mention in relation to that obligation on the Commissioner, if I might. There will be some investigations where a brief of evidence will be sent to the Director of Public Prosecutions and may well result in charges, and those charges will go to the courts, and it might take years for them to be determined, and ultimately there might be an acquittal. Now, in that circumstance, should the Commissioner still be obliged to prepare a report with his findings? He might want to, of course. He might think that it's important that he do so, but perhaps if he's made a finding of corruption, he might not want to publish it if the court has has led to an acquittal.
So the timing, in the event of a criminal prosecution is underway, or whether as a consequence
That's right,
of the outcome...
the two aspects. He might want to hold back on that report.
So there could be exceptions at times where the Commissioner may deem it more prudent to not publish.
Exactly.
It's not in the public
or
interest.
a redacted report, or extract those findings. So that's right, the two issues with respect. Firstly, he might want to hold back on that report to let the criminal proceedings play out, and I don't think he can under this section. And secondly, he might want to redact his original report much later if there's an acquittal and it's impliedly different from what he found himself.
Excellent. Very much appreciate that insight. Thank you.
I think when there's an obligation like Section 149 on a public officer, such as a commissioner, I think the law is that he should do it with all convenient speed. And the criminal justice system doesn't allow for all convenient speed.
Thank you. Mr. Wallahan?
Thank you, Commissioner. Putting your prosecutor hat back on in your previous life, and perhaps your judicial hat, I'm just curious about the interaction between the NAC or any corruption commission and the criminal justice system. Is that interaction between prosecutors and the NAC one that's only spelt out in the legislation, or is it one that's also governed by maybe a memorandum of understanding?
Well, certainly in our jurisdiction, our full court has said that one doesn't need a particular power in order to brief the DPP. The RSPCA can hand a brief of evidence to the DPP if it wants to. So there's no need for it to be spelt out, and I don't think it is spelt out in the NAC bill. There's no memorandum of understanding between the DPP and us, or indeed between the police and us now. I don't think it's necessary because we understand what a prosecuting agency would want. Indeed, that's one of the things that I sought to refine when I took up my office, the way we present our briefs.
Because we heard from the Australian Federal Police, and they said that they have a memorandum of understanding with ACLEI. They also have one with the Parliament for privilege, and I think they made the point that they would expect to draft one with the NAC as well.
It can't hurt, can it? I mean, I wouldn't argue against it.
And again, putting your prosecutor's or judicial hat back on, are there considerations in public hearings that have consequences for the criminal justice process that are not present in private hearings?
That are not present in
private hearings?
Private hearings.
Or is there a risk in public hearings that is not present in private hearings?
Well, yes. That's one of the reasons why, as my legislation stands, I would never want to have a public hearing, because witnesses who might ultimately give evidence at trial should not, in my view, be heard publicly beforehand as a matter of best practice. So the jury should hear first from them. That's not always the case, of course, and that can happen. They might have given evidence in an inquest or whatever, but that's the way I would see it. If the matter is going down that track, to me it's much better that it's all done in private. And my own practice has been, and it's not one that I'm obliged to stay with, but my own practice has been that I don't have a hearing of a subject person, the person who's accused of corruption. I don't have a compulsory hearing for such a person. I don't see the point.
And this committee is looking at a bill that has the option of private or public, and the bill as drafted has some discretionary considerations. Do you think the impact on a criminal trial should be one of those discretions to consider?
I think it is one, is it not?
No.
It's not?
It's not.
Well, it would be, I think, irrespective of whether it's a consideration that's mentioned in the Act. It would definitely be one which would weigh with the Commissioner, I would think.
It's a non-exhaustive list.
Yes.
And then, again, your various experiences, where there are public hearings, if we know there are benefits in public hearings, everyone accepts that, but could one way to mitigate the harm that comes with a public hearing be that you have one, but with all of the court-like rules of evidence, the rights that you have, the burdens and standards of proof? What would that look like if you were to have a corruption commission that said, well, we really need to have a public hearing, but I'm going to give you back some of those court-like protections that we took away? What would that look like?
Well, that doesn't appeal to me, I must say. To have a sort of mock court, in a sense, a quasi-court set up outside the judicial system, I don't really see the point of it. I mean, corruption commissions investigate matters that police generally don't or can't investigate. They need to get to the bottom of allegations. They need to have the tools that the NAC is going to be given by the look of it. They need those tools. They need robust powers and jurisdiction. And I don't think building in the sort of protections which someone would ultimately get if they were prosecuted into the NAC process would be advisable. I think that would just weigh it down, lead to disputation and litigation along the way.
We put in place these corruption commissions because those traditional measures, the courts and the police, have been unable to track down corruption. So just simply replicating them would be relatively pointless, wouldn't it?
I think that's right. I mean, the privilege against self-incrimination, of course, it's a very important privilege in court, but it's right that it shouldn't be present in the hearing, a private hearing particularly, of an integrity agency. The agency must be able to get to the bottom of what's happened and get the evidence which can then lead to other lines of inquiry. And that material will never be used against that person in a court. So that's an important protection of itself.
And just to be clear, I was only suggesting for a public hearing. I wasn't suggesting for private hearings that those rights be returned.
Yes. I think what I say applies to both with respect.
And then finally, the observation was made by my colleague Senator Shoebridge, I can't remember who to, but that we should look at this provision assuming the worst Attorney General or the worst politician, not the best. And I think whoever it was agreed with that. And then that principle makes sense. But that applies across the board, isn't it? We should have that in mind when we're considering the enormous powers for a commissioner, an inspector, or anyone else. Would you agree with that?
Yes, I do, but I don't think you should assume the worst. I think there are fundamental prerequisites that should be, hallmarks, if you like, that an integrity agency should have, and then having given it those tools, it should be allowed to get on with its work. I don't see that there's a need to assume a worst possible outcome or worst possible characters being involved.
No further questions, Chair.
Thanks. Mr Zappi, you've got a short question.
Thank you, Chair, and thank you, Commissioner Vanstone, for appearing before the committee. I just have two very brief matters to raise with you. The first is the changes to the South Australian legislation. Have they taken effect as far as your work is concerned?
Yes, very much so, apart from those that remain unproclaimed.
Since when? Since when have you been
Since the 7th of October last year.
Okay. 7th of October last year.
Yes.
I thought the changes to the... Yep, okay, okay. No. My second question relates to the discretion to commence investigations. On what basis are investigations commenced, and who has that discretion? Is that something you have, and can you commence an investigation?
Yes, well, with respect, that's an important point. It's one of the aspects of our Act which I think is good, and it's always been this. The Office for Public Integrity is to assess all complaints and reports. If they assess one as potential corruption, then it's referred to ICAC, and we decide whether to accept it or not. So, first of all, there must be that assessment as potential corruption, not a case to answer, not any higher test than that, but just potential corruption, and then I can either investigate it myself or send it to the police, or if I disagree with the assessment, I can send it back and suggest it be reassessed. So that means we don't need to have preliminary investigations to get to a certain threshold. We can just investigate, and then if there's nothing there, we can just stop.
Perhaps just for my benefit or the committee's benefit, can you initiate an investigation?
I used to be able to until 7th of October last year, but I can no longer. And I think that's a really important tool that the NAC is to have and should have. And I can give an example if it's helpful.
Yep.
The Federal Police give us information from time to time, and it's very sensitive information. In fact, it's often so sensitive that only a handful of people, even within ICAC, have access to that information. They have expressed the view on occasions that they don't want to send it to the Office of Public Integrity now that it's not under my control. It's outside my control, and they don't want to send that information there. So that's created problems. They would just like to send it straight to me and to have me decide whether to investigate. And there are other sources of that ilk.
So, and this will be my last question. If a matter was raised with you that you believe ought to be investigated, but you cannot initiate it, is there a process by which you would then follow through or try and follow up on that matter?
Yes, I could make my own report to the Office for Public Integrity and suggest that they send it back to me, assess it as potential corruption and send it back to me. And that has happened. From within ICAC, we have come across information which we think should be investigated as potential corruption, and we've gone in that circle. I mean, it's crazy, but we do it.
Thank you. Thank you, Chair.
Thank you very much. Thank you for your attendance, Commissioner Vanstone, here today. I think you might have been asked to provide additional information. If you have been, would you please forward it to the Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Again, thank you very much for your attendance and your evidence. We appreciate it. I now would like to welcome Ms. Cathy Cato, the Executive Director, Legal and Integrity from the Victorian Inspectorate, and also Mr. John Hoytick, former CEO of the ACT Integrity Commission. Just for your information, John McKechnie will join us at about 12:30, so I'll have to speak to him at that time. For the Hansard, could you please state your full names and capacity in which you appear before the committee? Ms. Cato, do you want to start? You're on mute, I think.
Apologies. Cathy Cato, Executive Director, Legal and Integrity, Victorian Inspectorate.
Mr. Hoytick? Do you want to state your name? Can you state your name and the capacity in which you're here? I don't think he heard me. Mr. Hoytick, can you state your name for the transcript and also the capacity in which you appear? He's not hearing me. Hands up, I don't know what we do. Yeah, well, I'll continue on. Can we just check? We can't, I don't think he's hearing me at all. Is he or not?
Mr. Hoytnick, can you hear us?
Can you hear us? Mr. Hoytnick? No, can't hear us, so I don't know what we're doing. We'll call him, but I heard that we can hear you, but he can't hear us, I don't think. All right. I will continue. So for both of you, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Ms. Cato, did you want to make a brief opening statement before we go to discussion?
I'm happy to go straight to discussion. Thank you.
Thank you. Mr. Hoytick, can you hear us now? No. All right. Well, then we're going to ask some questions and see.
Can't we?
No, sorry, what I just said is the WA Commission is coming at 12:30, so I'm proceeding with the rest of the matter with these two because we are running behind time, so I'll put him in at the time, okay? So he will be here. Is there anybody else?
Actually, it's John Gooding calling from the...
Okay. We're just calling him, okay. Should we wait or we proceed? Wait 2 seconds. You might have to be on the phone and then on the video. That's probably where we're going to have to go. Don't know who's calling, but somebody's calling.
That fan's quite hypnotic.
Yeah, it is. Just go to sleep. You're feeling tired. Yeah. We can hear him, but he can't hear us. Yeah. No. I think he'll have to be on the phone to hear us. But then we'll need a phone here, won't we?
No, we've got Chorus Call.
Chorus call, okay.
It's always got the WebEx phone number.
Yeah, okay. So, Mr. Hoyte, can you hear us now? I don't think so. I think we should start because we could... I think we... So we might put Mr. Hoyting on the phone, I think, is what we're proposing. Okie dokie. Can I ask who wants to start? Thank you. Senator Scarr will direct some questions to you, Ms. Cato, while we're...
Hello, Ms. Cato, can you hear me?
Yes, I can, thank you.
Excellent, excellent. In the first instance, can I just thank the Victorian Inspectorate on behalf of the committee for their submission, which raised a difference between the Victorian regime in relation to inspector powers and the proposed regime under the NAC bill. Could you just in summary outline what that distinction is as you saw it?
Yes, certainly. Look, in the role of the proposed inspector under the NAC bill is limited to detecting corrupt conduct within and relating to the NAC, investigations into NAC corruption issues, and investigating complaints. I think the key difference in the oversight that we have is a monitoring role, a live monitoring role. The NAC bill doesn't provide any monitoring or auditing role for the inspector that can ensure compliance of laws in real time, and there is no requirement to notify the inspector when coercive powers are exercised.
Okay, so from your perspective, just if from a practical perspective you can give this committee an appreciation of what that monitoring/audit function of the inspector, as the inspector operates in a Victorian context, what that looks like from a practical perspective in terms of that day-to-day oversight function.
Yes, I think it's pointed out by a couple of other of the key submissions before you, particularly Bruce McClintock and the Law Council of Australia, this importance of real-time oversight. It is particularly important with respect to, let's use an example of a public hearing. So every time coercive powers are exercised by IBAC in Victoria, they have to notify the Victorian Inspectorate, and we can then, as resources allow, we can review the exercise of the power and review the report relating to why it's appropriate to exercise that power. And we can then provide feedback. And that's particularly important when there's a public hearing. So, for example, we have to be provided notice of that public hearing 10 days prior, written reasons for the public hearing, and we can then give feedback about that, test out those reasons. So that's a very clean example of when it's important.
So
and what
you-
it enables people...
Sorry.
No, apologise. You go.
So you don't have to wait for a complaint to be made.
Correct.
In order to intervene, if I can use that word, in relation to a real-time process that's occurring. Is that correct?
That's right. Waiting for a complaint can cause the issue to have already bolted. So, you know, the power is already exercised and there's a problem with the exercise of that power, whether intended or not, and it's usually unintended. It's too late to try and address it when the complaint comes, for the most part. And that's particularly so in the case of a public hearing where if it impacts on someone's reputation, safety or well-being, that's already occurred and you can't take that back. The reputation is damaged and no complaint later can change the events.
So the inspector has more proactive powers, if I can put it that way, in a Victorian context, than reactive powers.
Yes, it's an influencing role at the time of the exercise of the power. And for most of the time, it's just done behind the scenes with conversations or correspondence between the parties.
Okay, excellent. I want to ask you a question in relation to who has oversight of the exercise of the inspector's coercive powers. So there was did you hear the evidence given earlier in the day?
I've been informed of it, thank you.
Oh, you have been. Okay. So one of the issues that was raised by the Victorian Commissioner and Ms Vanstone from a South Australian connection, both submitted to this committee, and I'm paraphrasing them, so hopefully I'm doing justice to their argument as I understood it, that it is important that an entity, whatever that entity is, have some sort of oversight of the inspector's powers if the inspector is to have the power to actually investigate, for example, as it does under the NAC bill, any corruption that might be the subject of a complaint within the NAC. I'm just wondering what your thoughts are in that regard and how that works in practice in the Victorian context.
Yeah, it's a very interesting issue, and I guess there's always going to be that who oversights the oversight, and it keeps on going. Can it stop at any point? I think we would have no objection in principle to the concept of any agency that exercises coercive powers having some level of oversight of those powers. In Victoria, there is a parliamentary committee that does oversight the general operation of the Victorian Inspectorate. There are 4 yearly performance audits that look at how we undertake all of our functions, including our exercise of powers. And we have also reporting obligations about our frequency of exercise of the powers.
Okay. I want to ask you...
Senator, can I just check? Mr Hoyte, can you hear us now? Yes, thank you. Excellent, thank you.
Yes, I can. Apologies for that.
That's okay, fine. Thank you.
Excellent. Ms Cato, I just want to ask you a question about resourcing in terms of the resources the inspector has in a Victorian context. And I note your title is Executive Director, Legal and Integrity, Victorian Inspectorate. So presumably that's your full-time job, is that correct?
Yes, it is.
Okay, and I can see one fetching red lounge in the background with a yellow pillow, but I can't see any wider in the office to see how many other desks and staff members there are lurking in the corners. But how big is the complement in a Victorian Inspectorate context?
Yeah, the Victorian Inspectorate, before I go into the size of it, I just need to explain the breadth of its role. We don't just oversight IBAC, we actually oversight 13 agencies.
Right, okay.
So we're a standing statutory agency with an independent inspector and a full office. We are, I think at the moment, about 27 staff.
And how much, so how much of your time, and this is going to be a very imprecise process, how much of your time as an agency or how much of your resources as an agency would be dedicated in terms of the oversight function in relation to IBAC? Is it 20%, 40%?
It'd be closer to 40%. It
40%.
takes up a
Okay.
large part of what we do. But I would just be very clear that our agency also, because we're fully budget independent, we run like a department would. So we have to run all of our corporate side as well, running buildings, etc. So there is that sort of corporate element. The actual operational staffing is smaller than you would otherwise expect.
Okay, thank you. So thank you for that. That was very useful. Mr. Hoytink, I just want to ask you a few quick questions. And firstly, I just want to ascertain, you're the former CEO. In the NAC bill, there's a distinction made between the Commissioner and, I forget what term is used, sort of the Managing Director of Operations of NAC. So there's a distinction between the management of the day-to-day, presumably human resources issues, etc., in a NAC context as opposed to the Commissioner sort of issues. The role of CEO in the ACT Integrity Commission, that would be equivalent to which position in a NAC context?
Well, much the same as what the CEO is within the bill, is basically looking after the day-to-day running of the organisation, which would be everything from HR, strategic processes, making sure policies and processes were aligned and reviewed and benchmarked.
Okay, understood. So the one area I'm interested in your thoughts in relation to, before I go back to you, Chair, is just in relation to the budget process in an ACT context. So presumably you would have had a key role in that context in terms of the budget, formulation of the budget and going through the process, whatever it was in the ACT, to get that budget approved. What was the process in the ACT context?
When I started with the ACT Commission, there had already been a budget approved, and basically I was the only employee from day one. So it was a matter of essentially standing up the commission from scratch. So there was a budget in place, but it was a methodology was essentially looking at what the commission needed, what we needed as far as resources were concerned. On top of that, there was also the development of policies and procedures, and the fact that 6 weeks after I actually signed up, the commission was required to be operational. So it was a very, I suppose, an intense period. As far as the budget process was concerned, as we have, or as the commission, I say that as a past CEO, as the agency matured, it was then a matter of looking at what the resources were and then going through the normal budgetary processes within the ACT to obtain additional funds for things like additional staff, for additional software, case management, and all those other things that are required to set up an agency.
So was there anything different about the budget process for the Integrity Commission in the ACT as opposed to the budget process for other departments? Was there any special consideration given to the fact that of the independence of the Commission and the importance of its work in that regard?
We basically fell underneath the Chief Minister's instructions as the Treasurer as to how the budget processes were, or how it was obtained. No, there was no difference. We put in our bids the same as all the other agencies.
Okay, all right. Okay, thank you, Chair.
Thank you. Mr Zapier?
Thank you, Chair. And, thank you to both of you for appearing before the committee. Look, I have one question, and I wouldn't mind a response from both of you on it. Looking at the legislation that this committee is now looking at, are there any glaring concerns you have with the structure of the legislation? And I'm sure that there's many, what I would describe as minor changes that could be made, but do you see, or do you envisage from your experiences, any glaring problems with the legislation that is being put to the Federal Parliament? Mr Hoytnik, perhaps if you want to go first.
There's no, I suppose, glaring issues that I would see with the legislation. It's much the same as the legislation I've worked with previously in New South Wales at ICAC and also within the ACT Integrity Commission. As with a lot of legislation, and this is what occurred in the ACT, is there were a number of amendments. Once the actual legislation was in place, and we actually started to work with the legislation, it was then a matter of going back to government saying there is a number of things which we have seen as we have now operationalised this process that have not met the mark. So there has been amendments sought afterwards, and I will say, I think from memory, there is over 40 amendments that have been sought to the ACT process because of the fact that they have been discovered as the agency has matured and the processes have matured. The difference here, of course, is that we have the ACLE to leverage off. But certainly, as it currently stands, I see no glaring issues. A couple of minor issues, but nothing that would prevent the operation of the NAC.
Thank you. Ms Cato?
Thank you for the question. In terms of the role of the inspector under the bill, I do reinforce the need for the monitoring of compliance in real time. I think in respect of the idea of corruption investigations being a key role of the inspector, I would endorse what Bruce McClintock has said about that, which is that would be very rare for there to be an actual corruption investigation of the anti-corruption body. However, there may be a broader range of complaints, and I think the more specificity is required in the bill as to the scope of the inspector's complaints function. There is a role for complaints for the Commonwealth Ombudsman with administrative action, and there is an unspecified role for the inspector, which can end up meaning that a lot of time could be spent on responding to complaints that relate to issues perhaps that are more staff grievances or things that are really not what was intended by the bill. I think those two are important. Another key factor is around the public hearings, and that is that we consider that a threshold for public hearings is important. A public hearing has the potential to impact on people's reputation, and that can often be in a quite unintended way, and it is irreversible. Once information is out in the public domain and picked up by the media, that person has no recourse to sort of rebuild that reputation, and sometimes it is not even a person of interest or a key person of interest who is impacted. We therefore think that unreasonable damage to a person's reputation, safety or well-being needs to be a mandatory consideration before a public hearing is considered appropriate. That's the key, really the key consideration, yeah.
You make that point in paragraph 10 of your submission. Yep.
Yes, we do.
Yep.
As to the exceptional circumstances test, if there are three other threshold requirements considered, which I'll go into, we don't think it's necessary. And those three are a public interest test,
Yep.
that the conduct is serious and systemic, and that the unreasonable damage to reputation, safety and wellbeing are considered. But they're not just considered, they must be considered, not in the may category where they are now.
Thank you for that. Thank you, Chair.
Thank you. Dr Haynes?
Yes, thank you to both of you for your appearance today. Mr Hoytnick, given your experience in establishing an anti-corruption commission from the ground up, could you comment on the adequacy of resourcing, particularly in the establishment phase where it's, I imagine, extremely important to establish public trust and the kind of resources that are required to get going and get going well? If you've had a chance to look at the budget allocation to the National Anti-Corruption Commission, I don't know, are you in a position to make some comment about that, about the budgetary adequacy?
I would say, correct me if I'm wrong, it's 262 million over 4 years is what's actually been put forward. As far as that is concerned, the use of ACLE obviously will be a lot of leveraging, or give us a lot of leveraging in relation to the establishment of the commission. But I think there also needs to be consideration of how much work is actually required to stand this up, and how much policy development needs to actually occur. As far as whether that is sufficient, it certainly seems to be a sufficient amount at this stage, and I say that very much because of the fact that I haven't or I'm not aware of how far ACLI have actually gone in relation to the establishment of new policies and procedures. But when I look at the current remit of ACLI and the fact that they look at law enforcement integrity agencies law enforcement agencies, and I look at the vast range of additional government departments, there is going to have to be a lot of work in relation to establishing contacts and policies, processes and MOUs with all those different agencies, which will require a substantial amount of people to actually be there to actually get this up and running properly from day one. I suppose from my perspective, what I would not like to see is the fact that when the NAC does open its doors, that it's still chasing its tail, trying to make sure that there's sufficient bodies or sufficient policies and processes in place to make sure that it works effectively.
Could you give us your considered view around, I guess, the Attorney General has indicated that it's his desire to have this commission established by the middle of next year. Is 6 months an adequate time to get all of those things together, in your view?
If there was sufficient people to assist in that process, I note in the ACLI submission that they said they would need to undertake significant recruiting to meet the requirements of the Act. So if there was sufficient people there to assist, it may be possible. Again, that comes down to the commitment of, or actually getting the right people. I mean, the labour market right across Australia at the moment is screaming for people, and qualified people to come along and work in various industries. And certainly oversight, governance and law enforcement is not immune from that particular phenomenon. So yes, if there was sufficient people, possibly.
Could I ask you, in your experience in dealing with the ACT government and getting the kind of budget that you required, could you speak to the, knowing that of course every department or government body would be seeking funds that may be in excess of what they truly need, but what was your experience in dealing with government, and could you make some comment about the budgetary oversight that the ACT government gave to requests from the Anti-Corruption Commission, and how that relates to the NAC?
Well, certainly one of the things which was unfortunately overlooked within the ACT legislation was the access to telecommunications interception, which is essential to how oversight and law enforcement agencies conduct their work. As part of that process, we went back to ACT government while I was the CEO and put in a submission in relation to getting the resourcing to actually undertake that particular process, which is ongoing. So certainly the interaction was that we needed to go back and seek additional funding. Some of that was considered and provided in the main. There's additional resourcing, I think, which needs to continue in relation to an agency which is very much developing. And that's one of the things as far as the budget process is concerned is if you have experienced people sitting in the roles and they say we need more money to do X, Y and Z, bearing in mind there is a lot of restrictions about what can actually be said if there are ongoing investigations. But I suppose having some faith in the people who you put in those positions and to say that they need more funding or a different way of doing business to understand that experience it's not said lightly. So certainly my experience was that they certainly listened in the main, provided the funding that was required.
Based on what you see in the National Anti-Corruption Commission legislation, and I'm not sure if you heard the Victorian IBAC Commissioner's witness this morning around...
I was on in the background, yes.
Yes. His submission also indicated that a separate tribunal for funding was a recommendation from him. What would your view be of such a tribunal for the National Anti-Corruption Commission?
Well, I think Commissioner Redlick's comments, I certainly endorse them. I think there's a requirement for a National Anti-Corruption Commission or any commission to be independent and to actually be free of government or from the bureaucrats, and I say that with all due respect, of the actual budget process. I know when I was working in New South Wales, there was some tension, shall I say, between the Commission and the budget process and how it was actually monitored, and the fact that essentially it was bureaucrats who could well be under investigation or parts of their departments being under investigation. that it should really be an independent process. Certainly, as Commissioner Redlich has said, having a tribunal who was able to consider the funding, I think would be a far more beneficial methodology.
Okay, thank you very much, Mr Toyton.
Thank you. Senator Chandler.
Thank you very much, Chair, and thanks to the witnesses for coming along today. I only have questions for Ms Cato about the Victorian Inspectorate submission. I note that you have in your submission a number of the benefits of the notification framework that is in place under the Victorian system. Could you just give a bit of a summary of the differences between your notification system and anything that exists under the NACC framework?
Yes, the problem with the NACC framework as we see it is that there is no notification process at all. And in fact, there's no monitoring or auditing process. So all that it has is it's a complaint function and an investigation function, which is all after the event. So it doesn't allow for any access of the inspector to the information, that would help ensure compliance with the law.
Yeah, and again, from your submission, I understand that IBAC is required to notify the inspectorate in Victoria when they're using coercive powers.
Yes, that's right.
So how does this happen in practice?
So within 3 days of the exercise of that power, they are notified to us, via an electronic link, and a report is provided along with the actual instrument itself so that we can review both the report and the instrument.
Sorry, Ms Cato, can you just repeat that last sentence? I think there's a bit of paper shuffling somewhere along the line and I can't hear quite clearly enough.
Sure. Within 3 days of the power being exercised, for example, the summons to a witness being issued, we are provided with a copy of that along with a report explaining the purpose of the exercise of that power.
And when you're reviewing that, what are you looking for?
So we're looking for its relevance to the investigation itself and its compliance with all of the very strict requirements set out in the legislation for exercising that power, and they're many and varied. So we have a checklist of up to 4 or 5 pages for each instrument that we go through and just check off that all the important factors have been considered. And a lot of that is about ensuring that the witnesses' rights are being protected. Mm-hmm. They're being, informed of everything that they should have been informed. Is it an enforceable notice? Or it's a long list of important factors.
Yeah, and if you were to find that the instrument or the purpose for which it had been drawn up wasn't compliant, what action occurs after that?
So we have a relationship with IBAC where we provide feedback on those that we review, which will not be all of them because that would be far too much of a resource. But of those that we review, we provide very quick feedback on just administrative errors. They might be missing dates and things like that, but we also provide feedback as quickly as possible on any errors or flaws in the instrument. We also review the examinations. So the actual hearings that take place, we can review those and we can look at whether or not questions are relevant, are questions being asked appropriately, and we can provide feedback to IBAC on that. And that can allow them to adjust how they approach what they do next.
So, sorry, do you only review a sample of the instances where coercive powers are used?
Yes.
Oh, so it's not part of the course every single time.
No, we simply don't have the resources to do that. As an agency, we receive over 1,000 a year, so we can't review every single one. So we go through a triage process to enable us to identify the most risky ones that we would look at first.
I see.
Yeah.
I see.
But a lot of
Sorry, you go.
No, I was going to say that. You just have to use your resources appropriately to get the most effective and the most high risk matters looked at.
Yeah, and so is that, I mean, I think you've alluded to this, but it's somewhat of an iterative process, right? In that if you're identifying sort of systemic issues with how those powers are being utilised, then you would provide that feedback to IBAC and then they learn and...
That's right.
Yeah.
Very much so.
Yeah. And so do you think we should be looking at a similar function to this for the NACC?
Yeah, I think that it has a lot of benefits.
Mm-hmm.
Could I just jump in there, if you don't mind? Certainly, as far in my experience within both the ACT Commission and the New South Wales ICAC, there was a monthly reporting process where every single use of a coercive power was actually reported to the inspector, to the ombudsman. So it was a very regular, there were regular meetings between those officers on a regular basis, and everything that was basically a coercive power, including the notices and the reasons for the issue, were provided to the inspector. And I see that particular level of transparency is essential to how the NAC would do its business.
And how did you close the loop in that feedback once that information was provided to the inspector? Was there feedback then provided back to the Integrity Commission?
Yeah, it certainly was, and certainly from the ACT perspective, it was a new thing and actually setting it up. But once now the process is actually in place, once it's actually supplied to the inspector, they look at it, they review it. If they have any feedback as to, for example, the use of a particular power or the wording, they would certainly give that back to the Commission. And if it was considered suitable, it would be added into any future use of that particular coercive powder. It was a very the relationship was very good, and certainly that's exactly the same within New South Wales.
Do the inspectorates in any of these jurisdictions have a process of ensuring that the feedback that they have provided has been actioned by the Commission in question?
Sorry, Claire. I think.
No, you go, John.
As far as that's concerned, yes, certainly there's ongoing discussion between myself and the inspector, and they would expect that any recommendations that they or things that they have put in, if it's certainly in the view of the Commissioner worthy of including, it would be included. And if it wasn't, there would be reasons given for why it wasn't.
Yeah. And in Victoria, Ms. Cato?
Yeah, it's a similar approach.
Great. Thank you very much. That's all from me, Chair.
Thank you. Can I also now welcome the Honourable John McKechnie, KC, Corruption and Crime Commissioner for Western Australia, who's joined us, and who's to give evidence today. For the Hansard record, would you just please state your name, your full name and capacity in which you appear before the committee? I don't think you can hear us. Blissfully unaware, okay. I think we might have another problem then. Houston, we have a problem. We might... I think there might be a sound problem. So can you hear us, Commissioner McKechnie, can you hear us? Nope. Okay, all right. Ms. Lawrence, I think you have a question for Mr. Hoytick. Would you like to make that?
John McKechnie, Commissioner, Corruption and Crime Commission, Western Australia.
Thank you. Sorry. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Did you want to make an opening statement before we proceed for discussion, or would you just like us to go to discussion?
Corruption and Crime Commission.
Commissioner,
We haven't succeeded already, have we?
Can you hear us again? Hello, Commissioner, can you hear us? I don't know.
Shall I just kick off with the other question?
Why don't you ask Mr. Hoytick your question, and we better be in contact with you.
Thank you.
I'm happy to make a brief opening statement.
Okay,
I just want to know whether you can hear this because there was a delay before.
We can hear you now, thank you. As we were concerned whether you could hear us, but we can hear you. If you would like to make a brief statement, that'd be great.
There seems to be a delay between...
It takes time to get to...
3 hour time, is it?
3 hour time.
It's a long way.
I'm feeling from Mr McKechnie.
Okay.
What's going on, Sarge?
Yeah, good question.
What's going on? Yes, I can hear you, but there seems to be a big delay.
Yes.
Yeah, there does seem to be a delay, but do you want to give us your opening statement?
Get somebody get this fixed.
Yeah, that's my man. That's it.
He's going to
Hey,
have
you
to
what?
get on WebEx, get rid of it.
Where's our
That's the only way.
Should be over here.
Could we just ask him again, give his statement? Or is
Thank you. I'm not sure that we've solved the communication problem.
Commissioner, we can hear you if you were able to
Got a
begin.
delay.
Do you want to, can you give us your opening statement or your brief statement now?
I think we have communication problems that we need to sort out, unfortunately.
All right, fair enough. Well, then what we might go to our plan B, which Ms Lawrence, would you like to ask your question of Mr Hoytick?
Sure. Thank you. So thank you very much for appearing today. Mr Hoytink, if I've said that correctly. Hoytink, my pardon.
Hoytink, yes.
I'm just interested in your experience when you were CEO. So the bill as proposed deals quite clearly with the appointment process. And in the unfortunate circumstance of the CEO's position needing to be terminated, the Governor-General needs to just determine that. But unlike with the role of the Commissioner, it's not necessarily on the recommendation of the Minister, and it's silent on the advice from the Commissioner, his or herself. And I just wanted to see if you had a view as to whether there needed to be a stronger mechanism in there to enable, if relationships were to break down between the Commissioner and the CEO, whether there needs to be another mechanism that the Minister could advise the Governor-General to terminate that appointment, or whether you feel it's enough, and perhaps under the direction of the Commissioner, the CEO would just read the mood of the room and decide to move on.
Certainly reading the mood of the room is required, but if there was another avenue of negotiation, certainly, or that the Minister could utilise, certainly I think that's worthwhile. I'm not sure exactly what that mechanism would be, whether that's something that would go to, for example, the Oversight Committee or something like that they would have some sort of input into it for consideration is a possibility.
Thank you. And was there a particular mechanism within the ACT Act that you can recall?
My recollection was it was essentially the Commissioner who made the decision.
I see. Thank you very much.
Thank you. Now, I think we've lost Commissioner McKechnie. It's going to fix it. Okay. Are there any other questions of Ms Cato or Mr Hoytink? I think we can let you go rather than wait. So unless I don't think there's going to be anything that arises. So look, thank you very much for your attendance today. I don't think you have been asked to provide any additional information, but if I'm wrong about that, would you please forward it to the Secretary within 5 days from today? You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. So again, thank you very much, and we appreciate you sharing your experience and your suggestions for how we can improve the NAC Act. So thank you very much.
Thank you.
Thank you, Madam Chair.
I think we might suspend this for... yep, I think we suspend this meeting for a few minutes while we await Commissioner McKechnie, and we might
We're
Thank you.
contacting him, are we?
Yep,
Is that
they're
how it's
working
going?
on it. Okay. Can I just speak about... We can hear you now, so hopefully you can hear us and there's not a time delay. Is that, can you hear us? Commissioner? Hello, Commissioner, can you hear us? Commissioner, we could hear, Commissioner, we could hear you, but can you hear us? Commissioner, can you hear us? I don't know. I don't think it's been fixed at their end.
Tell us just saying it's possible just to ring his office.
Yeah.
At least we can communicate whilst we're trying.
Yeah. Can you just ring? Can we ring him?
Yeah, Kate's on the phone to his office.
Kate's on the phone. Okay, thanks.
We've also given him the chorus call numbers.
Okay.
So he can just phone in.
Okay, so it might be that we just get to the chorus call numbers. I don't even think it's going in delay at the moment.
IT training for NAC commissioners, you got the bill.
Oh, someone else. This is the third person we've seen.
I was going to skip today.
Are we? Oh, that's all right. Okay. You'll miss out on my story.
Come for your story.
All right, Commissioner, I think we have discharged the other two witnesses, so it's just you. And I think we were asking you to. You said you want to make a brief opening statement. So did you want to do that now?
Yes, I do, and thank you very much for the opportunity to comment. It's extremely important for a trading nation like Australia to have the confidence of its trading partners, and that's why an Integrity Commission is, in my view, essential. I listened to Anne Vanstone KC and her opening statement and really have nothing to add to that. I agree with everything she said. So I just want in a couple of minutes to raise some issues which may or may not have been debated. There's sometimes a flavour of blaming the Integrity Agency for what Parliament has in fact created. And an integrity agency is part of what Justice Spiegelman described as the integrity branch of government. My own view is that constitutionally it's too early to know where integrity agencies actually fit. And so that is why we are having a range of opinions about their efficacy. They're partly in the executive, they have coercive powers, but they also have to accord procedural fairness in a way similar to a court. They do not have the power to make binding declarations of right, as a court does, nor to adjudge guilt or innocence in a criminal trial. Yet, an integrity agency does have the power to affect change and to affect reputation. We are different from royal commissions from whom we sprung in that, and this is an essential power which NAC has and which South Australia does not. But a NAC must have the power to make their own propositions, to investigate on their own motion. That, to me, is an important power. Running with it, as NAC also provides, is the need to have intelligence. And again, I agree with Anne Vanstone that a form of intelligence, a form of data, are the allegations which are made, many of which will turn out to have little substance, others of which cannot be investigated for practical reasons, but they provide enormously useful data as to the health of the public sector. There are a couple of issues which have been raised which I may as well comment on, but no doubt the committee will have questions about. And the first is public hearings. Our approach is we are cautious in having public hearings, but there are times when we think they are essential. And we tend to use them a bit more in a different way from other jurisdictions to an extent, I suspect, in that especially if there is a corruption prevention and education function as there is in NAC, public examinations of persons not directly accused of misconduct can be very beneficial. To take a recent case in Western Australia, where as a result of Commission's activities and working cooperatively with the police, a gigantic public sector fraud was uncovered that raised some $22 million directly and a further $5 million in bribes. The person concerned is now serving a lengthy period of imprisonment. But we conducted public examinations of the executive of the department concerned to find out what went wrong, how the corruption was not uncovered for 10 years, and then not by the agency either, and what lessons can be learned. So there's a very valuable public education in public examinations. I pause to say that those public examinations probably would not meet the exceptional powers necessary or the exceptional test necessary currently in NAC. My view, that's a break. There are very good reasons for public examinations in appropriate circumstances. Two other quick questions, then I'll finish, or quick issues. One is inspectors. I don't believe any jurisdiction actually has the balance correct because an inspector is not like a court of appeal. And as a judge for 16 years, I was well acquainted with court of appeal decisions, sometimes agreeing with me and sometimes disagreeing. But they have the binding authority to overturn. The relationship between an inspectorate and a commission can on occasions, although I've not personally had this, be quite fraught. And it's important for each to stay in their trend lines. So there's a danger that an inspector might be second-guessing an equally qualified commissioner. That's just something to bear in mind. And the other issue, which applies not only to integrity agencies, but also to courts, to police and the like, is the mental health of witnesses and how best to protect that. We've put in a range of measures over the years to do that. Part of the issue, I think, is that the persons who are subject to corruption investigations, who may be corrupt, have not previously seen themselves as criminal. And it's quite confronting for them when they do. This has nothing to do with the corruption agency, but more to do with what they have done. So those are my opening remarks, Chair, and I'm happy for any questions.
Thank you very much. I've got a couple of questions. The WA Commission has really investigated an extraordinary broad range of alleged or suspected misconduct, ranging from procurement policies to the use of search dogs. To the manner in which controlled drugs are managed in WA, I'm interested in the organisational capacity needed to support investigations in such a broad range of areas, and whether there is a use of experts where needed to upskill your staff to be able to do that.
Well, we certainly will consult experts in a particular area, and capacity is always an issue. Realistically, an agency of our size can conduct between 40 and 60 investigations at any one time.
So do you still have I wasn't clear, do you still have responsibility for educating the public sector about corruption? Or am I right in believing that function stopped in 2015, or did I misunderstand that?
No, you didn't misunderstand, Chair. You're quite correct. In 2014, the General Corruption and Prevention function was passed to the Public Sector Commission. We retain a corruption prevention and education function in relation to police.
Okay, so the public sector commission has taken over that educative function of crime, that part for you. It's probably hard for you to comment on another agency, but do you think that do you think that has been performed well, or do you think it needs to improve, or are there suggestions that you have to us about how that function should be done by NAC?
We're finding some difficulties. In the example that I gave, we were examining in public and issuing reports in relation to the Department of Communities that had a wider implication. And we try and look, when we're assessing whether to take on an investigation, whether it displays some systemic or public sector-wide view. Now, the Public Sector Commission's well placed to deal with that, especially as our definition of minor misconduct, which they cover, is conduct which could lead to dismissal, essentially an industrial matter. But we need the power, and certainly NAC needs the power, to look at things and say, this is what went wrong, and this might be a way to fix it.
Thank you. Mr. Wallahan?
Thank you, Commissioner. Thank you for appearing in, and thank you to your staff for helping us get through the technical issues. If I could refer to the test that is in your Act, is it correct that it's section 139 and then section 140? Am I looking at the right ones?
Yes.
So 139 starts with that examinations to be private unless otherwise ordered, and then 140 goes through the test for public examinations. Do you know off the... sorry, I'll start again. We've compared Victoria and New South Wales in terms of hearing days. So what percentage were private hearings and what percentage were public hearings? And it was about 52% over a period for New South Wales and 27% for Victoria. Do you roughly know your percentage of public versus private hearings?
Not at the moment, although somebody is rapidly scrambling to see if we can answer that, but I would suspect it would be far less.
Far less than both of those, 52 or 27%?
Yes. There is a Court of Appeal decision in about 2013 that says that the exercise of the discretion is more or less an unreviewable exercise because it is weighing up the public interest and taking account of so many factors. It's very hard for a court to second guess that. I take that not as an invitation but as a caution. And so the other thing to bear in mind is that if we're going to issue a report, people get the opportunity for procedural fairness before that report is issued or tabled, so that it's not the be-all and end-all of a private examination that it will always remain private or the facts will always remain private.
Oh, thank you. And then looking at section 140. Can you just tell us what goes through your mind when you're considering that section?
Well, I don't say first. The various things that I think is will this be a good educative experience? Will public sector officers look at our live stream and learn there, but for the grace of God go ours, or wow, we didn't think of that? If that's likely to be, that would be a good thing. If a person is imminently likely to be charged, you wouldn't have a public hearing. And the other thing is the reputation and the exposure of the person. We don't make findings, as I said, so we have to be very careful about people's reputation and mental health. Those are all the factors, and then a decision is made about which reasonable people might disagree at times.
Thank you for that, Commissioner. I have no further questions, but do you mind taking it on notice to provide that percentage of private versus public hearings and just indicate what date range you're using?
Certainly will supply that. And I should say, in sort of a supplementary answer, that I never make the decision, as it were, just sitting in my office. I always have legal advice, and the legal advice always points out the pros and cons.
Thank you, Commissioner. Thank you, Chair.
Thank you. Ms Lawrence?
Thank you very much. I'm interested, given your well-lived experience, it was very publicly played out around the tension between parliamentary privilege and being able to undertake your investigations as per your functions. And I was just wanting to see whether there's any experience or advice there that you might want to share in the context of our bill.
Yes, although what I'm about to say is more practical than legal or theoretical. Firstly, there's no question about public privilege. We, like courts, are bound by Article 9 of the Bill of Rights. And so it's not a problem. We have, since our court case, we have signed a protocol and a memorandum of understanding with the Parliament, with both houses of the Parliament. The difficulty is, in fact, practical and shouldn't be underestimated, because our investigation might seek a whole range of documents, some of which might attract privilege. And so the onus is really then on Parliament or whoever holds the documents to examine all those documents and remove those which are privileged. Now, that's easy to do if you've got a paper file of 100 documents. It's a little bit harder when you have 400,000 electronic emails and documents. And this is a really big practical issue. It was essentially the major issue that we had with Parliament, because in the end, Parliament had, I suspect, to spend a great deal of money and have banks of people just looking at emails and other documents, deciding whether or not they might attract privilege. Then that decision would be made by the Speaker or the Clerk. It's a huge practical issue that the law doesn't really recognise, and that's why protocols are essential, because parliaments are not equipped with the same electronic tools as investigative agencies to do the work. Does that sufficiently answer?
Thank you. And would it be possible to see the MOU you have in place? Would that be something we could be provided?
Certainly.
Thank you very much.
Can I ask a follow-up question?
Sure, Senator Scarr.
Commissioner, it's very interesting, your comments in that regard, because the Senate at the moment has before it a private member's bill in relation to this issue in the context of the Royal Commission that's currently taking place in relation to veteran suicide. And some of the commissioners in that context have expressed frustration practical frustration, if I can put it that way, in terms of what documents they can access that have been part of, for example, Auditor General processes, etc., because of this issue of parliamentary privilege. In looking into that issue, a distinction is drawn in ODGERS, which is the definitive text in terms of Senate practice, at least, in terms of...
I thought that was Evans.
Well, he wrote it. It's called ODGERS, but it could be called Evans, absolutely. A distinction's placed between a commission using documents which are subject to parliamentary privilege to put them on a train of inquiry in relation to a particular matter, as opposed to actually citing them or using the actual substance of the document itself. Is that a distinction which in practice has been meaningful in terms of the issues you've come across in your context?
Well, in the litigation, the President of the Legislative Council against the Corruption and Crime Commission, the trial judge, Justice Hall, ruled that when we receive the documents, they are, quote, used, quotes. So that distinction that you've just said wouldn't apply, because the moment we receive the document, it is used by the Commission.
Okay, that's
even if the Commission doesn't know it has it.
That's very useful. Thank you. Thank you, Commissioner.
Thank you. And Commissioner, I was wondering if you had a view on the process that's set out in the bill for the appointment of the Commissioner, again reflecting on your experience for your renewal of your appointment.
Well, there's a sensitivity in employing a commissioner, because in the worst case scenario, a commission can bring a government down. So you need to be very cautious. I have no particular comment other than, as a mild one, I think a non-renewable term is essential, but I think it should be 7 years, not 5, from my experience. I think 5 is a little too short, 10 is too long, 7 is about right.
Thank you.
Thank you. Dr Haynes?
Thank you very much, Commissioner. My question is around own motion inquiries, and you've said that anti-corruption commissions should have power to initiate inquiries themselves. In fact, you've just told us now how important it is in your jurisdiction. Do you think that the National Anti-Corruption Commission legislation should have an explicit power to do this?
Yes, I think it should be explicit, and it probably should have some threshold. Our own motion power does not. So an allegation is defined that the conduct raises a reasonable suspicion of misconduct. Now, only lawyers can actually deconstruct states of mind into reasonable suspicion, reasonable belief, balance of probabilities and proof beyond reasonable doubt. Ordinary people never think that way. Nevertheless, it is a recognised threshold. There is no such threshold in relation to own motion inquiries, but our practice is that I require considerable evidence, considerable legal advice, and apply a standard that's closer to balance of probabilities before we commence an own motion. So I think a state of mind or a state of fact before the triggering of an own motion would be a wise and useful thing.
And excuse me if I'm not clear about that. Would you be suggesting that that's written into the legislation, or how would you
Yes.
suggest we deal with that? Yeah.
I would write it into the legislation. I'm not going to suggest what the standard should be, but as I say, we have no standard.
Yeah.
And I think that's a potential danger.
Thank you. Commissioner, you mentioned in your opening statements that you have considerable measures for the protection of the mental health of witnesses. Could you just explain to the committee what they are? What does that look like?
Well, at a very practical level, when people are served with a summons, the various mental health and other options are explained to them. They're given brochures of that. When they're giving evidence, we have officers who are not connected with the investigation, just looking after the witness in breaks and so forth. We're considering actually hiring a professional in appropriate cases, a psychologist, to perform that. We give advice as to mental health issues generally. We're very aware, as I'm sure every anti-corruption commissioner is acutely aware, of the stress and strain on ordinary individuals. Even people who've done nothing wrong, there can be few things more unsettling than a commission officer arriving on your doorstep, even if, as in the majority of cases, we just want your information, you're not under any investigation. It's an area we're constantly looking at.
Commissioner, in regard to that, you mentioned that you collect considerable data and that you're constantly looking at education and research and improving the integrity of how you go about your work. Do you collect data around the mental health measures that you put in place for people brought before the Commission?
No, we don't particularly correct that.
Could I also just ask you to comment more broadly about pro-integrity measures, education and research? And I know that you've talked about earlier in this hearing today that some of those functions now have gone from your remit. Are you able to explain to me, please, if what kind of impact that's had on your capacity to create a pro-integrity environment, knowing that we want prevention, and I'm curious to get your reflections on that.
Well, I think we do it in three ways. One, we have a capacity building function, which we exercise. Members of our assessment directorate regularly are in contact with at least major agencies and also with minor agencies, telling them what the trends are, what are the things to look at. Second is the report itself is a significant educative measure. And thirdly, with reports, where appropriate, we've adopted the practice for some years, if we make recommendations of saying, and we'll be back in 12 months to see how you've done with the recommendations. Now, it's a matter for a department whether it accepts a recommendation or not, but it requires the department at least to say, well, we're not going to accept that recommendation for these reasons, but we are going to accept, and we have already done things here. So really, it's also the hidden thing. We do very thorough investigations, and that is well known in the public sector. You don't want us in.
Commissioner, just one final question around those. You going back to check around those recommendations. Is it then in the public forum as to whether departments have indeed chosen to take up those recommendations or in fact not done that?
Yes, we publish it as a supplementary or a second report.
Thank you.
And so this, to give an example, there was a bad case of miscarriage of justice here many years ago in relation to a young Aboriginal boy called Gene Gibson. And we did a thorough investigation of police misconduct, made many recommendations and required them over about 4 or 5 year period to report on the progress of implementing. Now, some of them were very difficult. Finding interpreters in a language to interpret the caution was very difficult for police. They looked at it very carefully before they concluded they couldn't meet that recommendation. So that's an example of how I think it's hugely educative to make recommendations and follow up.
Thank you very much, Commissioner.
Thanks. Mr. Lim?
Commissioner, you recently did a podcast with the CCC discussing the moral dilemma of becoming a whistleblower. What mechanisms are in place in Western Australia to protect whistleblower? In the same podcast, Commissioner, you discussed the fact that whistleblower almost inevitably are reporting on someone who is higher in the organization than they are. Do you feel there are sufficient protection, and particularly for individuals who work for intelligence organization, to be able to come forward with any allegation of corruption and be protected?
Well, our state, as every other state, has whistleblower protection legislation, public interest disclosure legislation. We go to the state, we have been in a state where we will not make a report because a report might expose a whistleblower. We get round things in other ways. But in the end, it takes a great deal of moral courage for a person to inform an allegation on a superior. We also have Section 174 of our Act. An employer who dismisses an employee because they've, as it were, been in contact with the Commission is guilty of a crime carrying imprisonment for 5 years.
Thank you, Commissioner. If you were to decide the design principle to redesign the CCC, what provision and power would you give it to support them to do their job to the best of their ability?
In relation to whistleblowing or generally?
Generally.
Well, I think that the NAC legislation is reasonable, subject to the comments that I made at the beginning. It's an evolution, and it's had the opportunity to take account of the learnings from other anti-integrity agencies. But as I say, I think we as a country are still on a fairly early stages of the journey about integrity agencies, their powers, and where they actually fit.
Thank you, Commissioner. No more questions.
Any other questions, anyone?
Perhaps just one.
Yeah, Mr. Zapier?
Commissioner, just one question, if you care to comment. Could you advise the committee of what you see as the differences between an anti-corruption commission and a royal commission?
Thank you for the question. The first major difference is something we talked about before. A Royal Commission is set up by government to inquire into some particular issue. Either something's gone wrong, there's suspected corruption, or it wants to learn more about a particular issue so it can legislate better. But it's given terms of reference, it's given its mission. A Corruption Commission has no such mandate or mission, but as it were, selects its own targets for investigation. It does that through the receipt of allegations and through own motions. So the big difference is that it chooses its terms of reference. It chooses its mission in a particular case, unlike a Royal Commission. The other thing is, and this is a general comment about both, when I was DPP, I had the results of at least 3 Royal Commissions and came to a sort of rule of thumb that you either have Royal Commissions or you have prosecutions. It's very difficult to do both. So if you have actual criminal behaviour, probably it should be prosecuted. But if you have wide-ranging systemic conduct, corrupt conduct that may not amount to corrupt behaviour, that's an appropriate place for either a Royal Commission or a Corruption Commission.
Thank you very much for that. Thank you. Thank you, Chair.
Thank you. Thank you for your attendance today, Commissioner McKechnie. We really appreciate your perseverance in speaking to us, and we appreciate what you have said to us today about your experience. I think you have been asked to provide some additional information, could you please forward that to us, to the Secretary, within 5 days from today, if possible. You will also be sent a copy of the transcript of your evidence, and will have an opportunity to request corrections to transcription errors. Again, thank you very much for your time. We're going to make an amendment to the program, and so we will adjourn shortly and resume at 2:30. And so we will then hear at 2:30 from the Queensland Law Society, Civil Liberties Australia, and Queensland Council for Civil Liberties. No, just the Queensland the Civil Liberties Australia. At 3:30 we'll hear from Mr. Stoltz and Dr. Stoltz, sorry, at 4 o'clock from the Australian Psychological Association. There will be a short break, and then at 5:15 we will hear from the South Australian Bar and Mr. Pangallo. So I will now, proceedings are now suspended until 2:30. Thank you. I'm now going to welcome, the representatives of the Queensland Law Society, and in the room is representatives from Civil Liberties Australia to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee? I might start with the Civil Liberties Australia representatives in the room. If you just say your full name and your capacity of being here.
Thank you. Dr. Christine Klugman, President, Civil Liberties Australia.
Bill Rawlings, CEO of Civil Liberties Australia.
Thank you. And then on video conference, the Queensland Law Society, can you just announce who's there?
Nerita Saram, I'm the Manager of Legal Policy at the Queensland Law Society.
Hello, I'm Matt Dunn. I'm the General Manager of Advocacy, Governance and Guidance at the Queensland Law Society.
I'm Rebecca Fogarty, the Vice President of the Queensland Law Society.
And I'm Brooke Thompson, a Policy Solicitor at the Queensland Law Society.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite, firstly, the Queensland Law Society to make a brief opening statement, and then I'll ask the Civil Liberties Australia if you want to make a statement too. But over to Queensland Law Society, do you want to make an opening statement?
Thank you. Thank you for inviting the Queensland Law Society to appear today. In opening, we respectfully acknowledge the traditional custodians of the lands on which we are appearing from, that is Meanjin, Brisbane. We recognise the country north and south of the Brisbane River as the home of both the Turrbal and Yagara nations, and pay deep respects to all elders past, present and emerging. The Queensland Law Society is the peak professional body for the state's 13,000 solicitors. We are an independent, apolitical representative body upon which government and parliament can rely to provide advice which promotes good, evidence-based law and policy. Our submission is informed by our experience in the Queensland context with bodies such as the Crime and Corruption Commission and matters including that of Logan City Council. We acknowledge that simply because something is done in a certain way in one jurisdiction, it does not follow that it should be replicated in another. Our submission supports the Law Council's submission, the Law Council of Australia, particularly in relation to legal professional privilege, the privilege against self-incrimination, and the right to judicial review. In our submission, we focus on two distinct issues. First, the default setting should be that hearings are held in private, except under exceptional circumstances, and where the Commissioner must take into account the list of factors set out in Clause 73, subsection 3. Secondly, the terminology corruption of any other kind in Clause 8, subsection 1, subsection E, should be deleted on the basis that it is vague and uncertain. The definition of a corruption issue should not include whether a person will engage in corrupt conduct, as contemplated in Clause 9, subsection 1, subsection C. And while the Commission should be appropriately empowered to investigate conspiracy or attempts to engage in corruption, we consider that capturing future corrupt conduct in the meaning of a corruption issue is ambiguous and not the most efficient use of the Commission's resources. I'm joined today by Mr Matthew Dunn, Ms Benari de Saram and Dr Brooke Thompson, and we are happy to take any questions. Thank you.
Thank you. Civil Liberties Australia, have you got any, did you want to make an opening statement?
Yes, thank you, Chair. Thank you very much for the opportunity. And may I commend the committee secretariat on managing this consultation in such short-term notice. I think they've done extraordinarily well. Civil Liberties Australia believes that the aim of a genuinely independent national NAC, Anti-Corruption Commission, is to ensure that the executive, ministers, members of parliament and the bureaucracy govern and act for everyone, and they act lawfully and in compliance with standards and norms of ethical behaviour when spending our money and acting on our behalf. CLA would support a NAC that meets 4 key criteria: that the Commission is truly independent, with a capacity to receive complaints from whistleblowers and conduct its own investigations without interference of executive government; that corrupt conduct is corrupt conduct, and the definition should be the same for everybody covered in this legislation; that the definition of corruption in public institutions to be investigated by the NAC includes all of those that they are corrupted by, including members of the private sector; that as sunlight is the best disinfectant, all hearings before the NAC should be conducted in public, and the outcomes of every investigation publicly available unless the Commission issues reasonable public reasoning as to why this is not the case. CLA acknowledges that these criteria are broadly consistent with the Beechworth Principles released by the member for Indi in 2020, and that with the exception of criteria 4, are largely covered by the explanatory material released by the Attorney-General. The NAC will be part of a national infrastructure and will hold to account politicians particularly, and heavies at the big end of town by comparison with citizens. CLA believes that there is a similar power imbalance between politicians, the bureaucracy and citizens at the bottom end of town, which needs to be addressed by a Federal Human Rights Act, which would form an equally important part of the infrastructure to a National Anti-Corruption Commission. The NAC deals with specific instances of power imbalance, and the Federal Human Rights Act deals with the power imbalance between individuals and government generally. Thank you.
Thank you. Senator Scarr.
Thank you. I've got some questions first for Civil Liberties Australia, and then I want to put some questions to the Queensland Law Society, of which I used to be a member, I should say. So we don't have representatives from the Queensland Council for Civil Liberties, which in my home state of Queensland has been at the forefront in terms of civil liberties, and we're talking pre-Fitzgerald inquiry, etc., etc. So even growing up, I admired some of the leaders of that organisation. What's the relationship between your organisation and the state bodies?
We are
a separate organisation. We are a national body called Civil Liberties Australia. We started out as an ACT body, but we realised that most of our work was in fact federal. so we concentrate almost exclusively on federal stuff. We cooperate with and talk to the others, but Queensland acts on Queensland things mostly, New South Wales and Liberty Victoria for their own states, etc. But we are the only body in the Northern Territory, Western Australia and Tasmania, and to some extent also the SA, which is having its own problems. But the key ones are the Queensland Council for Civil Liberties, New South Wales Council for Civil Liberties, Liberty Victoria and us. We are the four who are most active.
Okay, all right, thank you. Have you read the Queensland Council for Civil Liberties submission? Okay. The issues they raise are in some cases diametrically opposed to the position you just put in the opening statement that you gave. I just want to tease some of those issues out because obviously you've got every right to have a different view and there's different views around this committee table, but I just want to put a few propositions to you and just get your reaction. So, for example, quoting from their submission, they're actually strongly of the view, and maybe this is informed by the Queensland experience, right? But they are strongly of the view that the ability to hold public hearings should be circumscribed, which, and I note your opening statement that all hearings should be public, so they just have a diametrically different view of that. And I just want to put a quote to you just to get your response so we can get it on the record. We therefore support the default position that hearings are to be held in private. We note that the concept of exceptional circumstances is a much more fixed concept than the public interest test, and that it therefore is an appropriate threshold. We therefore support the law as proposed in the bill. We submit that if this arrangement were to change, that it should be changed to reflect the Queensland approach, which holds that hearings are to be private unless it would be unfair to an individual or contrary to the public interest. End quote. Can I just have your response to the position of the Queensland Council?
Yes, we realise that there is a balance, obviously, between the privacy of the individual and the public good. There is always a balance in things to do with civil liberties and human rights. We would prefer the default position to be public hearings, but we concede that there are instances, obviously, where being held in private is much preferable and more in the public interest. So while we are prepared to accept the position put by the attorney in this legislation, we can't always get what we want, so we're prepared to concede that there are evidences. And also, as the attorney says, the instances where there are public hearings, in fact, are very few, as in the New South Wales instance.
Okay, all right. I want to put a few other propositions to you contained in their submission to see if you agree that these are also concerns from your perspective. And again, I'll quote, firstly, on the face of it, the powers in the NAC bill they're referring to would permit the Commission to make an order prohibiting a person from contacting their legal representative. There should be express provision that a non-disclosure order cannot be made preventing a person from seeking legal advice and representation, end quote. Is that a view you would accord with?
No, people should be able to contact their legal representative.
Right. Okay, thank you. And it's good that you're here because they couldn't manage to get here, so I'm using this as an opportunity. Secondly, to quote, secondly, they do not contain an exception for disclosure in a therapeutic setting or to immediate family members. Such an exception would not seriously interfere with the stated purposes of the non-disclosure orders. We submit that these situations be added to the list of exceptions. So, end quote. So, would you agree that people who are the subject of inquiry...
I'm sorry, I have no knowledge of that act. I haven't looked at that part of the act in detail.
All right. The last area I wanted to put to you, and there's issues raised in their submission around the abrogation of privileges. So the abrogation, I'll move to the Queensland Law Society on this matter after I get your response on this, but they raise concerns with respect to the proposed removal of protection of legal professional privilege in certain cases and also the privilege against self-incrimination. Are those concerns which you have in relation to the draft bill?
We would have similar concerns probably to theirs in relation to those issues.
Okay, thank you very much. I do appreciate that. I'll now move to the Queensland Law Society, and thank you very much for your submission. So I just want to move quickly through your key recommendations. So the first is in relation to subclause 8.1e, and this is, I'll refer to it as the general catch-all provision with respect to the meaning of corruption. And the concern that the Queensland Law Society has appears to replicate the concern that the Law Council of Australia has, which is that that definition appears to be somewhat vague and elusive in terms of meaning. And if we are going to have a definition of corruption, it's important that the elements of that definition are clearly defined. Is that the basis of your concern with respect to that general catch-all clause in clause 8.1e?
That's correct, yes. We're concerned that a broad, undefined subclause could give rise to miscarriages of justice.
Okay, understood. Then I would like you to firstly tell us what your position is with respect to the holding of public hearings, and if you could provide some flavour to the committee in relation to the issues which have arisen in a Queensland context. And I note that you've referred to the matter of the Logan City Council. So I think it would be of benefit to the committee, to the extent that you can, to provide evidence with respect to the Queensland Law Society's reflections on what has happened in a Queensland context.
Being mindful that there are still prosecutions on foot, still matters in court, and not wanting to prejudice any of those matters.
And Senator Shoebridge is right. I'm not across the status of whatever proceedings may still be occurring, but certainly the intent of my question is not to request you to cross any line or even come close to crossing any line which would in any way be prejudicial or even be seen to be prejudicial, even in a minor way. So to the extent you feel it appropriate to do so, given your qualifications as well.
Absolutely. Thank you for the question. I might start off by talking about our position in relation to public versus private hearings. Our stated position in our submission is the default position should be private hearings. In our view, the NAC is an investigative body with really broad coercive powers, also employing a very broad definition of corruption and the ability to abrogate certain long-standing privileges. So in our view, in order to preserve prosecutions, in order to maintain that prosecutorial authority with those bodies as opposed to investigative bodies, and to not unfairly damage reputations of people coming before the NAC, it's really imperative that the default position be that private hearings are held, and obviously with the test of exceptional circumstances being employed, as well as the commissioners. We consider that the commissioner must have reference to those circumstances listed in clause 73(3).
Okay, so just
in terms of
So I just want to tease out some of the evidence you've just given there. So just to sign off on the Commissioner having regard to the list of factors, it's the submission of the Queensland Law Society that it shouldn't be may, it shouldn't be discretionary as to whether or not the Commissioner has regard to any of those factors. It should be the Commissioner must have regard to all of those factors. Right. And there's a general catch-all as well with respect to any other factors. Is that correct?
Yes, that's right.
Okay. And then if you could give us an overview, if you like, or a summary as to what Queensland experiences or the Queensland context in terms of the CCC has led to the Queensland Law Society perhaps coming to that position as the peak representative body of the Queensland legal profession.
Absolutely.
Okay, certainly. Look,
bearing in mind Senator Shoebridge's injunction.
Indeed, and we can happily do so. So one of the reasons that we're here today, senators and members, is because we have some interesting experience here in Queensland, and we have some salient lessons that might be something the committee wishes to take into account in the deliberations about the particular bill. Some of that comes from our experience of our CCC here in Queensland, which the Queensland Law Society has always been a keen supporter of, and has always been a vocal commentator of as well. What we have, and one of the reasons that I think we've settled on the position about private hearings, is that we are very keen to ensure that evidence that's provided to a corruption body doesn't end up causing miscarriages of justice or poisoning the well with respect to juries and prosecutions. We see prosecutions, charges, and the justice system working through charge and prosecution being the point of sunlight that the Council for Civil Liberties talked about, and that being a very important thing that is transparent and open to the public for the purposes of public confidence. What we know from our experience here in Queensland, though, is that many, many more people will give evidence to the CCC on various matters and be invited to come and give evidence than will necessarily ultimately have matters that come to formal charges or even find substantiated issues. And so that's one of the good reasons that it's important to make sure that those people are protected and also to reputations, livelihoods are protected, and that the appropriate consideration is given to the charging point, which is very important. And that probably brings us to the Logan City Council issue that member Senator, you mentioned before. And the issue that we could talk about with respect to Logan City Council is probably the material that we've given in our submissions to the Honourable Tony Fitzgerald in his Commission of Inquiry with respect to certain aspects of the CCC in Queensland, and also the information that we gave to the Parliamentary CCC Committee with their parliamentary investigation in respect to the Logan City Council issue. And what those particular, firstly the PCC process and what the Commission of Inquiry process that's recently wound up has showed us is that it's very, very important to ensure that there is a very thorough distinction in a corruption body between the investigatory functions and an independent decision with respect to prosecutions and charging. And that seems to have been one of the issues that arose in the Logan City Council matter, where seconded police officers that were seconded and were in the command and control structure of the CCC were asked to make independent decisions with respect to charging certain local government officers and members and mayors in Queensland with certain charges. Those charges happened to be disqualifying offences for the purposes of our Local Government Act, and so upon charge there were certain consequences that flowed. What the submission of the Queensland Law Society to both of those processes was that there must be and there needs to be appropriate separation with the investigatory function and the discretion to decide charges. And I think that's one of the aspects that this bill probably does do reasonably well, but it's worth considering and keeping in mind with respect to the deliberations of the committee and the view of the report, so that there isn't a situation where there could be institutional groupthink or there could be some type of feeling amongst police officers seconded to an institution, as there was in Queensland, that they needed to press charges in certain cases because that's what the organisational expectation may have been or otherwise. For the purposes of transparency and for the purposes of good government, we really need a proper separation between investigations, the reporting and findings of an investigation, and a clear prosecutorial discretion, which is at arm's length about the bringing of charges. And that ultimately, through Logan City Council, was the key issue. In which case, it would be better to see that sort of separation. I guess one of the other issues that we saw through Logan City Council as well was information that had been gathered via compulsive powers that was then subsequently given to the court in a civil industrial relations matter. And that's also an interesting issue that the committee might want to consider with respect to information which is compelled through those compulsive powers and how that can be then used subsequently, which is, of course, beyond the issue of the direct immunity or the derivative immunity issues, but also to the sharing. And we note that in the bill, I think it's clause 107 says that there can be information sharing with respect to courts, but it's meant to be in relation. Sorry, 103, clause 103. The disclosure can be made to courts of information which is collected, but it's in relation to charges and it's in relation to the prosecution of charges. So the issue there, I think, is a consideration of how can this information which is gathered by these extraordinary powers be used? Is it to be just used for the prosecution of offences, which seems perfectly appropriate and the natural point that you want a corruption commission to work? And then should it be able to find its way into other types of litigation like it did in Queensland in the Logan City Council matters? And that's probably not an appropriate use for information which is being compelled, especially if it relates to legal professional privilege and other types of material that the bill would take a rather rough approach to.
Okay, so I just want to tease out one point from your testimony there, and then I'll move on to my final points, which are in relation to privilege against self-incrimination, the legal professional privilege. So that second point you're making in terms of collateral use, if I can put it that way, of evidence which is gathered by an anti-corruption commission, so instead of it being used to progress charges corruption related, it's used for a collateral purpose. Are there sufficient safeguards in the NAC bill, the proposed legislation, to refer to one of the sections that's contained in the proposed bill that we're considering, this committee's proceeding? Is that sufficient to give the requisite comfort to address that point from your perspective? And if not, you can take this question on notice to give it further consideration. But from my perspective, you've raised a concern. I'm just interested to know if you consider the provisions in the draft bill are sufficient to address that concern.
Look, we may need to take that on notice if we can, Senator. The review that we've done with respect to those provisions would look like they're all anchored with respect to charges, but it is a reasonably sizable bill.
Okay. Well, look,
this has been a reasonably rushed and quick process, it's fair to say.
No, it is, but there's a lot of history in relation to this matter. So,
indeed.
But if you could take that on notice, it would be useful in terms of both of the points you raised. In terms of the separation of those decisions in relation to whether or not to put prosecution as opposed to investigation, and secondly, the collateral use, if I can put it that way, of evidence obtained by coercive processes and whether or not there are sufficient safeguards in the bill. If you could take that on notice to the extent you can and provide us, it doesn't have to be, we're not looking for many pages of legal analysis, but just if a short summary of whether or not on the face of it appears to be addressed, that would be helpful. I then just want to move on to my last topic, which is the abrogation of legal professional privilege and the abrogation of the privilege against self-incrimination. The Law Council of Australia has made a number of recommendations in relation to both of those privileges and has raised their concerns with respect to the abrogation of those privileges. Could you provide us the thoughts of the Queensland Law Society in relation to both of those privileges and whether or not, from your perspective, the draft bill achieves the right balance?
We, in general, support the position of the Law Council of Australia. We question whether abrogating legal professional privilege is necessary in the circumstances, it being a fundamental right. And we note in that regard that for Commonwealth statutory bodies with coercive powers, it is relatively unusual to abrogate legal professional privilege. The equivalent doesn't occur, for instance, with the coercive powers of the ATO or ASIC, for instance. In relation to that as well, we note that in practice, generally only a small amount of documents are covered by the privilege, and we acknowledge, particularly in the context of government environment, the importance of restricting claims of legal professional privilege. But we also note the fact that the legal professional privilege does not apply in relation to conduct that's found to be illegal. And so we do question whether it's necessary in the circumstances. Regarding, in any event, any complete erasure of legal professional privilege we don't support, and the Law Council submission sets out safeguards and exceptions also in respect of self-incrimination privilege. And in that regard, we note that the proposed provisions do not provide for protection against the derivative use of compelled information. We consider that questions of legal professional privilege and whether or not they apply should be properly dealt with by a court, a federal court, if and when they properly arise.
Okay, so just to tease that point out, and this will lead to the end of my questions. So if what you're saying practically, what should happen is if legal professional privilege is claimed over a document in the context of an investigation, in the context of the exercise of the coercive powers, then the document should presumably be sealed and sent to a federal court judge to consider whether or not legal professional privilege applies to that document. If it doesn't, then the Commission's able to use it. If it does, it's not able to use it. Is that correct?
That's correct, and that, in our view, is the best practice process, and a process adopted at the state level. I note that the Law Council of Australia, I think, refers to the Commissioner being able to, or I'm sorry, not the Law Council of Australia submission, the Crime and Misconduct Act in Queensland enables the Commissioner, the presiding officer, to decide the question of privilege, and there's then a right of appeal that exists to the Supreme Court in relation to that issue.
Okay. Last question in relation to privilege, and that is Clause 115 of the draft bill requires a legal practitioner who claims privilege on behalf of a person to provide the name and address of their client or the person. What's the specific concern in a legal professional privilege, noting that the privilege is that of the client, not the lawyer? We need to remember that. What's the specific concern from a legal practitioner perspective, or as defenders of the privilege, in terms of a legal practitioner being required under coercive powers to provide the name and address of a client?
Well, the legal practitioner obviously has a duty, a professional duty, to continue to maintain the privilege in circumstances where they may not be able to have contact with their client, they may not have instructions, and so their core obligation is to maintain it. In relation to the remainder of your submission, if we could take that on notice.
Okay, I'd be keen for you to tease that out in terms of disclosure of the name and address, because some people might consider that issue and just ask the question, well, why shouldn't a lawyer, at least if they don't provide the advice, at least be required to provide the name and address of the client? So I think it would be helpful to tease that out if you've got any further thoughts on that.
It relates to the integrity of confidential information, and it relates to the broader policy issue of potential clients being discouraging from obtaining proper legal advice in circumstances where their identity may not be able to be preserved.
So the concern is, if that disclosure power existed, coercive power existed, someone may not even, they might be fearful about going to get legal professional advice. Is that correct?
Yes, and it undermines that fundamental relationship between the lawyer and client, which is at the heart of these issues of legal professional privilege and self-incrimination privilege.
Okay, understood. Thank you. Thank you, Chair.
Thanks. Senator Sterle.
What I do, Chair, my questions will go to both witnesses. Do you want me just to stick with Queensland first or mix the questions up?
Whichever way you prefer.
Okay, look, I'll put the question to both at this stage, if I may. And firstly, I'll go to the Queensland because the tape's turned on. Do you broadly support the creation of a National Anti-Corruption Commission?
Yes.
Great. And I'll put that question to Civil Liberties Australia as well.
Yes.
Yes. Yep. Thank you. Now, under the Human Rights Act of 2011, a statement of compatibility with human rights must be prepared for each bill presented to the Parliament. This has been completed for the NAC bill and is included at the start of the explanatory memorandum. The statement of compatibility says, and I quote, "The NAC bill is compatible with human rights and freedoms or declared in the international instruments listed in Section 3 of the Human Rights Act of 2011. To Civil Liberties Australia, do you agree with this statement?
Yeah.
All of those acts have in them the capacity for exemptions where needed. And so far as my reading of that human rights compatibility, it contains the usual clauses that allow that to happen.
Good, thank you. And to Queensland?
I think we would submit that broadly the bill is compatible with human rights, but our submission has raised, I guess, the two key fundamental issues that we would see are contrary to fundamental human rights. So the issue of having a hearing in public and then the abrogation of the two privileges.
I'm sorry, I missed the last bit.
So the two human rights issues that we would see with the bill are the issue of having a public hearing versus a private hearing and the abrogation of the two privileges, so legal professional privilege and the privilege against self-incrimination.
And Civil Liberties Australia, did you want to quote in on that as well? Make any comment?
Well, just to point out that the NAC is not a court, so the things that might appear applicable before a court may not be applicable to the National Anti-Crime Commission.
Okay, Chair, that's fine. Thank you very much.
Thank you.
Thank you.
Senator Shoebridge.
Oh, thanks, Chair, and thanks everyone for your attendance this afternoon. I might just go to the Queensland Law Society first. I don't know if you heard the evidence of the Victorian IBAC Commissioner this morning. Did you have the benefit of hearing that? No? Well, he effectively said that legal challenges to his work, and often from high-profile, well-resourced targets of their investigation, had meant that the time frame for delivering reports in Queensland had sometimes tripled. It had tripled the amount of time to produce a report because of a series of legal challenges in Victoria. Do you accept we should be mindful of that in crafting a federal bill?
Could you, I'm not sure I understand what the precise issue your question is directed at. Do you mean?
Well, should we? I'll be clear. Should we?
Lawyers can frustrate attempts for efficient investigation by use of legal professional privilege?
No, lawyers can frustrate the workings of an anti-corruption commission through a series of external legal challenges and can prevent, in some cases, or seriously delay the work of a corruption commission through external legal challenges. Do you think we should be mindful of the impact of that when we're crafting a national bill?
No.
And when you say that, do you think it would be acceptable to draft a bill that we knew would be susceptible to repeated legal challenge and could end up having inquiries and hearings take 3, 4 or 5 years before they're concluded? You think that would be an acceptable outcome?
You go.
I think an acceptable outcome is one in which the person subject of the investigation is afforded due process, and as part of that, that would include something like appealing against a ruling made in relation to legal professional privilege or something like that, and those issues do take time to resolve through the court system. So we certainly understand the need for investigations to be conducted in a timely way, but that should not impede a person from asserting their fundamental legal rights.
But a trial court wouldn't, a trial court wouldn't tolerate constantly interrupting proceedings. A magistrate's court trial, and the legal system wouldn't tolerate every time a question of legal professional privilege popped up in a magistrate's court proceedings, having that bounced off to the Supreme Court, put in a list and a fortnight or 3 months or 6 months waiting to have that determined in the Supreme Court. The
Well, with
rest of the
respect,
legal
that is the
system wouldn't
process.
tolerate those interlocutory challenges.
Well, with respect, that is exactly what happens.
Well,
That is exactly what
it must be
happens,
very
and-
different in Queensland, where you're having trials stop for 6 months while you have a stay order effectively and an interlocutory challenge. Nothing must be completed in your magistrates' courts.
Not at all. Questions of legal professional privilege don't arise all that often. The legal principles are well established. Justice delayed is justice denied, and
Correct. And that's the point. Surely that's
Thank
the
you.
point. Justice delayed is justice denied. And if you're going to, and the evidence we got from the Victorian IBAC was very clear, that repeated external legal challenges frustrates the very purpose of these anti-corruption commissions, whose job is to step up and investigate corruption that is otherwise not well discovered or not well dealt with in the traditional criminal justice system. That's its job. Do you agree?
Well, the assumption at the heart of your question is that the legal challenges that are perhaps reviewing a decision or deciding a claim of legal professional privilege are inappropriate in and of themselves, and I don't accept that assumption. I would also note that the courts have well-established processes for dealing with vexatious and improper claims, costs orders, and similar. So these are not new issues, and these are issues that the legal system has developed robust principles that balance the need for efficiency and not having incentives to go down the path of vexatious litigation, whilst balancing the rights of people who are under investigation and ensuring that their basic human, civil and political rights are not abrogated.
If the public hearing is being, if a hearing is being conducted by a legally qualified commissioner, what objection do you have with a legally qualified commissioner making a determination of legal professional privilege? Why do you say that's inadequate?
None, so long as there's a right of review to a judicial body. But we think that the best practice is to have the decision to be made by in this case, I guess it would be a federal court judge. We think that that's best practice. But thank you.
All right. Could I ask you about your submission about 8.1e? You propose it be deleted. Isn't 8.1e effectively just saying corruption as ordinarily understood? It doesn't limit the definition of corruption by 8.1a, b, c or d. That's effectively what it does.
Well, this is where sometimes looking at individual issues in isolation can create a degree of artificial
I'm looking at it in the
discourse.
context of 8.1a, b, c and d, and that's what I'm putting to you.
Of course, and so the concern that we have about the subsection and the possibility that it's vague and speculative is read in context of other parts of the Act that we have indicated we have concerns about. If those other aspects of the Act, for instance, having a clear practice of private proceedings, for instance, and a clear separation between the investigative versus the prosecution powers, then perhaps that aspect of the definition is not so offensive. So there's a context here that submission has to be seen in. But as a general rule of any sort of legal drafting, laws that punish behaviour and make things illegal and make people suspect to investigation need to be clear so that they can be followed.
It's unclear to me how those other elements in the Act that you cited would impact upon the ordinary meaning of 8.1e, given it's clearly in the context of 8.1a, b, c and d. I'm sorry, I don't follow your submission that it somehow you'd read 81E in the context of unrelated provisions in the bill. I don't see that. It just seems to say 81A, B, C and D are not limiting the definition of corruption, which most courts would read as having its ordinary meaning, 81E. Do you not agree with that?
No.
Okay.
I think the issue that might come with 81E is that it's a very difficult situation to be able to give advice to a client about whether the conduct or a factual scenario in front of you fits into that definition of corruption of any other kind. And the difficulty there is that you will only know if the type of factual scenario that you are dealing with in front of you falls into that definition after a court's already made a decision in a prosecution with respect to that. So we have fundamental legislative principles in Queensland in our Legislative Standards Act, which ask for legislation to be clear and specific and to be able to be easily understood as to what that requires. And our view would be that simply adding the any other kind at the end doesn't actually, it means that it is very difficult to know if any particular factual scenario is falling within that category or not. Certainly, we're not proposing that corrupt conduct is conduct that is acceptable or conduct that is appropriate or conduct which is supported in any stretch of the imagination. But it is very difficult as lawyers to be able to provide decent and reasonable advice about whether that particular section is going to be engaged or not engaged in a particular circumstance until after that particular factual scenario has been tested by the courts. And that's a difficult thing to tell a client about, well, we'll have a guess and we'll see whether it fits into this particular heading or not. And I think that really probably sits at the base of our concern, is that it's difficult to know, does that really sit within the knowable, is it specific enough? Can it be perhaps made into something that's more certain? Is it something that fits in there than simply any other conduct which after the fact is thought to be corrupt?
Well, the difficulty, of course, in deleting 81E would potentially be that if there was corruption that didn't fall within, as ordinarily understood, that didn't fall within the definition in 81A, B, C or D, then the NAC couldn't look at it. And that would have a very significant potential impact on the ability of the NAC, wouldn't it? That would be the result of accepting your amendment.
Yes.
Yeah, all right. Could I ask you then about...
But it is quite broad.
The other headings there are already very broad and they deal with most of the relevant and usual understanding of corrupt conduct. So it's just, if that can be made more specific rather than removing it, then that's well and good, as long as it points to a particular type of conduct which is actually understandable, knowable, and you can measure that against a factual scenario.
Could I just quickly ask about 91C and then, Chair, is that possible or not?
Yep.
The whole purpose of having a definition of corruption issue in Section 9 is to allow the NAC to start doing the work and doing the investigation work without having to form a firm view that serious or systemic corruption has occurred. It allows them to do their investigative work and get on with the process if they've got a concern. Do you accept that that's one of the key things that having a definition of corruption issue is for? Yeah, I'll take that as a yes because I saw a nod on the left-hand side. And of course, there will be people who are planning or conceiving of corrupt conduct but haven't yet engaged in corrupt conduct. Do you accept that?
Yes. Yeah.
So if someone is planning or conceiving of corrupt conduct but haven't yet engaged in corrupt conduct, do you think the NAC should be able to investigate that?
We think the NAC should be able to investigate conduct that amounts to an attempt to commit corruption or conspiracy to commit corruption.
That's not answering my question.
But the issue we have with subclause 9(1)(c) is that it really contemplates conduct that has not yet occurred.
Well, conduct that may not have been perfected to fall within the definition of corrupt conduct. But I'm asking you if somebody is planning or conceiving, if someone is planning or conceiving of corrupt conduct but hasn't yet engaged in corrupt conduct, do you think the NAC should be able to investigate it?
that would fall within probably the definition of an attempt. Under
No,
current.
they haven't yet done it. They're planning it or conceiving of it. They haven't done it.
There may be some aspects of conspiracy or pre-concert, but part of the reason that the fact that we're having the discussion that we are highlights how imprecise and opaque the concept is that you're trying to articulate. And again, that shows the dangers of attempting to create a process that criminalises future conduct.
Well, first of all, it doesn't criminalise it.
Subjective
First of all,
state
it doesn't.
mind.
It doesn't criminalise it. But I don't think we're agreeing on whether or not NAC should be able to investigate it. I think there's a powerful public interest in being able to investigate it before it is perfected. But I don't think we're going to narrow the issues here. So I'll hand over.
Thanks. Mr Wallahan?
Thank you, Chair, and all my questions are directed at the Queensland Law Society, so thank you all for coming and for your submission.
Thank you.
My first question is about Section 8.1e. If I could perhaps just read two parts of the explanatory memorandum out and then get you to comment on them. The first is in 2.9 on page 70, and the last sentence says, Paragraph 1e is intended to cover corruption of any other kind that is not dealt with in the preceding paragraphs. And then in 2.4.7, which is on page 75, it says this limb would provide the Commissioner with the flexibility to address emerging areas of corruption that may not currently be foreseen. We asked the Attorney General's Department to give a hypothetical of corruption that wouldn't otherwise be covered in the first limbs from A to D, and they couldn't. Can you think of any hypothetical for corruption that would not come within A to D and would require saving by E?
No. And then if you do, you amend the Act.
Thank you. My next question is the Queensland Council of Civil Liberties have made a submission which Senator Scarr took, I don't know if they took you to, but they took others to. And I just want to get your opinion on one part of their submission. So on page 3, on the third paragraph, I'll just quickly read it out. There is also the practical consideration that publicising, and I'm talking about Section 73, public hearings. There is also the practical consideration that publicising an investigation may compromise the effectiveness of that investigation. Publicity means forewarning, and thus it creates opportunities for strategies to be formulated to frustrate an investigation. And they acknowledge the flip side. The flip side of this, it is argued, is that publicity might encourage new witnesses to provide information. However, in practice, this very rarely happens, and the footnote refers to a review of the Crime and Misconduct Act from 2013. And so it is not a convincing counter-argument. What is your opinion on that submission?
Yep. As we stated in our submission, thank you for the question. We are we're concerned about in holding hearings in public that the very situations that have been foreshadowed in Queensland Council of Civil Liberties submissions will occur in terms of forewarning, opportunities for strategy, tainting of potential jury pools, and the degradation of the opportunity to receive a fair trial for a person who is investigated by the NAC, and then a prosecutorial decision made to pursue charges in a criminal or civil context will occur. So that's really that really goes to the heart of the fact that we think hearings should happen in private as opposed to hearings being held in public. And those situations, in fact, where hearings are held in public and new witnesses, in fact, don't come to light, that would concord with our submissions as well.
Thank you. And then my final question is also on Section 73. If at the end of this process for this committee, and whether by recommendation or otherwise, the government decides to remove the exceptional circumstances test, and then hypothetically decides to, in subsection 3, replace may with must, would you recommend additional safeguards? And would one of those be, in those subsections in 3, or could it be, that the Commissioner must turn his or her mind to prejudicing a fair trial, or something like that?
Certainly, the prejudice of a fair trial is an important public interest consideration. Ultimately, what you want to do with a corruption commission is you want to investigate corruption and then you want to prosecute corruption publicly. That's the purpose that it exists for. So there is not a lot of point in conducting an investigation in such a way that you ultimately prejudice the availability to secure a prosecution in following. So certainly that's an important aspect that could be considered and probably should be in the list.
Chair,
And we would support retention of the exceptional circumstances test, even in addition to the considerations, the Commissioner's considerations becoming mandatory and utilising must instead of may.
Just quickly, a quick follow-up question just on that. And the comment you made, the purpose, in terms of the purpose of an anti-corruption commission. We have heard from other commissioners during the course of today, and it might have been yesterday, that one of the purposes of an anti-corruption commission is to educate the public. And we were given the example this morning from the Western Australian Commissioner in relation to one of the hearings he was involved to in relation to government procurement, that he was hoping that, or one of the considerations he may have, and again I'm paraphrasing in case the Commissioner's listening, I'm doing my best, but one of the considerations he might have in deciding whether or not to have a public or private hearing is whether or not the relevant public servants in the procurement department would be live streaming the Commission hearing and being educated about the sorts of issues that could occur. Now, that inquiry he was referring to happened after charges, I think, might have been laid in that case. But he did talk about the public education aspect of anti-corruption commission. So I just wanted to give you an opportunity in that context to give your thoughts on that.
Certainly, happy to do so. There are other parts of the bill that probably go to that educative function in a better and more effective way. So the NAC can engage in a sort of Royal Commission style, open, systemic public inquiry function, which is different to a corruption investigation. Okay. That's an appropriate vehicle for that. And also too, here in Queensland, our CCC on many occasions has completed investigations, which it has done in private, and then it has issued a report for the sole purpose of education and fortification of the public service. And it's fair to say that public service officers do tend to look at published reports of our CCC quite closely and certainly use them as an educative vehicle. So there might be other ways to achieve that than sort of bringing particular unfortunate investigatees through the sort of public mire.
Understood. Thank you.
And sorry, one more question which will be on notice, and so I'm not expecting you to answer it now. We've conducted a comparison of private hearings versus public hearings in New South Wales and Victoria, the percentages. We've asked Western Australia to do the same. Could we trouble you to do that analysis and get back to us about the percentage of hearings in Queensland that are private and public, and let us know, because that comparison is useful.
Thank you. Look, we will be happy to take that on notice for you. We'll have to review the annual report of the CCC and see if that's publicly disclosed information. And if it is, then we'll certainly pass that to you. And if it isn't, then we might not be able to obtain that information. Unfortunately, the Queensland Law Society is not quite as powerful an organisation to be in the intimate workings of the CCC of Queensland. But if we can possibly find the information, we will be
Okay,
more
can
than
you
happy to volunteer.
do your best? Can I ask Dr.
Thank you.
Haynes to
Thank you, Chair.
go?
Thank you, Chair. My question is to the Queensland Law Society also. Your submission says you support the bill in that private hearings are the default and the test for holding public hearings. You also suggest a change to clause 73(3) to replace the word may with must. I think we've established that's your view. If that change was made, can you explain why the exceptional circumstances test is also needed, and what does that test actually achieve?
We think that the test of exceptional circumstances provides an opportunity for the Commissioner to take into account unique circumstances that might not be contemplated by those other factors listed in 73(3). So we would support the retention of the test of exceptional circumstances in addition to the mandatory consideration of the factors set out in 73(3).
Would you be able to give me an example of what you would consider exceptional circumstances?
Can we take on that?
We can take that on notice.
Yeah.
Thank you.
So, certainly, sorry, member, there might be some incredibly high-profile matters or otherwise that could fall into that exceptional circumstances condition. So, but we'll be happy to set out some material on notice for you.
Could I just put to you, though, that subsection 3 does not limit the matters to which the Commissioner may have regard. Would that not satisfy you?
I think that would be a lower threshold than the requirement for an exceptional circumstance. And we would maintain that there does need to be a sufficiently high threshold for a hearing to be held in public.
So you'll get back to us with some examples of what that might look like?
Sure.
So could you tell me then, with those safeguards, with exceptional circumstances, what purpose then would you say the judicial review of public hearings might actually achieve, other than delaying investigations by the NAC and impeding the NAC's work?
Preventing miscarriages of justice.
Even though all of those
Preserving
other safeguards had been abided by?
It's a fundamental principle that there be rights of review.
And
It's a
could you,
fundamental principle of any civilised society.
for a public hearing in an investigation of the NAC?
Well, certainly for significant decisions, not every tiny little decision. That would obviously be completely counterproductive. But there has to be the availability of that right in appropriate circumstances.
Could you give me an example of what you would consider appropriate circumstances for a judicial review?
In terms of examples, we'll take that on notice as well so that we can properly inform you.
Thank you. That's all my questions. Thank you, Chair.
Ms Lawrence?
Thank you. Mine's really a follow-on question on the judicial review. So we've heard quite consistently the desire to see the Commission be independent. I think some are even using the words truly independent. The proposed change that you're suggesting to require for a judicial review, are you thinking that it's a review of the lawfulness of the decision of the Commissioner, or looking at the merits of it?
Would be a merits review.
Perhaps questions of ultra vires might come up as well, though.
So how
Questions
does
of whether they have the power to make the decision.
And so how then are we able to demonstrate the independence of the Commissioner if in fact the decision doesn't rest with the Commissioner?
There are many decisions that are made by many arms of government that have appropriate judicial review, and I don't think that anyone would suggest in administrative law that because there are avenues for judicial review that therefore government has no independent decision-making power. Certainly independence in this context is about independence and freedom from political interference. It's about not being directed for particular purposes of a government result, and it's about independence to make decisions at arm's length, which largely are not coloured by a political motive. One of the things that Queensland Law Society has submitted previously in some of the earlier consideration about the NAC is a need for the bipartisan agreed approach to the appointment of senior officers, perhaps the Commissioner or otherwise, in order to be able to remove that potential for partisanship. So I think when we're talking about independence, we're not necessarily really talking about the fact that decision makers should be able to make arbitrary decisions that are never reviewed, because ultimately
But they're not arbitrary
that
because
itself
they've got
could
the
lead to
conditions.
the corruption that you're trying to avoid. Really, what we're talking about is we're talking about an independence from political interference. We're talking about independence from interference by those who have an interest in the proceedings to particularly drive it for some ulterior purpose. So I think by independence, you're not just necessarily really talking about a freedom from review altogether, because the ultimate checks and balance of our democratic system is for the courts to be able to have a jurisdiction to review decisions of government. That's the basis of our democracy and the separation of our powers.
And so I hear what you're saying, but given that there are other processes in place too, such as the the investigator's role, I appreciate some witnesses have suggested the audit's functions, the inspector's functions need to be broadened, but the commissioner's presumably going to be coming with the qualifications, perhaps of the equivalence of a judicial officer in any event, and the descriptions that the tests that have to be met that are prescribed in what will become the Act will need to be satisfied as well. So we're already building in those elements. I'm just curious as to why we would add an additional layer to essentially do the job of what the commissioner is being paid to do, in terms of making that decision and wearing the responsibility for it.
Indeed. And look, thank you for that question. It's a very good question. And reasonably, it goes back to that need for checks and balances, again, that we just talked about, because a commissioner might be empowered to make a decision, consider relevant factors, and come to a particular outcome. But say, for example, a commissioner is considering whether to hold a public hearing in a corruption investigation with respect to their next door neighbour, and they've had a long-running dispute over a fence and a barking dog. There's hatred and unhappiness between the two parties, and the commissioner decides that they will put the matter to a public hearing because that suits their collateral purpose. In those circumstances, you would want to be able to have some check and balance on that decision-making power, because the commissioner might not have appropriately considered all of the factors and may not have appropriately...
In those circumstances, we'd have a former commissioner quicker than you could say parliamentary hearing.
But, sorry,
Thank you, that's their opinion.
Under this Act, it would have to be a fence in their building, and there would have to be a public servant, and and it would have to be systemic. It would have to be serious. I mean, seriously, that was a nonsensical thing to put to us. Frankly, it was nonsensical kind of example. Sorry to be harsh about that, but that is not an example that goes to the point that has been asked. Have you got a further question?
No, thank you. But I appreciate your perspective, and thank you for appearing today.
Good fences make good commissioners.
One follow-up from Dr.
I'm
Hayes.
just curious, given your concern around the capacity of the Commissioner and the apolitical nature of the NAC, your views then on how the inspector, as drafted, can review any complaints about the National Anti-Corruption Commission. Do you have a view on how that is drafted?
I think we'd have to take that on notice. I'm sorry, it's not an area that we've looked at in any great detail.
Thank you.
Okay. Thank you very much for your attendance to both groups. Thank you to Civil Liberties Australia and to the Queensland Law Society. I think that certainly Queensland Law Society has been asked to provide some additional information. Could you please forward it to the Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. We do appreciate you both putting in written submissions and also giving us your time today. So thank you very much.
We appreciate the opportunity. Thank you.
Thank you. Can I now call Dr. William Stoltz and welcome him to give evidence today.
Is that a Queensland saying? Well, good fences make good commissioners?
It's
a good poem by Robert Frost.
I know. I'm like, seriously sorry, but it's sort of unpleasant.
Wasn't the best.
No. It's a public.
You don't have to agree with all the witness statements.
No, I think
there's room
I think
for
you were
varying views.
You were very measured in your response.
You were measured, yeah. Sorry, I'm lost it.
We're tired.
Because I'm looking at the time.
When I get tired, I get less measured.
I get, yeah, I can. If you've been sitting here, like, for, biting your tongue for 5 or 6 hours, it can be quite dangerous.
Yeah. Mm-hmm. Yeah, I know. So we are broadcasting, and can we now thank you,
in a positive,
Dr. Stoltz. Thank you very much for coming to give evidence today. For the household record, would you please state your full name and capacity in which you appear before the committee?
Dr. William Stoltz. I'm the Policy Director at the National Security College at the Australian National University.
So although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make a brief opening statement, bearing in mind we do have your written
Yes,
signature?
Chair, thank you, if that's all right. So good afternoon, Chair and committee members. Thank you for this opportunity to speak with you about this important inquiry concerning the legislation for a federal anti-corruption body. For the avoidance of any doubt, my remarks today are my own views and should not be taken to represent a homogenous perspective on behalf of the National Security College nor the wider Australian National University. As a university community underpinned by the principles of free expression and intellectual diversity, I acknowledge that my colleagues will hold a range of professional views on the National Anti-Corruption Commission. As outlined in my written submission, I believe there is merit in the creation of a NAC as a means to protect our democratic bodies and civil service from instances of corruption that not only abuse public trust, but ultimately corrode the credibility and integrity of our institutions. As a researcher concerned with national security policy making and as a former national security practitioner myself, I do, however, have some concerns about how the NAC will interact with cabinet and high-level national security decision making. I am also admittedly disappointed that this committee has not been afforded more time to scrutinise these bills, and as I will outline, I believe there are several aspects concerning the powers of the NAC that warrant some lengthier and perhaps recurrent scrutiny from this committee. In my submission, I discussed and made recommendations concerning 3 areas in which I believe the bills need to be refined. These related to the opening up of the Commonwealth's Telecommunications Assistance and Access Regime, also known as TOLA, for use by the NAC and 7 other state commissions, the interaction of the NAC's investigative powers with the decisions of Cabinet and especially those Cabinet ministers making national security decisions, and the need to protect the NAC's referral process from being weaponised for vexatious or malicious purposes, including by foreign actors. Concerning the addition of 8 new interception agencies under the TOLA regime, including the NAC, I don't believe this committee has been given adequate time to assess the full implications of this change. I also don't believe the bills appropriately reflect the unique authorisation process that will be required to give the NAC access to TOLA. This could be resolved procedurally or in the bills themselves. And finally, I don't believe that the case has been made as to why these 8 commissions should not simply access TOLA powers via established assistance arrangements with existing interception agencies like the AFP. I believe the committee will be hearing from Professor James Renwick later in this inquiry, who, as the independent National Security Legislation Monitor, evaluated the TOLA regime. You may wish to seek his views on this question. In relation to the interaction of the NAC's investigations with Cabinet and national security decisions, I believe the bills require further refinement. Interception of communications relating to active Cabinet deliberations, that is to say, decisions that have yet to be finalised, could cause a particularly serious chilling effect whereby Cabinet ministers refrain from asking for advice or creating proper records for fear that doing so could be misconstrued by the NAC. I don't think existing considerations for security matters or intelligence information are sufficient, and I also believe that relying on existing criminal thresholds to authorise invasive surveillance and interception of cabinet ministers does not pay due regard for the impact such investigative techniques could have on our conventions of cabinet government. I believe the NAC Commissioner needs to receive external advice on the potential impact on Cabinet before applying for warrants that would allow such methods to be used. My third area of concern relates primarily to the issue of foreign interference and vexatious use of the NAC's referral process. Sadly, we need to be alive to the reality that the NAC will be finding its feet and conducting its investigations in the most aggressive era of foreign interference and espionage that we have witnessed since the worst days of the Cold War. Unlike existing state commissions, the NAC potentially provides an avenue for malicious actors to mobilise false allegations against our nation's most senior leaders and elected officials, to generally attempt to discredit the integrity of our national institutions and to stoke apathy and disillusionment among some Australians toward our government. We have seen in recent elections in the United States in particular, efforts by foreign entities to use false allegations, disinformation and downright conspiracy theories to sow discord among the population. The predominant objective of these efforts has been to simply degrade the proper functioning of democracy. Of course, we need to be careful not to overstate the effectiveness of such malicious information operations, but in the NAC referral system, we are potentially creating a mechanism for a range of malicious and vexatious actors to lend credence to false accusations by simply publicly announcing that this or that official has been referred to the NAC. Just as the bills make it an offence to provide misleading or false information to a NAC investigation, I also believe it should be an offence to publicly reveal a referral to the NAC without the express permission of the Commissioner. This would also ensure that the NAC investigations are not disrupted by undue public attention, and it would reduce the exposure of NAC investigations to potential political pressure. As suggested in my submission, there may also need to be some adjustment to parliamentary standing orders to discourage use of parliamentary privilege as a means to politically weaponise referrals to the NAC. Thank you again for the time of the committee to consider my submission, and to the Secretariat team for their assistance. I look forward to taking your questions and observations.
Thank you. Senator Chandler.
Thank you very much, Chair, and thank you, Dr. Stoltz, for coming along today and for your testimony. In your submission and in your opening statement, you suggest that we need to, or that the NACC should operate jointly with existing law enforcement and intelligence agencies to access surveillance data as a way of minimising the risk of malicious actors interfering with their investigations. Could you expand on that point, please?
So what I was getting at there was with the telecommunications, the TOLA regime, the assistance and access regime, was the ability, and I think it was outlined by the AFP yesterday, the ability that already exists for integrity organisations to work hand in glove with law enforcement agencies or interception agencies to be able to access the TOLA regime, which I think is I don't believe the case has necessarily been made why these 8 other institutions need to have the ability to do so on their own. And I think that this committee needs to be very alert to the resourcing challenges, the staffing challenges that will be present for when the NAC is stood up to be able to exercise those powers correctly. The NAC will need very specialist staff, very particular systems in place to be able to use the TOLA regime properly, and that's one of the things that I think that this committee would hopefully get assurance of kind of in perpetuity, just as the TOLA regime is regularly reviewed by the PJCIS and the PJCLE, that this committee would also be assured that the NAC is appropriately being resourced and equipped to exercise those powers, because they potentially will be accessing fairly sensitive information, because it's worth remembering that under the TOLA regime, the relevant providers does not just cover private sector entities that we might immediately think of like Telstra or Optus. It provides any entity that's providing a communication service, and that could actually be a federal government agency. I mean, one has to kind of exercise a degree of imagination, but it's entirely conceivable, I think, that you could have the New South Wales Anti-Corruption Commission undertaking an investigation that interacts with a federal government official or even a federal politician, and they might say, Well, we want to see what they've been communicating in their work environment. So we're going to issue a technical capability notice through the TOLA regime on the Department of Prime Minister and Cabinet in order to gain access to the Cabinet system that securely shares Cabinet information. That raises a lot of, that particular scenario, but ones like it raise a lot of concerns, I suppose, about the interaction between the different jurisdictions and what's appropriate under federation, but then also who's being made aware that the New South Wales Commission or another state entity has begun to access federal government information. Hence why I tend to lean on saying, well, the Commission should simply access this regime with the assistance of other agencies just to avoid those issues altogether.
And I think in some of the questions that I asked to AGD yesterday, I'm not sure if you were listening along, but we sort of tried to investigate exactly how all of those schemes are going to overlap or interlock, so to speak. I mean, I'm not convinced that we quite got to the bottom of it, but that's probably a conversation for another day. You mentioned the PJCIS. Do you see there being an interaction between the work that committee does, the work that this oversight committee might end up doing to ensure that we do have sufficient coverage of these sorts of foreign interference risks in terms of what the NAC can potentially look at?
Oh yes, I think that has to be an established pattern. That has to be a regular part of what this committee is doing. I mean, I'm not entirely sure, for example, if this committee has received in-camera briefings from ASIO, for example. I would like to think that you would get that sort of access to understand the foreign interference risk associated with the issues I've raised. And I would like to think that that would become kind of a regular part of your ability to assess whether the NAC, again, is being appropriately resourced and is able to handle the sensitive Commonwealth information that it's going to gain access to. But that also, I suppose, extends to the other commissions that might be accessing sensitive information through things like the TOLA regime.
One of the other issues that I briefly delved into with AGD yesterday was around the decision to have AAT members able to sign off on warrants and therefore, you know, potentially have visibility or access of sensitive information. I know that you briefly turned to this within your submission. Do you think it's appropriate that the AAT should be able to approve a surveillance warrant?
Well, I suppose the question for me is to look at the thresholds that an AAT member or a judge are going to look at in terms of issuing warrants, but particularly warrants that might be interacting with senior national security officials or cabinet ministers and their staff. And the reality is that the thresholds as laid out are really couched in definitions of serious crime. And so an AAT member or a judge will only really need to consider whether the issuing of that warrant is proportionate to the crime. They're not being asked to consider factors relating to the sensitivity of national security information or the proper functioning of cabinet. So as a general premise, I'm uncomfortable with the fact that there isn't a kind of tailored threshold for cabinet and national security information or investigations interacting with it. In terms of whether an AAT member generally should be able to issue those warrants, I know it's kind of been an ongoing theme. I kind of, to go back to my original point, it is more about whether the approving officer is being made to consider the full complexity and the full implications of conducting surveillance and interception, particularly on that cohort of people in the Commonwealth, cabinet ministers and national security officials.
Yeah, indeed. I think that's a very pertinent point. And just finally, I note that as the legislation is currently drafted, the Governor-General is exempt from investigation. Do you have any views as to whether or not that is a good idea?
Well, I suppose it's a good idea insofar as we do need some officials who sit outside of this system who can be potentially appealed to arbitrate. Otherwise, it potentially becomes a kind of a completely closed closed network of Commonwealth officials where there kind of isn't anyone who can step in and resolve potential issues that arise. And in the context of cabinet, that's kind of my particular concern, is that, and I mean, again, we're kind of stretching our imagination, but the reality is that the law has to deal with kind of any conceivable thing that could arise. But if you're potentially thinking of serious corruption that might involve multiple cabinet ministers or otherwise be affecting the proper operation of cabinet, there does need to be someone that the commissioner can reach out to and seek advice from, and that probably is the Governor-General, given the Governor-General will be the one appointing them after this committee's made its recommendation. I mean, again, is it conceivable that perhaps the Governor-General themselves may engage in corruption? I suppose that is a great challenge, but that goes perhaps more to a wider philosophical discussion about the amount of executive authority that we invest in, I suppose, the Governor-General as the monarch's representative, which is perhaps a little bit too philosophical for the terms of reference of this inquiry.
Indeed, we could be here a very long time ruminating on that particular question, I think. And just finally, I mean, broadly speaking, Dr. Stoltz, with the amount of information the NAC is potentially going to have access to, and the powers that it is potentially going to have and the information it will get from that, how high do you think the risk is of potential foreign interference? Is it a very attractive prospect for some sort of foreign entity that is meaning harm to Australia or wanted to undermine our political system to attempt to tap into?
So I suppose there's two elements to that question. There's what is the risk that's created by having another agency that's going to create a duplicative repository of sensitive information that would be of value to another government? There's that aspect of it, and so that's for example when the NAC might collect copies of security or intelligence information and have to store it in a separate facility, et cetera, but also the records that they will create on government officials itself could be an entirely new and quite appealing kind of repository of national security information. So that first aspect, I think, goes to this committee being reassured that the NAC is being given the resources it needs. I know that in the presentation yesterday you got from Attorney General's Department, they mentioned all the different internal kind of codes and procedural requirements that agencies have to meet to be able to safely secure information. So you as a committee need to be assured that the NAC is meeting those standards, and if they're not, what's going to happen? Are they going to have their access curtailed, and do they do? All that sort of thing. So that's the first element about the NAC actually, being another source of information that could be targeted by agents of a foreign government. But then there's the other aspect that I'm concerned with, which is the referral process itself. I know that I think the committee has probably been watching quite closely at what the historical record is of other commissions, but I think, other state commissions that is, but I think it does bear pointing out that this is a very separate and distinctly different entity in the sense that it is operating at that national level, not to be at the risk of offending local and state government officials. The reality is that the Commonwealth does have powers and does do things that are of much greater interest to foreign entities than what might be going on at local councils and that sort of thing. And so the ability to be able to use the referral system vexatiously in order to try and to discredit public officials, but also just to disseminate disinformation and discord with our democracy. If it was the case that the NAC was, in its first years of operation, just flooded with completely false referrals that just generated a kind of apathy and disillusionment in the Australian population of just saying, oh, well, everyone who works in Canberra, everyone who works for the Commonwealth Government is obviously corrupt. I mean, those referrals may be complete junk and the NAC might be able to work through them, but there will still be a damaging effect done to public trust in our democracy, which can go to serve the objective of foreign governments, namely that would fit with the doctrine of operations of the People's Republic of China and some of their entities that undertake these sorts of activities. I can go into that, but I will pause there because I've been rambling for a while there.
No, that's all right. And I think AGD said yesterday that in receiving complaints and investigating complaints, there is a trigger point basically built into the legislation by which the NAP can say, well, we're concerned that there are security issues in relation to this complaint specifically. We will go to ASIO or whatever other entity might be relevant to involve them in determining, the veracity of the complaint. But I'm not entirely sure that those thresholds are necessarily clear-cut within the legislation as it currently stands.
Yeah, and that is also why I suggest that the act of publicly disclosing a referral without the sign-off of the Commissioner needs to be looked at very closely. The bills have laid out that you cannot provide false or misleading information to an investigation in order to protect against vexatious use of the system. But there's kind of a step before that, which is just the referral process of just naming everyone in Parliament or naming every Commonwealth official in public referrals that you then just kind of publicise online or publicise to the media. There's not a lot that the NAC or the AFP or ASIO can do after those things have been put out there into the public domain. Hence why I believe it should be made an offence to make that public disclosure without the approval of the Commissioner, to try and guard against that vexatious or malicious use of the referral system, and to also protect the investigations from being disrupted without the Commissioner signing off on the public disclosure of something that they may not have even begun to investigate yet.
Can I ask just a follow-up question just in relation to that point, just quickly with your indulgence, Chair? With your kind indulgence. And that is that at the moment under the current system, politicians, and it has been known to happen, can refer a matter to the Australian, say, Federal Police and say, I'm referring this matter to the Australian Federal Police because it's so important. But we don't have that check and balance of the system at the moment. So, in effect, practically the mischief that you're identifying, I mean, it happens today in relation to other law enforcement agencies, doesn't it? I
think that's right, and it happens, and it could conceivably happen at the state level. But again, I think this is where we need to be looking very clearly at the national context of this organisation, and that it's just another mechanism by which to sow discord and dirt about Commonwealth officials that might be entirely vexatious.
Can I follow up on that? But wouldn't it also prevent or discourage, genuine people who are making a public interest disclosure from going public about that disclosure? So, I mean, how do you make the balance?
I think that's the great challenge with this body, and probably the reason why it's taken 30 or 40 years, I suppose, to come around to creating a Commonwealth body.
That's the reason.
But there's...
You can run with it if you like. Go run with it.
Yeah.
If you like.
But that's, like, they're probably... I'm not going to say that there is a perfect balance, because I think that there's a lot of issues here that have to be weighed up. Like, not just that issue of, well, do you deter people from making a referral if they're not able to publicise it, but do you also just undermine the very credibility of the referral process if it's also just used as people on Twitter just kind of immediately spamming the NAC with a whole lot of junk referrals? And I suppose, again, going back to that point where this committee is going to have to play a kind of constant role in watching how this organisation evolves and providing that point for tweaks and adjustment, is why I hope that this is a long-standing institution, not just of this parliament, but subsequent parliaments.
I mean, I think those we've seen this morning mentioned to us it's a process that evolves over a period of time, and so that's it. And I think the things that you raise also, you've got to balance that against the freedom of political communication and also parliamentary privilege, which you've raised. And those things are long-standing privileges and rights, I suppose, and so it's the balance of those. But Parliament probably weighs those things up every day of the week. Dr. Haynes, did you have a clarification?
I just wanted to follow on from a couple of questions from Senator Chandler. So thank you very much for your submission, Dr. Stoltz, and your witness today. You've asked us to exercise our imagination around the interception of communications relating to active Cabinet deliberations, which could cause serious chilling effect, whereby Cabinet ministers refrain from asking for particular advice or creating proper records for fear of doing so that could be misconstrued by the NAC. Do you actually have any evidence that would assist us to exercise our imagination or go beyond an imagination?
Well, I suppose, I mean, I would just speak, I guess, and without going into kind of details, but experience from when I was a public servant, making submissions to Cabinet or making submissions to senior Commonwealth officials in the national security space. The process of seeking advice, testing ideas, even asking for worst case ideas is actually part of the really rigorous process that needs to happen in confidence, in private, within the public service, including within Cabinet. And I think it means that Cabinet ministers, agency heads, secretaries need to be able to ask their departments for all manner of advice and to be confident that when a spectrum of decisions is presented before them, that is not going to be taken and judged as the snapshot of their decision making. I suppose one example immediately jumps to mind is, for example, when the Secretary of Home Affairs wrote to the Secretary of the Department of Defence to discuss whether the powers of the Australian Signals Directorate should be applied domestically. That was an honest exchange of ideas between two public officials, which in this case, the correspondence was published by a journalist, arguably disrupting that process of two secretaries having an honest conversation about options that they may not necessarily have a strong preference for, but they need to scrutinise in close detail. My concern is that if there is a baked-in assumption for Cabinet ministers in particular and their officers that any interaction that they might have officially as Cabinet officials could just kind of being constantly, even just incidentally collected by the NAC, that will alter and shape their behaviour. Now, I know that obviously requires a lot of thresholds to be met. So for the NAC to start doing things like undertaking computer access warrants or covert operations or exercising surveillance device warrants on an official, there's obviously a lot of thresholds that have to get to that point. But I think this is where we need to be very alive to the realities of incidental collection, that agencies, when they're undertaking things like installing a surveillance device in someone's home or someone's office, are going to collect information about other people around them. So, for example, the subject of an investigation might be a junior official, a junior staffer in a minister's office, but the process of potentially collecting information on that target will soak up a lot of other residual information, potentially quite sensitive information, that should never end up being part of the investigation proper, but the reality is it is being collected. And that will, I think that poses a risk to the kind of that open deliberative culture that we need to have within those spaces like Cabinet and other parts of the public service.
Could I also ask you about the Governor-General and Chief Justice of the High Court, as you suggested, so regarding the proper functioning of Australia's Cabinet, what would assist them, given that they both have no experience in the deliberative function of Cabinet?
Look, I suppose what I was trying to drive at with that idea, written in great haste as I tried to meet your deadline, was to try and grapple with that idea of where's that person that the Commissioner can go to test that any proposition to start conducting investigations on a Cabinet member or related officials, who can they go to ask the question and test their thinking when it comes to the proper functioning of Cabinet? Because at the moment, when it comes to seeking the approval for the relevant warrants, say for example a surveillance devices warrant, it's not going to be the judge or the AAT member. That's not really their responsibility. There needs to be, to my mind, an individual who the Commissioner can go to say, look, I'm about to press go on what could be a really sensitive and potentially quite cataclysmic kind of investigation here that might soak in information relating to multiple Cabinet ministers and their staff, et cetera, et cetera. Can I test that I'm doing this in a proportionate way with those conventions of Cabinet? And I guess, to my mind, the GG and the potentially a High Court judge are really the only two people outside of this system that could potentially give some sort of advice about what the proper functioning of Cabinet should be, but more on that convention level. Again, I'm not a constitutional lawyer. I think, again, this might be a question for Professor Renwick about the constitutionality of that. But again, it just strikes me that the Commissioner needs to be able to seek that advice and assistance on the Cabinet's functioning element.
That's all, Chair. Senator Shoebridge?
That would be an extraordinarily difficult position to put the Governor-General in. To be giving advice as to whether or not the National Anti-Corruption Commission should undertake an investigation into the Cabinet. That would be novel and potentially conflict-ridden, putting the Governor-General in that position.
I think everything about that scenario would be extraordinary, but it is not necessarily...
Which is perhaps why we shouldn't do it.
Say again?
Which is perhaps why we shouldn't do it and don't put it in the bill.
Well, I suppose then you're leaving in the hands of judges and AAT members to authorise potential collection on Cabinet officials or national security members without any real consideration for the impacts that that investigation might have on the proper functioning of Cabinet or national security decision-making, which is my concern. Now, I'm not presenting, maybe it's not the GG, maybe it's the Cabinet Secretary, maybe it's some other official that can be found to be identified. But I think treating a surveillance devices warrant or a computer access warrant or a controlled operation on a Cabinet member or a senior national security leader or their staff, treating that as the same as any other type of person in society that might be subject to those powers ignores the potential quite systematic change that you might create by exercising those powers in relation to Cabinet and national security decision-making.
It seems to me that kind of procedure, if you've got the NAC persuaded that there's, a case to answer for systemic or serious corruption that's been undertaken at a Cabinet level, that putting those kinds of protections, if the Parliament put those kinds of additional protections in place, you would be creating politicians as a kind of protected species under the NAC. And I don't think the public thinks that politicians should be a protected species and have additional protections to what other public servants or other members of the public would have. What do you say to that?
Well,
that kind of self-serving protection of politicians?
Look, I mean, I can't speak to what all my fellow Australians regard of politicians. I hope they regard them with a degree of respect for the public service that you do. I would say, though, that when it comes to Cabinet officials, the system kind of does treat them like special protected species, in the sense that a Cabinet official, by virtue of the powers that they're exercising, are kind of a different type of person by the powers that are vested in them. And there's all manner of different procedures that apply to them, particularly, in this place. And I think we need to be realistic about factoring in that kind of nebulous dimension that is called the national interest in exercising these quite invasive powers against Cabinet officials, so that we don't create a chilling effect and don't curtail the proper functioning of Cabinet government.
Go back to the core point, that these functions are only be able to exercised when there's a corruption issue and there's a genuine and serious concern about serious or systemic corruption. And putting these kind of artificial barriers in place seem to me to be against the whole import of the bill.
I suppose I'd be more specific and say that when it comes to the exercise of the very invasive powers that I'm concerned about, it's actually more about that it has to meet the threshold of being a serious crime. So it has to meet that threshold of being a corruption issue, but then it has to go even further and meet that threshold of being a serious crime. And it's at that level where the warrant would actually be approved that that I don't think that there is enough due consideration at play. Hence why I have suggested that perhaps another thing to consider would be to create an actual different separate offence, something resembling a kind of serious corruption offence, where you can actually put in place those nuances of how you're going to exercise these sorts of invasive collection methods in relation to Commonwealth officials. That maybe the existing thresholds for Surveillance Devices Act aren't neatly transferable to the issues that the NAC investigation is going to encounter.
I think you're asked questions about whether or not you thought the Governor-General should be covered by this. And I think your answer was you kind of wanted the Governor-General to be perhaps a referral point or have some kind of scrutiny role. Is that right?
Well, I think the Commissioner... I think the Commissioner needs some sort of entity that they can appeal to help navigate this difficult problem of potentially undertaking investigations in relation to Cabinet and national security decision-making.
Assuming we're not with you on the idea of giving the Governor-General that novel role,
Yeah.
If they don't have that novel role, is there any other rationale to not include the Governor-General in the remit of the NAC?
Well, again, I'm not a constitutional lawyer, but I suppose you've got to, I guess in that particular context about, you're probably getting to questions about constraints on executive power, given that the Governor-General is meant to be, the monarch's representative. I really don't, I guess it's not something I'd given a great deal of thought to, about whether the GG was necessarily the person that needed to be included. I mean, I suppose that my Republican sympathies coming through that they're largely a ceremonial role, and my focus was predominantly on the effective operation of Cabinet.
But absent some kind of legal doctrine that you're not in a position to put forward, there doesn't seem to be a rational reason not to include the Governor-General. And, we've seen in recent history the Governor-General entering the political fray and seeking to have public money directed in a particular direction. So it's not outside the bounds of even current experience that the Governor-General may enter the political fray.
I think Senator Shoebridge just needs to be very careful in relation to the comments you've made about the Governor-General, because you need to be just mindful of fact standing orders do specifically provide that we can't make personal reflections on the Governor-General. So maybe you can rephrase or...
We can conceive of circumstances where a Governor-General, in the abstract, may wish to enter the political fray and seek to direct funds, government funds, to a charitable entity or some other entity. And if the Governor-General was to do that, there seems to be no rationale to me why the NAC couldn't investigate it. What do you think?
Oh, look, I mean, apologies, Senator. I mean, I know that question is within the scope of the terms of reference of this inquiry, but the purpose for which I've lodged this submission is very much to focus on questions about Cabinet and national security decision-making, and so it's not a prospect that I've really turned my mind to, and so I really can't speak to it much, I'm afraid.
Thanks. Okay. Thank you for your attendance here today. If you have been asked to provide any additional information, which I don't think you have, but if you have, would you please forward it to Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. But again, thank you very much for your submission and attending today.
Thank you to the committee. Thank you, Chair.
So can I think we have a representative from the Australian Psychological Association on the line. Thank you. So
hello, can you hear me?
Yes, we can hear you. Thank you. You will give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Yeah, my name is Katrina Davis McCabe and I'm representing the Australian Psychological Society. I'm the President-elect.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. Given the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and it attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Okay, thank you. Well, thank you for inviting the Australian Psychological Society to appear today. I'm Dr. Katrina Davis McCabe. I'm a counselling psychologist and President-elect of the Society. And I'm here to speak about the impact of shame and reputational damage on an individual's psychological health in the context of a public hearing. As Australia's peak body for psychology, we represent more than 27,000 members, and we're well placed to advise on this from a psychological viewpoint. Shame and reputational damage can be incredibly harmful, with victims at risk of quite serious and life-threatening mental health conditions. Individuals who experience public humiliation and shame can suffer major depression, suicidal ideation, extreme rage and anxiety, and there's research showing even psychosis. So these effects can actually continue over the long term and even in some cases for the remainder of a person's life. So regard for mental health and welfare of participants during public hearings, we believe should be informed by psychological best practice, such as treating participants in a trauma-informed manner and making trauma debriefing available. So, given the potential for psychological consequences, the APS recommends that appropriate measures be taken to protect the reputation of participants in such hearings. So I'm open to any questions that anybody has.
Mr. O'Brien?
Thanks so much for coming along today and providing us with your evidence. And look, we've heard from a lot of witnesses in relation to the nature of these commissions and their proceedings and their investigations, both, as you state, from a reputational point of view, which probably relates more to public hearings than anything else. And I just want to say on the record, I'm a supporter of an anti-corruption commission. I have been publicly for some time, and I also believe in public hearings, but I believe that we need the right balance, checks and balances, to ensure that people are not harmed. And I must say that testimony from a number of the commissioners today has given me confidence that it's in the forefront of their mind as well at a state level. But one area that, and I raised earlier that the experience of being subject to an instruction from the government or an order from the government saying that you must appear at a certain time, at a certain place, and you must answer questions, and you must give truthful answers to those questions, otherwise you're committing potentially a criminal offence that can see jail time. Is quite a stressful experience for anyone, and I think we're all in agreement with that. One element of that process and of these, particularly these very secretive private hearings where the sunlight doesn't shine in, are gag orders. And at a state level, a number of states have laws saying that basically you can't, if you speak about what's happening in the proceedings or give across any information to anyone other than your legal counsel or a health practitioner, you're committing an offence. And obviously that's a good thing that I think that a health practitioner is explicitly or expressly stated in there. An aspect of the bill that we're examining is that equivalent section speaks to being able to make certain disclosures to for legal advice, but not for health. And previous witnesses have stated that effectively a person who comes under one of those orders or notifications has to go cap in hand to the person who's made the order to seek permission to get medical help if they are in need of it, particularly mental health. just like your opinion on that, and whether you think that having it expressly stated or having a person who is in need of treatment having to go to the actual commission who has required them to be there and answer the questions, what's the best outcome from a psychological perspective?
I think that it can be very distressing for a person to not be able to talk about things or not be able to discuss how they're feeling sort of with family or friends. And actually, we might see that those people would possibly be at the highest risk. We know that those who don't have family support or those who are likely to internalise everything and not talk about it can suffer more complex mental health and suicidal ideation than those who have family support in place. So my answer to that is it's going to be quite distressing for that individual.
Thanks for that. I don't have any further questions.
Can I just ask a follow-up question from Lou, just on that point, because I think one of the points that my colleague from Queensland was drawing out is there's a process under the Act that the person who's perhaps suffering from the suicide ideation, struggling from a mental health perspective, the bill provides that you have to actually go to the Commissioner to get potentially to get their consent for you to go and see a mental health professional, as opposed to there being express carve-out that you can just go straight to a mental health professional. So we've had some discussion during the course of the week as to, well, what's the impact of that additional step of having to actually apply to the Commissioner for consent to go and see a mental health professional, as opposed to just being able to go to a mental health professional as a matter of urgency. Could you comment on that, please?
Yeah. So you see, for some people who are perhaps psychologically healthy, don't have a history of mental health issues, that might not be a barrier. But for some people, that will be a barrier. And it might be something that would stop them actually going and seeking treatment. Now, and this is also within a highly stressful situation. And we would see, I mean, sometimes even going to a GP to get a referral to a psychologist is a barrier. And that's without a whole other stressful situation going on for that person.
Thank you. Thanks, Chair.
Ms. Lawrence?
Thank you for appearing today. Is there a case where there could be made available a panel of psychologists or psychiatrists that could be appointed by the Commission for the purposes of service to a witness? Like, is that a model that you think might be acceptable, so that there is...
Possibly, but you'd have to look at a conflict of interest within that. But I think that could be managed, and certainly would be better than having nothing in place. The thing is that when someone does go to see a psychologist, there is, a high level of confidentiality. So that what happened within that psychology session isn't going to be disclosed, I don't know, to the media or, to anywhere else. So when the person reaches out, if there is no barrier in the way, then that space is going to be confidential.
Sure, thank you. But that could be a potential model that could be explored,
it
rather
could
than
be,
a separate carve-out, maybe. Okay.
And certainly the NPS would be open to further exploring that with you if that was useful.
Well, certainly, if you have any ideas around a model that you'd be happy to submit, that would be terrific.
Yeah.
So just a follow-up question on that, with your indulgence.
It might be a better model.
And that is, if someone who is the subject to an inquiry has been seeing a mental health professional for a number of years, presumably there would be benefit to them continuing to be able to have access to that particular mental health professional, as opposed to going to have to see a new mental health professional who's never engaged with them before and doesn't know, or perhaps might be a complicated history. Is that a fair comment?
Absolutely. And when we made our submission, we talked about trauma-informed treatment, trauma-informed care, and that's what we were talking about, because I think the individual needs to be supported throughout. So we're talking prior, during, and after. So prior might be, for example, making the process really clear and transparent of so they understand what's going to happen. If they have a current psychologist that they were seeing prior, it's going to actually be really important that they're able to support them through the process. Then, if we think about during the process, I think it's about checking in with the person, checking where their mental health is and are they okay. And then afterwards, most importantly, is actually offering a debrief to the person and just allowing them to explore the process about what they've experienced and how it felt. And the research shows that just having a debrief after a traumatic event is likely to lead to a better outcome longer term.
Thanks. Dr. Haynes?
Oh, thank you very much, Dr. Davis McCabe, for your submission and for your witness today. From what I can see in your submission and what you're telling us today, is it correct that you're not recommending any changes to the legislation, but you're recommending supports that the National Anti-Corruption Commission could provide?
That's right, yes, to support the individual.
So some kind of set of guidelines for mental health supports, something such as that?
Mm-hmm. Yeah, and just to make the support available, to to acknowledge the trauma-informed care, the trauma that can result from participating in this, and then providing care through and after.
Thank you. Do you believe an exoneration report where a report states that there's a finding that no corrupt conduct has occurred, an explanation would support the psychological well-being of a person who is involved in an Anti-Corruption Commission investigation?
Yeah, I think anything that can help the individual to understand is helpful to their mental health.
Yeah. You also noted that there's significant negative mental health effects on persons who are knowingly or unknowingly victims of corruption. Would you agree that a robust National Anti-Corruption Commission may have a positive impact on mental health of these people by deterring actual corrupt conduct?
In what sense?
Well, that corruption has a significant negative mental health impact on people affected by corruption. So a strong anti-corruption commission that stamps out corruption can have a positive impact on the mental health of those people who are victims of corruption.
Yeah, absolutely, and just creating a positive culture.
Yeah, thank you. Thank you very much.
Mr. Wallahan?
Thank you, Dr. Davis McCabe. There's two parts to your submission. There was the second part, which you were brought to, which is trauma briefing and potential guidelines. But the first page is about something else, isn't it? It's about the mental health consequences and shame that comes with public as opposed to private humiliation.
That's right.
That's right.
Yeah.
Now, I'd like to, I'm just going to give some numbers to you and then ask a very specific question. There's 76 senators, 151 members of the House, 7,400 AFP members, 90,000 ADF members full-time and reserve, 155,000 APS employees. In the second last paragraph, you say, for many people, their professional persona is a core to their self-identity, and any damage or threat to it is therefore amplified. Out of those groups that I mentioned, has there been any evidence from the Royal Commission into Veteran Suicide that ADF members, in particular, attach a premium to their core self-identity? And in particular, the paragraph above, you refer to the consequences when someone is estranged from their group and loss of their place in the world. Because this commission, unlike the state ones, will be focused on ADF members as well, they're included. Mm-hmm. Is there anything you'd like to say about that Royal Commission? Or that
With
group?
the ADF, sorry, had you finished?
Sorry, no, you go.
With the ADF members, I mean, what we do, we see a high rate of PTSD and trauma in that group anyway. So any further, that they might be a group that are higher risk and likely to have more severe mental health issues. To answer the first part of your question, I would need to take that on notice and get something back to you.
Do you mind doing that? I tried
Yeah.
looking at that Royal Commission, but it was quite hard. Maybe some of your members have given evidence there that's relevant, but anecdotally,
Yeah.
the issue of identity seems to be something that veterans often speak of, and that loss of identity is a key factor in mental health harm. My other question was on exoneration, but that's been covered. Thank you.
Yeah, okay. Just on the identity, I think that someone's job and position and profession is core to their identity. And when that identity is attacked, it attacks the core of that person. And it's that attack that leads to the decline in mental health, because then the person is left asking, well, who am I? What is my purpose? What is my role? And when it's within a public hearing, I think that there's a lot of shame around that, and that kind of public hearing or social media or media sort of amplifies that shame. But certainly, I will take your question about the Royal Commission, and we'll get back to you.
Thank you.
Was there one further questions?
Just one question.
Senator Shoebridge.
Yeah, thanks so much for your assistance. We heard from the South Australian ICAC Commissioner that there's an exemption in their Act from non-disclosure, which allows for, notwithstanding there being a non-disclosure order, or I think the way the South Australian Act works is there's a general non-disclosure obligation, but notwithstanding that, a person can convey information for the purposes of obtaining medical or psychological assistance from a medical practitioner or psychologist. Mm-hmm. Is that the kind of additional protection measure you would want to see in the bill? An express ability?
Yes, yeah, anything which takes that barrier away to the person seeking support.
Yep.
Because the barrier that's in place, I mean, if we look at sort of worst case, we are looking at suicidal ideation and we're looking at suicide.
All right.
Thank you. I think that's... Is that...
Is there time?
Yeah, there's time. Go for it.
Dr. Davis McCabe, just one question, and it relates to the issue of people being affected by having to either be called up by a commission. There's been commissions in Australia at state level and also at federal level now for many years. Do you have any statistics at all about the level of personal harm or psychological harm that has been done to people that have had to appear before those commissions? Are there any records kept?
I will have to check on statistics, but we do have some research available. We've got published research articles which would address some of that, and I can get those to you, and I can check on actual statistics.
Yeah, and that is specific to the corruption commissions around Australia.
Okay.
Thank you.
I think it's unlikely that we will have that data, but I will check.
Okay, thank you.
Thank you.
Okay, thank you for your attendance here today. You have been asked to provide some additional information. Would you please provide it to the Secretary within 5 days from today? You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Proceedings are now suspended until 5:15 p.m.
Thank you very much. Thank you.
Thank you. Before I welcome the witness, can I just give a general warning to those who may be watching at home or who are in the audience that the inquiry subject matter or material that might be discussed in this next session may be confronting. Sometimes words can cause sadness or trigger traumatic memories. If you need to talk to someone, support is available. The following services are available 24 hours a day. Beyond Blue, which is 1300 22 46 36, 1800 RESPECT, which is 1800 737 732, Men's Line Australia 1300 789 978, Lifeline 13 11 14, Suicide Callback Service 1300 659 467. The details of the numbers that I've just read out are available on the web page for this inquiry. I would like to welcome now the Honourable Marie Shaw-Casey from the South Australian Bar Association to give evidence. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
My name's Amari Elizabeth Shaw. I'm the President of the Australian Bar Association, and I'm speaking to a written submission that we provided.
Thank you. Ms Shaw, we're expecting Mr Frank Pangello to join us at some stage. When he does so, I will need to also brief him about what I'm about to say to you. And that is the following. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you for giving me the opportunity to appear before the Select Committee. Can I say that unfortunately, because of my corporate commitments, which is really no excuse, I haven't had the opportunity to study the bill before the Federal Parliament, so I cannot assist the committee in commenting on that bill specifically. But I am aware from South Australia, of course, we've had the change in legislation recently as a result of various challenges to its fairness and the way it was impacting on people. And so I can speak, because I am a practitioner in the criminal jurisdiction, to how the Act is operated in this state and how it has impacted on people's lives, and indeed not just that is not just their reputation. If you don't mind me focusing on the South Australian Act for that purpose by way of illustration and merely proffering my comments for the purposes of whether or not they assist this Select Committee or otherwise is entirely a matter for you. So the starting point from my own experience and those of the members here who practice in the criminal bar is that it seems throughout that where the target is corruption here, of course, by a public officer, and the focus on achieving an outcome in that respect, to what extent are we compromising the safeguards of ordinary citizens to fairness, and to what extent are we grappling with when does the ends justify the means? And so the issues that have arisen here under or the former Act was firstly that it did permit the investigation, for example, of a public officer without really that public officer being necessarily aware of what it is he was supposed to have done, or she has done, I should say. And that stress that can impact on someone is a far cry, for example, of what's been alluded to. I noticed another speaker with a Royal Commission, where at least one knows what the terms of reference are, one knows what one is facing, whereas the way in what the Act operated here, ICAC could set their own terms of reference, if you like, and the person who was the target was never really had a clear opportunity to respond or meet it because it was an ongoing investigation. And I think the example that, and the secrecy of the proceedings here, although our view is that people's reputations should not be destroyed in a public arena, but the downside of the secrecy was it was of a nature that you had to get permission to tell anyone. So, for example, in one matter that I'm aware of, and I don't know how this happens because we're not allowed to talk about it unless there's been evidence given about it at a select committee, it was obviously available to ICAC to summons any witness to a compulsory examination, and that includes, for example, the spouse of a person that ICAC may have targeted. The spouse wasn't allowed to tell her husband where she was going. Basically had to tell the husband, well, you have children, I can't tell you why. And after attending the secret hearing, wasn't allowed to report to the husband where they'd been unless there was permission. And so the nature of the hearing that I've seen in other cases is that obviously there's no right to incriminate, there's no right to exercise the right of that is not incriminating yourself. That is cut across, and then even though you might have a lawyer there, the lawyer can't stop the examination. And the downside of that is that, when I say the downside, the transgression of fundamental rights that occurs is that with that information, it's one thing to steer a investigation of corruption to at a disciplinary level and to ensure it doesn't happen in the future. It's another thing to use that compelled information to found a statement that then leads to a criminal prosecution. Because once a witness, for example, is committed to a compelled statement and they are told that if they renege on that compelled statement, they may be prosecuted. And here, what was occurring before the changes was that ICAC was able to obtain those compelled statements from witnesses, for example, in a matter that might have been a relation or someone that the person might have been mentally ill and didn't want to cooperate, whatever the reason for non-cooperation. Once the cooperation was compelled, then that witness is then faced with a statement saying, well, this is what you've said under compulsion. If you deviate from that, then you're liable to be prosecuted for a false statement. And so the use of compelled evidence, criminal proceeding, allowing ICAC to conduct the investigation after the laying of the charge has meant that, in effect, whereas the police investigate a matter from the point of view of searching for the truth, that is, the truth that might include the innocence of the person in terms of the citizens' rights to fairness, protections by general orders that don't allow conversations with witnesses that this is off the record when it's not off the record. All of those protections that have happened as a result of years of experience of miscarriages of justice, they were not applying to the way in which ICAC goes about its investigation. And so the example we had was, and we know this from a select committee here, that the police officer Superintendent Barr, who had an Australian Police Medal, had been investigated for over 2 years. His widow gave evidence, his son gave evidence to the select committee, and one learnt of the stress that this put him under and learnt through the select committee evidence that, in fact, a report had cleared him of various matters before he took his own life. And so one can say that, that's only one life, but is that one life too many? And what really was the important outcome that needed to be achieved that could actually have an investigating body outside the courts that has the result that someone takes their own life. And I think that was recognised by one of the earlier speakers, Mr McKechnie, about stress and the unfairness of the nature of the way in which a citizen can be targeted but not have any protections. That's the first point. The second point is that the other experience we've had here is that, again, this was the subject of select committee evidence, so I can speak about it, that there were 6 police officers who were charged with various criminal offences after an ICAC investigation. And what was, from their point of view, devastating right from the jump was that the Commissioner made an announcement on their arrest that as a result of an ICAC investigation, these 6 police officers were going to be arrested. The purpose of the ICAC Commissioner making that announcement when these men and a lady were facing criminal charges is probably contestable because one of the dangers that might be foreseen is that if you set up an organisation which is funded heavily, is there some pressure to get outcomes without the scrutiny that comes from a court proceeding where both sides are tested and the evidence is not necessarily potentially unreliable because it was obtained by way of compulsion. Those are perhaps key points. And I also thought that the submission earlier by might have been Mr. Redlich about the ability that the exceptional circumstances should be that it should require no cross-examination in public. The Commissioner is satisfied that the witness's reputation will not be unreasonably damaged. What was a good way of approaching the otherwise uncertainty about exceptional circumstances, because if indeed the exceptional circumstances test is left without constraint, then it might fall heavily on perhaps the most salacious allegation or upon the most prominent individual. And indeed, one way of perhaps that occurs to us is that it's the kind of damage that might occur to reputation which is non-recoverable, and there might perhaps be included in that an ability to have a judicial review or an appeal against a decision to hold a hearing in public. And so what abounds within the ICAC framework of investigation is accountability. That is independent accountability, because as has been pointed out, if you start with the terms of reference in a Royal Commission, then everybody knows the limits of what you can do. On the other hand, if you're given powers and there is no one looking over your shoulder, if you like, or a standard by which you must approach it, and I'm not being critical or making any judgment, I'm merely comparing that process with what we see in courts of law, that even when we have one judge making a decision who's fully qualified, heard everything on both sides, we have an appeal process, the full court might get it wrong, and it's not until we get to the High Court that a charge that might have been thought to be proven beyond reasonable doubt has been through 4 judicial officers, and it's only at the High Court is it established that in fact this was a miscarriage. And so what I'm really speaking to is the seeking the Select Committee to consider in the way in which this Act is implemented might be provided to ordinary mums and dads who happen to have the misfortune, if they happen to be investigated, to be a public officer or come within the jurisdiction of the Integrity Commission. And the final thing, as I've said, is that the massive change that was made here to the ICAC Act was, whereas up until that change, the ICAC were able to be an arm of the prosecution and that therefore meant that they could deploy all of their powers. There was no obligation of disclosure. They could effectively continue to conduct compulsory examinations in secret, and the person not being able to tell anyone, even after the trial began. Now, that, as far as I know, that didn't happen, but I'm not allowed to know if it did. And so that's the demarcation between the role of the National Integrity Commission in addressing corruption and the interference with the ability of an accused to receive a fair trial if he happens to have been the target of an ICAC or an NICC inquiry is one which every Australian citizen ought to be concerned about. That is that when you come to face a criminal charge, someone who happens to be within the jurisdiction of this Act should not have less rights or indeed have more stringent treatment than another citizen who is not, doesn't happen to be within the jurisdiction of this Act. So I'm not sure that that really helps the committee. It's more to say from the South Australian experience that the way in which the Act falls on individuals can't be predicted. It can't be predicted whether someone in fact has a mental illness. It can't be predicted that the way in which the investigation is conducted might ruin their lives. It can't be predicted whether or not that damage to reputation is forever a stain on their life and the life of the offenders. And so it's in that area that I simply make the submission on behalf of the South Australian Bar Association that our experience is that whatever the federal government or the select committee recommends, the most important thing is to identify the safeguards that are in place for ordinary Australians.
Thank you. Can I now welcome the Honourable Frank Pangallo, who's also going to give evidence today, but who is overseas. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Chair, Frank Pangallo, member of the Legislative Council of South Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard. Mr Pangallo, although you are an Australian citizen, when you give evidence from overseas, while you are fully protected in Australia in respect of giving that evidence, you cannot be protected by Australian law in another country, and that includes parliamentary privilege. I now invite you to make a brief opening statement, if you so desire, before we proceed to discussion.
Well, look, thank you, Chair. I think you've already received my submission, and I'm sure that the members have had a look at it. I won't go through it with you again if you've got it and it's going to be tendered as evidence to the committee. But look, I just would like to reinforce the comments that I heard the Honourable Murray for KC make during her submission, and they were the concerns that myself and other members of the South Australian Parliament had in relation to the procedural fairness and the effects of an investigation as far as harm and reputational damage it would have on individuals, particularly when they were found to have later been found innocent of any charges against them. The Parliament of South Australia made what I consider quite a courageous decision in looking at reforms to the ICAC Act following two parliamentary inquiries that I was a presiding member of. We received rather disturbing evidence from a number of individuals as well as also legal practitioners that there's been an abuse of power by the Integrity Agency and that procedural fairness was not followed through. And as a consequence of that, it led to a number of recommendations that were made to the Parliament in relation to reforming the Act. And in essence, what it does is provide procedural fairness to individuals and other protections as well. If you'd like me to go through some of the major recommendations, I can do that for the benefit of the committee, but they are in my mission, and the actions that we took in South Australia were quite courageous and probably the same reforms that many other jurisdictions in this country would like to do. And in saying that, it's not that the South Australian Parliament curtailed the effect of the ICAC, not at all. In fact, they still have the same strong coercive powers. What the Parliament decided to do was that the ICAC should concentrate on serious systemic corruption and other matters, certainly sort of more, matters that were probably not of a serious nature, would then go to the State Ombudsman to investigate and deal appropriately with that. We also put in place the Office of the Inspectorate, which I believe is also in the Federal Act, and that's an important aspect of not only the national bill, but also the one that we had in South Australia. There are other jurisdictions that have oversight of their integrity agencies. What we found on our committee was that there wasn't appropriate oversight of the integrity agency. And had it not been, and I'll point this out to the committee, had it not been for the Select Committee into Reputational Harm and Damage into ICAC investigations, we would never have known what was actually going on. That in fact, we had an integrity agency that in some cases had lacked integrity. And that was the reason that we needed to make some reforms so that there'll be more accountability of this agency, not to clip their wings or reduce their authority, because they still have a very strong, powerful base in which to investigate criminal activity amongst public servants. A crime is a crime, Chair, and no matter where it is, it will be investigated, whether it's done through the ICAC or through the South Australian Police. The legislation that we passed certainly does not diminish the fact that you can get those outcomes. Our intention was to make it a fairer process that those that are accused get appropriate representation. And I think there's another aspect of our legislation which I think is important, and I'm not sure whether it is in your bill, but there is a provision in our bill that legal costs can be covered by the South Australian government. It is conditional, of course, if there is an adverse finding or there is a conviction recorded, of course it wouldn't be applicable. But it does provide some relief for people that are accused and have to front up in front of a star chamber and then are faced with counsel assisting the ICAC that are high-powered silks, and they can't afford similar type of representation. So that's another aspect of it that we tried to make fair. I'll go back to the Inspectorate. Again, an important aspect of that. We discovered through our two parliamentary committees that the role of the reviewer that was existing under the old ICAC legislation was certainly not, it just wasn't appropriate, and they didn't have enough resources to be able to investigate complaints against the Integrity Agency itself. So we felt that there needed to be more independent oversight of that Integrity Agency. look, I'm happy to take some questions. I don't know if you would want me to go into public hearings.
I think certainly there's a number of people who want to ask you questions. Let's see how we go with that. But can I ask Mr. Zapier has some questions for...
Sorry, Madam Chair. Sorry, Madam Chair. I'm to leave. Mr. Pangallo is well aware of this evidence. So could I be? I apologise. I haven't answered questions. Would I be able to be excused, or is there any particular question? I'm not sure that I can assist beyond my own experience we've had here.
Yeah. So could you? Mr. Zapier has one question for you. Can you wait for that question now? If he puts it to you now.
Thank you.
Monsieur, thank you
Certainly.
thank you for appearing before the committee. I have only one question, and if you can answer it, it will be useful.
Yes.
The changes to the South Australian legislation took effect in October last year. There is a report in the in Daily Only today that says that in the last 12 months, effectively since those changes, there have been 50 matters that have been under investigation by the Commissioner. In the previous year, there were only 30. So, in effect, we've had more investigations under the new legislation. My question to you is, do you have any observations about how well the new Act is operating in South Australia? And in particular, are you seeing the same level of concerns as previously were there under the old legislation?
Well, under the old legislation, there were serious concerns that ICAC was crossing into the independence of the courts and the judiciary, and that people were denied fair trials because the evidence had been compelled and essentially replacing the South Australian Police Force as investigators. And that was a source of grave concern because it meant that the ICAC had no obligations of disclosure. There was never any ability to ensure your client got a fair trial. You effectively, in an ICAC bin was a whole lot of material that exculpated your client because ICAC had no obligation to anybody. The ICAC Commissioner is completely independent and is not accountable to the Director. So the effect of the new legislation from the point of view of the Bar Association...
Monsieur, sorry to interrupt. I'm aware of what the problems were with the old one.
I've completely misunderstood, have I?
Yeah. My question goes to the new Act. Are you seeing the same level of concerns or the same type of concerns?
Concerns by... Well, from the point of view of the concerns that accompanied the old Act? No.
Yes.
That is that there is a clear demarcation now that ICAC cannot cross over the line into a criminal prosecution. That is the province of South Australian Police, and that is a protection to every South Australian.
Perhaps
so that is the key change of view of the interaction between ICAC and the system.
I guess my question is this: is the new Act?
Have I missed your point? I'm sorry, Mr. Zapier.
Is the new Act working well or working better than the old Act, in your opinion?
Well, in my view, it's working much. The roles of people are clear, the limits of people are clear, and the safeguards around achieving the outcome has improved. And that's not because I have access to any data. I'm only hearing it, if you like, secondhand. So I am not the person really to respond to that question with detail. Mr. Pangallo might, but I don't have access to the inner workings of ICAC or the OPI.
Thank you.
I apologise, I can't be much assistance.
No.
Okay.
Mr. Zapier, can I just make this point? You referred to the additional number of matters recorded by the ICAC in its current annual report, that there were an additional 20 matters compared to the previous year. My understanding is that there have been a significant number of complaints against police officers, which the ICAC is investigating, and other matters it probably has done on its own motion. as far as the Act itself, it's early days, and you may have noticed that the current ICAC in South Australia is asking for a 12-month review of the Act. Well, it's early days, Mr. Sapia, because when the Act was passed a year ago, there was a transitional period of 12 months to apply, so that a number of matters that ICAC were looking at or had on their books would need to be cleared, and after that, the Act would probably follow through in full, which is happening probably as we speak now. It would have started now. So the calls for a review after 12 months are totally premature when there's no basis for any evidence to do that.
Thank you.
Thank you.
Ms. Shaw, I understand that you need to leave, so thank you very much for your evidence and for attending today. Other questions?
I'm sorry I couldn't have been.
Thank you. Senator Shoebridge.
It'd be fair, wouldn't it, to describe the South Australian ICAC as it currently operates as not really an anti-corruption commission at all, but more like a crime commission, because it's only looking at criminal offences, it has a very narrow compass, and it's much more like a traditional crime commission than an anti-corruption commission, isn't it?
Well, that was the intent of the legislation, that it looks at serious systemic corruption.
But only really where it's a criminal offence. So it's really more a crime commission than an anti-corruption commission, properly understood.
Well, it still looks into matters of corruption. Of course it does. And the offences that fall under its jurisdiction would be those that carry jail terms of 2 years or more. As for other matters, that go to the Ombudsman, that has, the ability to also rule on imposing.
The Ombudsman may have a broader anti-corruption remit, but it's really a crime commission, as you point out. Unless you're going to jail for something, the slimmed down South Australian ICAC isn't the place to investigate. It's probably a closer model to the New South Wales Crime Commission or the traditional state crime commissions. Do you agree?
Well, in a way, but I think it's more focused on what its role should be.
Yeah, and really in the South Australian model, the anti-corruption work that's done by, say, the Victorian IBAC, Queensland CCC, the New South Wales ICAC, in the South Australian model, that's really been shifted firmly back into the Ombudsman, really, hasn't it?
Yes, but again, we also have the Office for Public Integrity, which has been set up as an independent body, which is a clearinghouse for a lot of these complaints, and they would ascertain where particular matters go.
So I suppose if we're trying to set up a national anti-corruption body with that broad anti-corruption remit, what's happened now in South Australia doesn't really give us a blueprint for it, does it? Because of the far narrower and kind of in the national context unique focus of the South Australian Commission. Do you agree?
Look, I think the South Australian model is one that would certainly provide more efficiency for an anti-corruption body.
Well, it's efficient to the point that it doesn't look at corruption because you've really put that into the Ombudsman.
No, it does.
It's very efficient.
It does look at corruption.
Okay.
It does look at corruption. And if it feels that the matter is not of a serious nature under its own remit, it then gets referred to another body to look at.
And
so you're creating efficiency. Previously, Senator, I'm sorry for interrupting.
No. I thought you'd finished, so if you had any more to add, Mr. Pangello.
Well, I was just saying, previously, the committee found that they were going on these fishing expeditions for, matters that were not of a serious nature, and it was certainly costing taxpayers millions of dollars in failed investigations that eventuated.
And the overwhelming bulk of the matters your committee looked into, as I understand it, were private hearings. They were things that were happening, in without public scrutiny, without the kind of sunlight of a public hearing. As I understand it, the bulk of the concerns